All right. 14A District Court for County of Washington, State of Michigan, is open session. Kind of business for the court drawn near, the Honorable Judge J. Simpson.
You may be seated. I do believe before we begin, we need to waiver. Okay, don't stare at me like I'm talking French, but you speak French, so go ahead.
I would understand it. Your Honor, the people hearing them out today, people versus Jerome Burns, we do not believe there is a conflict between Your Honor, this court, and the Office of the Public Defenders. If such a conflict were to arise, we would move to waive that.
Thank you.
And Your Honor, we, from the Assistant Public Defender, Chinazi Kiriaki-Ridley, representing Mr. Jerome Burns in this matter, we also do not believe that there is a conflict in this matter, and if such conflict should arise, we waive that as well.
All right, very good. Did we get him out? Or let's call the case of People State of Michigan versus Jerome Burns.
Good morning, Your Honor. Marie House Assistant Prosecuting Attorney, back to people.
And good morning again, Your Honor, Assistant Public Defender, Chinazi Kiriaki-Ridley, on behalf of Mr. Jerome Burns. Mr. Burns, state your name for the record, please.
Jerome Burns. All right, are we ready to?
Your Honor, a few things. I've been communicating with defense counsel. We have witnesses here. Victim is on her way. Sergeant Matthews is driving her. I believe they hit some traffic, but we have our other witnesses present and ready. I did want to make a record. We received a great deal of evidence from defendant's phone. As the board likely remembers, we had a preliminary, an extraction. I shared that with defense counsel because it was of potentially exculpatory nature. I was also though very clear that's a preliminary finding. There was ongoing extractions from the phone and analysis that needed to be done. I was initially sent 2 zip files of what was extracted from the phone. Background to this is that there was at least one hidden folder in the defendant's iPhone that had biometrics associated with it. So essentially they could get into the phone, but they weren't able to get into the hidden folder. So we were looking at options for that. The extraction we received didn't work on any of the county computers, so I was unable to, yes. Ironically, I was unable to pull that up. I had informed defense counsel of having that, but also that I wasn't able to open it. So the next step was asking them, hey, is there another way we could do this where I could actually view this evidence and share it with counsel? I believe it was yesterday. And I will say Sergeant Matthews went above and beyond in trying to do things quickly. He was able to get 2 thumb drives, one for prosecution, one for defense, copied over to our office. I notified defense counsel. I believe they have picked it up since and are in possession of their copy. But it's a lot of information, Your Honor. And a lot of the information relates not only to the preliminary report that I shared with counsel. In essence, it gives a lot more context than what I have been able to view, give context to that first piece of evidence. It's also evidence that we would want to ask the victim about. So the potentially exculpatory information, I believe, would necessitate the victim testifying again, unfortunately, given that evidence, but also the evidence that we are just recently in possession of would speak to that very closely. And I can go into further details if court.
I just want to make sure I'm understanding. So there's evidence that may be exculpatory, which would require the victim to reappear and testify.
Correct, Your Honor, to give context to that piece of evidence, but we also now the evidence that we have received as of yesterday, it gives a greater context to that preliminary piece that we shared with defense.
Got it.
The reason for sharing that first is because of the potentially exculpatory nature. I wanted to make sure they had it and they were ready. But of course, there's a lot more to it. And what we have other witnesses, I'm ready to continue with those witnesses so that they don't have to keep reappearing. But I'm not sure I'm comfortable proceeding with the victim's testimony until both sides have had a chance to review this additional evidence off defendant's phone.
Okay.
As I stated, victim is on her way here. She does have a son. I don't know if she was able to get childcare for him or he'll be with her. So I don't believe we reached a consensus this morning, but I did speak to council about, you know, for her testimony, do we need to keep her here and take that testimony today? As I stated, and I'll say it again for the record, I'm not comfortable until both sides have looked at the evidence. I'm not comfortable directing her on it, and I'll leave up to council how she feels about cross-examining without those pieces. But as for the other witnesses, Your Honor, we would be ready.
Your Honor, we find ourselves in a pretty difficult situation because we have not been able to review all of the information from the thumb drive. I asked sister counsel, she's unaware because she hasn't gone through it either, if any of the information in the thumb drive may pertain to the witnesses that are present now and ready to have testimony taken from them. I don't see why there would be. However, there was some information just in the preliminary pieces that were sent over last week or a few weeks back that may have occurred around the time of the interaction with one or maybe all three of the witnesses present today, specifically some communication between my client and the complaining witness. We're not sure who was around at that time, but I just don't know what else is in the phone. There's a great deal. I am not experienced in sieving through this type of data. I'm literally just clicking on every folder or file and
I thought you worked for the NSA. No, I'm sorry, go ahead.
Not on the record.
In my prior life.
Yeah, okay.
So, and that's why I find it difficult to say, yes, I'm ready to proceed on the three witnesses that we have. Yes, I'm okay with an adjournment of, the information from the complaining witness. And I know my client's position 100%. He has been in custody throughout this entire period. He is very eager to resolve this matter. We received some very disturbing news from his family yesterday. His father's currently in the hospital, and he's been really struggling to assist with his mom. But I know that my conversations have always pulled out his desire to move forward and continue this case along. So we're really at a crossroads right now, Judge.
Right, and just so that we're clear, part of the reason the court agreed to adjourn the matter was because my understanding was the defendant believed that there was something that was exculpatory on the phone. And so that's why we even started down this path. Just that there, I'm not blaming anybody, it just is what it is. With reference to, I'm sorry, Ms. Eckenroley, were you done?
Sorry.
Okay, no, I just wanted to make sure. With reference there, you said you had three witnesses today.
We have three witnesses, Your Honor. Two of them are in the gallery. One is the officer who responded. The other one is a social worker who spoke to the victim at the time at the hospital after the assault. So they would be ready. We also do have Sergeant Matthews. Sergeant Matthews would be able to start today. We may want to recall him after the victim's testimony, depending, but he'd be the third witness that could start testifying today.
Got it.
And I share defense counsel's lack of knowledge of technical things. So when she asked me about the messages, I was able to get through some of them. Of course, not all of it. It is a great deal of evidence. And I would agree that there are text messages, and those we do have timestamps, and Sergeant Matthews could speak to from defendant's phone, defendant messaging victim around the time that it seemed it was becoming clear to him that there might be some police involvement and things like that. I'm not sure if that affects Officer Morton's testimony. I mean, he responded, he did what he did, but I'll leave that.
Well, I guess I initially let's take out, there's a social worker to testify who, and this may be the more difficult one for the court to try to analyze and maybe part of the defendant's point. That,
It wasn't me, Your Honor.
oh, you don't care? You don't care? No, man, I feel, that thing goes off, nothing. Then that goes off, nothing. No. You got me? Okay, thank you, Ann. No, don't worry about it. I feel safe. So with reference to the social worker who spoke to the victim afterwards, I would have to say I might be a little bit concerned if there are concerns with what the victim has testified to, and the victim is relaying certain information to the social worker. I'm not sure, maybe the parties can clarify it if they can, or I don't know. It would seem to me that getting through or understanding what's on the phone is also going to be cloaked in that same context as the victim. If that made any sense.
It did make sense, Your Honor, and I'm racking my brain as to with the preliminary information we have, my concern, defense counsel might disagree, my concern isn't necessarily what the victim said. Our understanding of the evidence, especially with the little of the new evidence I've reviewed, is that the potentially exculpatory evidence, our perspective is that it's not exculpatory because there's a greater context and we have theories and so on. And I think the evidence will highlight that. However, again, like I said, defense counsel might disagree.
Well, and I guess my point to that might be, she might disagree or may not know.
Correct.
Which may be worse.
Yes, Your Honor.
Because it's that greater context, I guess, piece of of that evidence that might not only have some greater context to what the victim says, but might also have greater context to what the victim said to the social worker and what the social worker says.
I understand.
Is that sort of what you're referring to, Ms. Ackenwood?
That's correct, Your Honor. But yes, not knowing what's on the phone, I don't know how it pertains to our social worker or even the officers, because again, there's, from the preliminary information, there were some communications that fell within that timestamp of after the event, during the time that other parties began to get involved. I don't know. And we just know that from the preliminary.
And you know, the difference between the preliminary, other than the obvious difference, the preliminary information we're able to get evidence about the time stamps, because in part of that report, and part of the supplement, I believe, Sergeant Matthews outlines this time, this day, this text was sent, and so on. With the new evidence, I don't have a way of knowing the timestamps on it, and the defense does either. So we would need someone to testify to all of that. And I don't know if Sergeant Matthews has had a chance to review all of it, because he similarly had a problem opening the initial file and has only since yesterday had access to all the information off the phone.
And Judge, I just wanna, I guess I need to just put this on the record. I know that I think it's important that the court notes that my client never requested for the people to get his phone. My client never requested.
Right. I mean, I agree with that piece, but and I'll certainly let you finish. What my point was, the defendant, at least as I was informed, the defendant wanted his phone, which he believed to be in his property.
Correct.
That his reason for that is because there was a belief that there may be something that might be exculpatory on the phone.
Correct.
Okay. When the defendant was, or at least the court was aware that he wanted the phone, I was then informed that the police agency had picked up his phone and had his phone. So if anything, I'm saying in terms of the request that it was the defendant who was requesting the police go through his phone, I don't think that's not what I meant to say. What I meant to say is it transpired that way because there was something there. People, to their credit, then said, if there is something that is exculpatory, then we want to make sure that the defendant has that. So that might be a clear picture, but I'll let you go ahead.
Sure. Yeah, so that is correct, Your Honor, but I think the piece that the court should probably also note is that the only reason that they picked up the phone was because my client was asking a family member to come and get his phone for him so that he could instruct us on how to get that evidence out of his phone. And the police department overheard that call and took it upon themselves to come and pick the phone up. And then that's where we got into this entire delay because there was negotiations as to how we were going to get it to the phone and things of that nature. So it does not change where we are. I just felt that it was important to clarify the record to that point.
And please understand that I wasn't trying to, and I think I may have said it at the end of my first statement, I'm not trying to blame anybody for the delay. I'm not trying to say the defendant is trying to delay this out or the people. It is what it is. I just wanted it that we, and I'll take you at your word for how or why they picked up the phone. But suffice it to say that somehow or another, that train started rolling down the tracks.
Correct.
And so
Absolutely.
we all had to deal with it. So.
Even if I could just add one thing, and it's simple for the record, because I know everybody here is aware of this. When we were here and there was information from the defendant that he wanted potential exculpatory things off his phone, I want to be clear, it wasn't a PCC. We were here for exam. The victim was here. People were ready to go. What I want to add to that is that defendant also has a bond violation, and I know he hasn't been sentenced on that bond violation, and I'm not sure what the sentence would be. But this is there are many factors that go into this, and that is one of them. And the violation is such that it's not just a minor technical violation; it's quite a serious one.
So I guess the defendant wants to proceed right away, and I get everything that counsel has stated, but I'm worried, just secondarily, that you'd be placed in a position of attempting to try to cross-examine a witness for your client's benefit, where you don't have benefit of everything. And that really is fundamentally my big concern.
Your Honor, I'd say the people share that concern, and in communications with counsel, I also want to be clear that if we don't continue today, that is not from the people not being ready. That is not from the people saying we don't want to continue. In fact, as I stated, the victim is on her way despite many difficulties to try to make it here, and our witnesses are present. So for as much as it helps to the defendant's benefit, this is us also trying to be very careful in how we go about things. None of us want there to be issues on appeal. We all want to make sure that we're very careful and respecting not only the rights of the victim and the people, but really the rights of the defendant.
Right. Ms. Eckenruther, have you had a detailed conversation with the client about going forward today? I mean, I realize that some of the issues that the court is raising, you may not have because I've raised those, but you're smarter than I am, so you may already thought about that.
And Judge, I mean, if the court is okay with giving me a moment to, now that he's been able to sit here and listen to all
Oh,
sides
okay.
of it, yeah.
And I'm not gonna have a problem with that. Let me, what I've said about the social worker, does either party see with reference to the two officers that same potential issue arising?
Your Honor, it comes down to what Your Honor very eloquently put. We don't necessarily know. I don't have reason to believe. There's nothing I've seen up until now that would suggest that there's, of the things I've seen, there's nothing that would make me think that we couldn't proceed with the officer's testimony. But
I'm sorry, I don't mean to interrupt, but the officer spoke with the victim,
correct, yes.
correct?
Yes.
And from speaking with the victim, a report, that's part of the report, right?
Yes, Your Honor. So there was an interview with the victim. There was an interview, of course, with the social worker who had spoken to the victim. And there was at least one interview with the defendant.
Okay. I mean, just, and I haven't had a chance to necessarily think that entirely through, but it would seem to me, oh my goodness.
Instant smile, Your Honor. Just making sure we're doing our
I can
jobs.
hang out for a
right.
little while for the court's next recess.
Well, I'm out. All right. It is so good to see you.
Thank you. Good to be seen.
I'm happy now. Despite your,
Thank you.
despite your non-attention to my safety. I'm happy. What? So, let me just put it in a nutshell. It would seem to me, and maybe this would be the conversation that needs to be had, that anyone who spoke with the victim is going to fall, in my mind, into that same potential concern regarding placing context around what her statements are. I think we're in the same boat. I picked the social worker initially because it was going to be difficult, but there was also going to be a closer conversation between the victim and the social worker. But I think if the officer interviewed the victim, that same thing is going to happen or potentially happen in the Simpsons.
Your Honor, may we approach just briefly?
Well, no, this is where it starts. You know, I'm going to just tell you, I walked in here, two of my favorite attorneys, and I said, this is going to be a good day to come back from vacation. You have both ruined that. You may have heard.
14A District Court, County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson.
You may be seated. We're going to need that seat. Thank you, Ms. Perry. Yeah, you can tell Garen and Simon are really gentlemen because when thought I'd just throw that out there. I'm just observing. Well, I didn't expect Simon, but Garen. Court does call the case of the people, we call the case of people versus Burns.
Good afternoon, Your Honor. Grace Ann, the prosecuting attorney about people.
And good afternoon, Your Honor. Assistant Public Defender Shanazi Kyriakin-Riley, on behalf of Mr. Jerome Burns. Mr. Burns, would you state your name for the record?
Jerome Burns.
All right, very good.
So, Your Honor, thank you for the court's patience and allowing us to talk through a few things. As I indicated to your honor and defense counsel, I've looked through a great deal of the evidence. I was handed a essentially summarized report by the detective who did the extraction from the phone. I shared that for today's purposes with defense counsel. We both kind of skimmed through it. With what was in that report, I felt comfortable proceeding today with the responding officer, with the social worker witness, and starting with Sergeant Matthews. I was not necessarily comfortable proceeding with the testimony from the victim until I've looked at everything more at length. So I guess we wouldn't have a request to adjourn. However, we also understand defense counsel's side of things and want to be understanding of the concerns that she has and time that she may need to look through everything. So we also wouldn't object to an adjournment at this stage.
And Your Honor, I think that she did state the fact that there was a new summary that was provided to us today by the officer who was able to do the extraction from the phone. I did have an opportunity just to glance at that summary. I spoke with my client. Previously, the court is always obviously aware that his position was for us to continue on with the exam today. In light of the new information, by way of summary that was submitted to us today, I need time to go over it with my client and see if there's any insight or context that he would be able to add to it for me. Most of this is communications with the complaining witness specifically. So there's just a lot of information that we have still yet to go over. So I guess that although my client, for the record, is not asking for the adjournment, we're just letting the court know what position we're in right now with the information that's been presented to us.
All right. Understood. And so from the court's perspective, and I'm going to adjourn the matter, finding good cause to do so. Counsel's been very good at explaining to me exactly where the parties are. I think it would certainly behoove the defendant to be able to have his attorney go through that information and then go through that with him in fairness. As I also expressed to counsel while we were in chambers, I strive to make sure that the decisions that I render in these cases, in every case, is the correct decision. And it would worry the court a bit that if there's information out there that is not being provided to the court that may give either some context or understanding as to the testimony that I'm hearing. So for those reasons, the court will adjourn the matter. I will be adjourning it, also part of the discussion in back, realizing the defendant is in custody, has been in custody, and that there are, without going into the details of it, vacations that are scheduled and other things, plans that people have made, and so that we can have consistency. We picked August 13th as a date to continue. Court's going to do, and that will do that August 13th at 9 a.m. The court, for its part, is flipping its docket to handle what would be in the morning, in the afternoon, to try to accommodate this and to make sure that we get this done in at least a reasonable period in time. Counsel has also let me know they think that will be enough time for them to be able to get through everything. So that there's a full understanding, and from the defense side, being able to also discuss that with the defendant. Right, so August 13th, 2025, 9 a.m. for me for the continuation.
And Judge, if I may address first? Your Honor, with obviously the court is very aware of the continuances that we've had in this matter. Mr. Burns has been in custody for 81 days to date from the date of the original arrest. I know that there is a current issue, or at least a bond violation that he has already entered a plea to, that the court has yet to sentence him for. I do not know what the court is going to do. I'm not sure if the court has been able to make a decision, especially based on the status of the case as is. I received information from my client's mother on yesterday that his father is currently in the hospital. He suffered a stroke on Friday. And he has been hospitalized since then because my client does not have telephone access, or anything of that nature. He had been completely unaware of that until I had spoken with his mother. And then I was able to relay that information to him. She has been finding it very difficult to handle her husband's affairs and to assist with his medical upkeep, especially when he is going to be released by God's grace. He will be able to be released sometime soon, and he'll have a significant treatment regimen that he will have to undergo. I know the court is aware that my client lives with his parents and had been living with his parents prior to this situation. They're not considered as elderly, but they are older. And his mother will need some assistance. I know that the court has heard some testimony in this matter. We'd like to ask that the court consider giving him a bond that he would be able to post, ideally, preferably a personal recognizance bond. I know that there are things that the court can put in place to protect or address any concerns that they may have for the complaining witness. He is not a flight risk. The court knows that his parents have been at every one of his court hearings from the beginning. So we know that he himself will be at every one of the court hearings based on what he has assured us. The way that this case has gone in so many different directions, Mr. Burns 1000% understands that he is fully in control of what happens next. If the court is willing to give him a personal recognizance bond, I dare to say that he understands that any actions on his behalf would negatively impact his case, because they have. Everything that has happened thus far that has brought us to the number of continuances that we've had. I've spoken with them. Most of them, if not all of them, have to deal with some type of action that was taken by him. If that has not taught him that his actions directly impact the outcome of the case, or at least the ability for us to try this case in a fair manner, I don't know what else would help him do that. I believe that he is understanding the importance of maintaining his bond. I believe he understands the importance of no contact with the complaining witness in any shape or fashion, with the issues with his father, the assistance that's needed by his parents. We're asking that the court make a consideration of giving him a bond, and if in the alternative, judge, at least allowing him to be able to communicate with his parents so that he'd be able to keep up with what is happening with his dad. We prefer that he be given a PR bond. I mean, he has been trying his absolute best to aid in his defense from the jail. It has been quite difficult because he only has his parents to rely on to relay and give us whatever information they may have. So that is our request today. Primarily based on the number of continuances that we've had. I know we've talked about it on the record, and not that anyone is at fault for that, but he's been in jail for 81 days on this case, Judge. So we're asking for a personal recognizance bond.
Your Honor, we have a great deal of concern in this case. We had a concern initially when this case was charged. That concern has done nothing but grow as this case has progressed. We heard testimony from the victim, quite extensive testimony about the level of coercive control that this defendant had on her. That gives us no hope that that has changed. Part of the reason that we don't have that hope and don't believe that anything's changed in his mind for the better, at least if anything has changed for the worse, the actions he took while he was incarcerated after been given very specific conditions of bond. At that point, it should have been clear to him, if it weren't previously, that engaging in behavior that makes things more difficult for the victim, who is the mother of his child, is not going to be beneficial to him. What he then decided to do is make several calls, ensuring, first of all, he fought her having access to a vehicle to transport their sick child while we were in court. Even to the point where his father was willing to hand over keys, and we thought we had it resolved, and he refused. Then when the court ordered, keys need to be turned over to the victim, she needs to have transportation. The court had a long conversation with him about the situation and what would be appropriate what he needed to do. He then decided it'd be a good idea to have people, third parties, contact the bank, trying to get this car repossessed, going so far as to say the victim who was staying at the domestic violence shelter at the time, make sure that they come and repossess the vehicle as she's trying to unload her things. I mean, this is a woman who has had everything taken from her. She has no place to live. She had no transportation, and she's caring for a sick child, defendant's sick child. He also, during those calls, made statements about how he would have assaulted Your Honor, if he wasn't handcuffed. All of that is plenty concerning. In addition to that, he made statements on the jail calls, and we heard through the victim's testimony that he has made statements, and I believe the evidence we now have can corroborate that, of taking their son away, and that the victim would never see their son again. She also testified, of course, that was part of the reason that she gave it in this case to the sexual assault, and it was a big part of her concern in this case. So when we're talking about victim safety, we have concerns because of that coercive control, because of the hourly check-ins he required from the victim, knowing exactly where she is, who she's with, and so on. That doesn't just go away. We also do have concerns that he would take their son and disappear. So both for flight risk and for victim safety, we have a lot of concerns. We'd ask the court to deny the motion.
Yes, Your Honor, I just wanted to address a couple of the issues that were raised by the people. At this point, my client does not have a vehicle. The vehicle was turned over to the complaining witness, and obviously the court is aware that the vehicle is either not working or something to that effect, because the complaining witness has needed assistance from the people to get to court on each of these hearings. So he is going to completely have to start all over. We've already pled to the bond violation. I think that it should be noted that no contact with the complaining witness was actually made. There were attempts from my client. We do not deny that, Your Honor. Most of that was due to frustration and what he was dealing with at the time, and just trying to understand how he found himself in this situation. He has taken responsibility for that. And I think that should give him some type of benefit of the doubt, Your Honor, because he has been able to take accountability and responsibility for the actions that he did commit. However, the complaining witness left the home that was shared by all of these parties well before this incident happened. He does not have any control over her. If he did, she would have still been in the house. The only reason that we're here right now is because their son was in the hospital, and they were at the hospital together. Whatever control or coercion or dominance the people believe that he has over the complaining witness, there has been no showing that is the case ever since she left the home. So I don't think that is a concern that the court should have. My client has much more important things that he needs to worry about right now, rather than whatever it is that's going on with his relationship. He has not tried to contact her directly while he was here. The only contact that was alleged was the fact that he asked someone to go and have the car repossessed because it's up for repossession. And I mean, quite frankly, Your Honor, he is still financially responsible for a vehicle that he no longer had control over. And his position was, if I don't have control over the vehicle, then let the bank take the vehicle back, and everybody will just deal with things the way that they were dealing with it prior to that. I do not think that the court should or would have any concerns with my client contacting her, having any issues. He wants to focus on his family, his father, and his mother. He has work that he needs to do, Your Honor. He needs to be able to help his parents financially. That is the position that we're in right now. He has to start all over. He has no leg to stand on right now other than a place to live, which would be at his parents' home. I think that a hot zone tether, a tether of some sort, would be able to protect him. He doesn't even have a phone, Judge. The phone that he did have is in the possession of the police department. He would be using his parents' phones, if anything. So he doesn't even have much to work with. So I don't think that the concerns that the people have for the victim's safety or the complaining witness's safety in this matter are valid, because my client can barely take care of himself at this point.
The court, having looked at it and also having bit familiar with the bond violation that I've yet to sentence the defendant on. Certainly, given, and again, it's not anyone's fault necessarily, the continue time to make sure that all of the evidence is properly analyzed by each side. The court, in any sentence that it does impose, and I did represent this to counsel, will take into account the time that the defendant, I'm not making any guarantee as to what extent, but we'll take that into account in terms of any sentence that it would impose. I still do consider the defendant to be a risk to public safety and to the victim in particular in this case, and would deny the defendant's request for a bond reduction at this time. I will, however, given light of given notice of the circumstances involving his father. His father, I know, had been in these proceedings in the previous times, that I would permit, although I have revoked his phone privileges, to the extent it can be arranged with the Washington County Sheriff's Office and jail, I would permit the defendant to call his father while he is at the hospital one time per week, so that at least he can have communication with his dad. All right. And maybe then facilitate some of the issues that his mother might be running into in terms of the caring of the house. So counsel, if you prepare an order to that effect. But once, so that I'm clear, once his dad leaves the hospital, his phone privileges will go back to the status of being absolutely revoked. All right.
Your Honor, may I just add one thing? I'd asked the court because part of, and I was going to respond to counsel, but I felt that unnecessary at the time. Part of the jail calls indicated that he was asking his parents to contact the victim to have her essentially get rid of this case. So maybe a warning that, so he's very clear that these conversations, so we cannot be about the case, about the victim or anything like that. Thank you.
Yes, and I think that ought to be clear, and you understand that, Mr. Burns. Yes. All right. So the case should not be discussed, certainly no directive should be given to your dad in terms of what to do or anything else along those lines. If I find that to be the case, that's just going to be another violation of my order, and I don't think we want to end up in that situation. All right. I'm doing it solely because having found out this information, your dad's in the hospital. I think that as an act of grace, the court is going to give you the opportunity to at least speak with your dad. All right. Okay. Thank you.
Thank you.
All right. Folks, I realize we're running a bit behind. You can see that I've been dealing with that. You're gonna have to give me 5. I'm gonna take a brief recess. I'll come back and then we'll start calling cases. Court's in recess.
All right.
Yes. Okay. Date and time set for sentencing. Ms. Flair, go ahead.
Yes, Your Honor, Teresa Blair on behalf of probation. Your Honor, I did want to make the court aware that I do know Ms. Keebler from a prior work relationship, which we did have social events that we had while that was taking place. I did want to make the court aware of that. However, I don't believe that my recommendation to the court is impacted in any way. I believe that the recommendation that I provided to the court would be like any other probationer that came. And those events happened a while ago, a long while.
Not wanting to age oneself, you're just saying a while.
That's
ago.
correct.
Okay, all right. And I will just say that I had previously disclosed in taking the case that I also know Ms. Keebler. And we had a working relationship, both the state prosecutor as well as defense counsel saw no issue with this court proceeding with the case, given that. I would also say that I would have known and knew in the past that there was a working relationship as between Miss Calera and Miss Keebler. And I would expect nothing less from Miss Calera, and she has never disappointed me that she would not let that affect her in any way. And certainly when I look at this recommendation, it is a standard recommendation and does comport with this court's manner of sentencing in these types of cases. So unless there's an objection for the defense in that regard.
I didn't object then, and I'm certainly not objecting now. I think the court's correct in its characterization of the recommendation, and I appreciate Ms. Pilar putting the disclosure on the record.
All right, go ahead.
Your Honor, we have reviewed the recommendation. We've also reviewed the assessment that accompanied the recommendation, including in the conference room today, but also prior to this. We, with the exception of, and then we discussed this at the bench, Ms. Keebler needing some accommodations when it comes to alcohol treatment, which we discussed, don't have any other comment really with respect to the recommendation. It is as I would have expected, and I explained that to Ms. Keebler. So we're prepared for the court to proceed forward accordingly.
All right. Ms. Keebler, is there anything you'd like to tell the court before I impose that?
Your Honor, how do I adequately apologize for being in front of you today? If anyone knows better, it's me. I want to thank you for overseeing my case today. This has been an incredibly humbling experience, and I promise you you will not see me in this capacity again. Thank you.
Thank you, Ms. Keebler. And I'll just say, you people certainly can find themselves in difficult circumstances, but I think that much of it, sometimes behind the scenes, the way you have, at least the time that I've known you, served the people of Washington County, mistakes can be made, right? But it doesn't by any means diminish the service that you give to the people here. This court does acknowledge that this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of IOP treatment, attendance at weekly AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. This is therefore the sentence of the court that I will place you on 18 months probation. I will order $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, and $540 probation oversight fees. When can that be paid?
I can pay it today.
Thank you. That will be paid today. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested. You are to complete an intensive outpatient substance treatment, including all outpatient substance treatment, including all recommended aftercare with status reports to probation. I will just note in that regard that much like with any defendant, that where an accommodation is required, we will provide that accommodation for the defendant.
Thank you.
You are to attend 2 AA meetings per week with monthly verification to probation. You provide proof of victims impact panel attendance to probation. I will continue the scram tether for an additional 30 days in lieu of 4 days in jail. However, 93 days in jail, credit 1, the balance is suspended. Love to you, Ms. Keebler.
Thank you.
Thank you, Judge.
Thank you. Court does call the case. People versus Edward Harris. Okay, can you hear me, Mr. Harris? Can you hear me?
Yeah,
Okay, good enough.
how you doing, Your Honor?
I'm doing well.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Harris. Mr. Harris, can you state your name for the record, please?
Edward Harris.
Teresa Claire on behalf of probation, Your Honor, Mr. Harris is before the court for violation of probation hearing. Mr. Harris is in violation of the terms ordered by this court in that he owes a balance of $1,095, having made no payments. He failed to report to probation as directed, he failed to provide proof of substance abuse treatment, and failed to complete or provide proof of a mental health assessment. Mr. Harris additionally has had new police contact with a new case being filed or submitted to the prosecutor's office. Your Honor, that alleged date of offense was May 3rd, 2025, with the requested charges of larceny in a building. Probation is also aware that Mr. Harris has some violation of probation hearings out of circuit court. That's going to be addressed there. It's my understanding from the felony probation office that he's likely to serve jail time in those matters. Given all of the circumstances, probation is recommending that Mr. Harris serve 365 days in jail with credit for 88 days that he served the balance. He completed in jail MRT program for the court to consider early release upon completion of that, waiving all other terms except his financial obligations and discharging him from probation.
I did have a chance to speak with Mr. Harris and Ms. Pilara about this. I'm going to ask for an adjournment of this hearing, actually, to see what happens both on the felony case, as well as I would like to get some documentation from Mr. Harris's caretaker, his sister. He's been having pretty significant memory issues. He had an aneurysm earlier this year, and I want to make sure that if that could have an impact on the sentence, the court and probation has that information, and to see if felony probation has that information as well. I mean, frankly, Your Honor, if I ask Mr. Harris if he's been diagnosed with dementia or Alzheimer's, he doesn't remember. So he's been having some memory issues, and like I said, his sister is his full-time caretaker. So I just would like a chance to speak with her more, to know more about what's going on with him.
Well, it would seem to me that both could happen. I mean, the significant penalty in this case is the jail time that I would be imposing. I am certainly, if information is provided after you speak with this, is to probation and into the court to reconsider the amount of time, if any, that the defendant would serve. So I'm going to decline the adjournment. I think I'm going to go ahead with the sentencing with that caveat that if you provide that information, I'll take a look at it.
Sure, if anything comes, I'll get it to the court.
All right. Okay. Is there anything you want to tell me before I post the sentence?
No.
All right. Given all of that, I'm going to order 365 days in jail, credit 88 days that he served defendant, and I'll order the defendant to serve the balance. I will indicate also that the defendant is to complete the in-jail MRT program. I will consider an early release upon completion of that program, as well as if other factors are submitted to the court that would dictate an early release. I will waive all other further terms except his financial obligations, discharge him from probation without improvement.
Your Honor, if I may ask one question?
Yeah.
I don't know if when Mr. Harris walks out of this room, he's going to remember to enroll in the MRT. Will the jail, since it's court ordered, will the jail automatically enroll him? Do you know? Or any
I don't
of our
think it's automatic,
officers?
but
I can get in touch with the jail and see if
why don't we?
they can help me
So
facilitate that.
Okay.
Okay.
Do it that way.
Okay, thank
All
you.
right.
Thank you.
Thank you. You take care of yourself, sir.
Okay.
Let's call the case of the people versus Daniel Noble.
Good afternoon, Your Honor. Brendan Balsam, up here on behalf of Daniel Nagel.
I'm here as well, sir.
State your name for the record, sir.
Daniel Allen Noggle.
You have it. That's all what.
Hello?
All right. Yes. Go
Your
ahead.
Honor,
Make-
Your Honor,
making-
today's, go ahead, I'm sorry.
No, I'm making sure you had me.
Oh, we've got you.
Oh,
Okay, go
boy.
ahead.
Your Honor, today's date and time set for sentencing in this matter. That being said, I had the opportunity to review the pre-sentence report with Mr. Noggle. The only correction I'd ask the court to make, it just is a simple one. It's on the first page where it says place of birth. It says Tecumseh, NI, that should reflect MI for Michigan. But other than that, everything is factually accurate. No corrections, additions or deletions.
Anything either of you'd like to say before I do impose sentence?
Just a few things on his behalf, Your Honor. Mr. Noggle is 45 years old. He does reside in Tecumseh. He's never been in trouble before. He does have 2 children. He's been in a long-term relationship. He just started a new job that he's very proud of. He did accept responsibility for his actions. He was very candid with the probation officer about the incident. He's fortunate that nobody was injured or even worse, killed. With that being said, Your Honor, I think the recommendations are fair. I would ask you to adopt those. There is one caveat. He did indicate to me just recently that he has a pre-planned trip from August 13th through 19th. It's a family vacation to Tennessee, and he's asking for permission to be able to travel.
Sir, anything you want to tell me before I impose sentence?
I would like to just apologize to the court and the people for my actions. Was a bad judgment call on my end, and I appreciate everybody's time and effort and helping me with this and getting this on the right path.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of alcohol education, attendance at 1 AA meeting per week for the next 90 days, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court will place you on 9 months probation, order $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, $270 probation oversight fees. When can you pay that, sir?
I would ask if it would be possible for me to pay that back in 4 equal payments with the option to pay early if I can do so.
We'll always take your money early. But
Perfect.
when do you want to start this and how much are you going to pay up front?
I can pay $350 up front today.
All right. Pay $350 today, and then it'll be a payment plan as arranged by probation for 3 other equal installments or other installments.
Okay, sir.
There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety education program. You're to attend 1 AA meeting per week for the next 90 days with verification to probation. You're to provide proof of the victim's impact panel attendance to probation. Allowed 93 days in jail, credit for 1. The balance is suspended. I will also order the defendant may travel to Tennessee, and that was the 13th through the 19th. Is that correct, counsel?
Yes, Your Honor.
13th through the 19th of August. Not sure why you want to go to Tennessee, but what the heck? All
I mean,
right.
hey, thank you, sir.
Just kidding. All right, thank you.
Your
Thank
Honor, can I
you.
ask one last question? I had indicated my client, provided he's in compliance with everything that Your Honor just ordered, he can petition halfway through his sentence for early termination of probation, correct?
Yes, that's provided for by statute, so he can certainly petition. Court makes no guarantee as to whether or not I would grant it, but he can certainly petition halfway through.
Fair enough, Your Honor. Thank you. And should he reach out to the probation department today or will they contact him?
Yes, he can reach out to you.
Yes, you can reach out to the probation department.
Thank you, Judge.
Could I please get the number to call for that, please?
Sure.
Your Honor, we'll reach out to him.
Okay, we're not giving you the number. They'll reach out to you. No,
Okay.
all right.
Can
All
I,
right.
I'm
Thank you, Judge.
sorry, can I ask one more thing?
I can't stop you. Go ahead.
I work till 9 PM tonight. Is it possible for them to call me in the morning?
Yes. Yes, right.
Yes, of course.
But I
We
need to-
have that scheduled.
But I need to make that payment today. How do I do that?
On your screen,
Yes, sir.
you're on a phone, so you're probably gonna have to swipe screens. There's a QR code. That QR code will take you to our payment site and you can pay by card there.
Okay, perfect. I'll
Okay.
do that.
Okay, I wait till I give it a couple hours so we can get the information entered. Okay?
So how I can still find that QR code on the website for the 14A court?
Your Honor, my office number is 734-973-4883. Mr. Noggle, call my office and my assistant can help you.
Thank you very much, everybody.
You're welcome. You're welcome.
Any other questions?
No, sir.
No, thank you.
All right, good. Thank you.
Bye.
Court does call the case, People versus Andre Smith.
Your Honor, good afternoon, Joe Simon on behalf of Mr. Smith. State your name.
Good afternoon.
Andre Smith.
All right.
Your Honor, we have no factual corrections to make to the pre-sentence report. The recommendation is consistent with our expectation. My client is very remorseful and has done a really good job of putting himself in a position to, I think, fulfill these requirements timely.
All right. Sir, anything you want to say before I impose sentence?
I take full accountability for my actions, not only because I've broken the law, but because I've fallen short of the standards that I hold myself to. So I thank you guys for the opportunity to do better.
All right. Sentence of the court, 4 months prosecutor deferred sentence. You're to pay $480 fines and costs, $100 probation, oversight fees when can that be paid?
Everything today.
Fantastic. Pay that today out of the counter. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. There is no going to any Walmart store in the state of Michigan. I'll set a review hearing that to be held November 12, 2025 at 9 a.m. I'll order 365 days in jail that is suspended.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Sherry Walker.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Sherry Walker, who is approaching.
Hi.
Please state your name for the record, ma'am.
Sherry Walker. All right.
Teresa Claire on behalf of probation. Your Honor, Ms. Walker is before the court for a violation of probation hearing. Ms. Walker is in violation of the terms ordered by the court in that she owes a balance of $1,218 having made. She failed to complete a substance abuse assessment and or treatment. She failed to complete a mental health assessment and treatment. She failed to complete 25 hours of community service, failed to report to probation as directed, and has 4 new pending criminal cases, one being in possession of drug paraphernalia, a retail fraud, second degree, another possession of drug paraphernalia, a retail fraud, first degree, second offense, and a retail fraud, second degree, second offense. All of those incidences happened after being placed on probation. Given Ms. Walker's non-compliance with the probation and her failure to follow through probation, is recommending that Ms. Walker serve 365 days in jail with credit for 13 days served to date to serve the balance that she completed in jail on program with consideration of early release upon completion, waive remaining terms, accept her financial obligations, and discharge her from
probation.
Thank you, Your Honor. I did have the opportunity to meet with Ms. Walker and discuss these violations of probation with her as well as the jail recommendation. We do acknowledge and admit to the alleged violations, and I would ask to argue against the jail recommendation, however, when appropriate.
All right. Mention the violation.
Yes, Your Honor.
All right, go ahead.
So, Your Honor, I was able to have a very long, meaningful conversation with Ms. Walker. And first off, she does want to apologize to the court that she did not complete the terms as ordered on probation. And she does acknowledge that she currently has some pending cases, and I do not want to comment on those as they are still pending, outside to point out that it is my understanding they are all non-assaultive allegations. My client does reside in Ypsilanti by herself. She receives Section 8 housing. Ms. Walker states to me that prior to her receiving Section 8 housing a year and a half ago, she was a resident of the Delana Center. Since receiving this housing, her life has changed in a lot of positive ways, including that she has potential work at a laundromat actually down the street here. She is a caregiver for her mother who resides in Ypsi. Her mother is 83 years old and is unable to really get around. My client is also engaged at the Hope Clinic on Harriet Street and has even spoken to people there about the possibility of potentially volunteering. My client is very concerned that a year in jail, of course, would leave her likely losing her Section 8 as well as then her current apartment that she's been in for a year and a half. She even stated to me she thinks the TV and the lights are still on at home and she's concerned about paying rent, which Your Honors wears on is usually due on the first. In her case, it certainly is that she has to pay her portion of the Section 8. My client states to me that she came into custody when her name was ran and she was picked up. And she states to me that she does not believe any new charges are coming from that police contact. Ultimately, I'm asking the court to consider discharging Ms. Walker from probation without improvement. Closing out this case and not imposing the jail time so that she can maintain her housing.
Ma'am, is there anything you want to tell me before I impose sentence?
Yes, sir. How you doing? Remember I lived in Montgomery, resided in Montgomery, and we did the Zoom, and you had gave me some community work to do, and I was in the Salvation Army, but the husband and wife got in trouble by using drugs, so they closed it down. But I did do some community work there, some hours there, and also I also was going to my court during the through Zoom. I was doing all that. So like when I opened up my blinds every morning, it was a dope house there and the church that I was doing community work there, service there for you. I was just struggling, because I love to open up my blinds every morning. And so, I was doing so well until one day a friend of mine brought up drugs and I forgot I even did drugs. I was doing so well. And so I got back up here. I went to the Delana Center. While I'm on drugs, I was determined and got on Section 8. And now I live by myself on LaForge. And I'm the only one with the key. And I do believe I left my lights and TV on. And I don't know no neighbors out there because I was only out there a year and a half. I haven't been out there. And then they're like coming through, because we was on the news about the mold and all that kind of stuff. And so Section 8 have people coming through certain house apartments to check the the mold and the whatever that's wrong with our apartments since it's been what you call it, new management, build property. But I haven't been on if you can release me to I haven't been on Tether over 40 years as I was, in juvenile. I haven't experienced being on Tether as an adult. So if you can please release me, if possible, so I can take care, I don't lose my place in my Section 8. And you can put 2 of them on my arm, my wrist, and my ankle. And I would do anything that you want me to do. If you just give me a chance on Tether, I'll pay the fines. I'll drop clean. Because I have a job down the street, the laundromat. I can give you documents of that when I go to work. And also the owner of the laundromat saw my work ethics. And he gave my friend an application to give to me to fill out for as a affiliate. So I have that going for myself and the whole clinic. I have that going for me. And I just can't do everything. I just can't be locked up and lose everything, be back at, on the streets. And the only thing I love, I will show you. I'll drop clean. If you give me one more chance, release me the tether. I can show you. And then if I mess up then, I swear I'll just do whatever you want me to do. But please, can I go home?
How'd you come back into custody?
I was on my friend's house, lived across the street from me. She was about to do my hair. And next thing I knew, they just busted the door down. And they ran my name. And that was that. And that's how I ended up here.
Because I originally sentenced you back in January of 2023. Didn't do anything on my sentence. We had you set to come back April 10th of this year on the violation of probation. You didn't show up. And now we have you back.
Can I respond to that? My mail was going to my mother's address. I didn't have a place then, and she didn't tell me that I had court and then like that. And I'm not gonna lie on my mom, but I didn't have a place then. I just recently got my place, and I didn't know because my mail was going to 2302.
You knew you were on probation.
Yes, sir.
You didn't call probation.
No, sir.
And you knew that you hadn't done anything.
Well, I had started down in Montgomery.
You knew you hadn't done anything on probation. Right?
Yes, sir. But
You'll hold the keys to whether or not you get out of jail. But I'm going to order the 365 days in jail, credit 13, defendant is to serve the balance. I will consider release upon her completion of the in-jail Dawn Farm program. I'll waive all of the remaining terms, including accepted financial obligations, and discharge her from probation without improvement.
what that mean? Can I do a year?
Calls case people versus Jacob Treadway. He needs to go.
Oh, sorry.
Good afternoon again, Your Honor. Joe Simon on behalf of Mr. Treadway. What's your name? Jacob.
Jacob Treadway.
Thank you.
Your Honor, we're here for sentencing. We have no comments on the recommendation other than to say my client can pay his anticipated fines and costs today. And he's going to fulfill all the requirements the court gives.
Sir, anything you want to say?
I'm sorry for the mistake I made, Your Honor, and I'll learn my lesson. I'm never going to drink and drive again. I promise.
Court does acknowledge this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient programming, weekly attendance of AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court place you on 12 months probation. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. You pay those today.
Yes, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete outpatient, inpatient, or outpatient treatment, at Dawn Farms, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with proof of probation. You're to provide proof of the victim's impact panel attendance to probation. I'll continue the sober link testing for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail, credit 1, balance suspended. Thank you.
Thank you.
Court calls the case of the people versus Kevin Smith.
Public Defender Natalie Pate with on behalf of Mr. Smith, who's approaching. Please state your name for the record, sir.
Kevin Smith.
Thank you, Your Honor. I have had the opportunity to review the sentencing recommendation with Mr. Smith, and we are asking the court to adopt it.
Sir, anything you want to tell me before I impose sentence?
No, sir, I just wish that, I know the decisions I've made while under the influence of alcohol haven't been some good ones. And, I just wish I would have seen that at an earlier age. That's about it.
Sentence of the court, $125 statutory fee. I'll order 93 days in jail, credit 32 served. Defendant is to serve the balance. He is to complete the in-jail Dawn Farm program. The court will consider early release upon his completion.
Thank you, Your Honor.
Court does call the case, People versus Rebecca Miller.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller, who is present via Zoom. Ma'am, can you please unmute and state your name for the record?
Rebecca Miller.
Thank you, Your Honor. I've had the opportunity to review the report as well as recommendation with Ms. Miller. The only very brief correction we have is to her mailing address. She's requesting that apartment 8 be added to that. Outside of that, we have no corrections to the report and would ask that the court adopt probation's recommendation.
Ms. Miller, anything you want to tell the court before I impose sentence?
No, Your Honor.
Sentence of the court, I'll place you on 12 months probation. You are to pay $480 fines and costs, $360 probation oversight fees. When can you pay that?
I need a payment plan, please.
A payment plan as arranged by probation.
Thank you.
There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete an outpatient treatment at Dawn Farms, including all recommended aftercare with status reports to probation. You are to attend a minimum of 3 AA meetings per week with monthly verification to probation. You are to complete 25 hours of community service as directed by probation. There's no going to any Meijer store in the state of Michigan. I'll order 93 days in jail. Credit to the balance is suspended. Thank you.
Thank you. Thank you, Your Honor.
Thank you, Ms. Miller.
Court
Thank you.
does call the case People versus Michael Collison.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Collinson. Mr. Collinson, please state your name for the record.
Your Honor, this is Michael Collinson.
So, Your Honor, I guess there's kind of two pieces of why we're here. There is an allegation of Mr. Collinson's tampering with the tether, I suppose, and then his discharge from treatment. And I'd like to address both. I hope that the court got, regarding the tamper, I think that, I've had an opportunity to speak with Mr. Collinson for a long time about both of these issues. Looking at the pictures, to me, it looks like wear and tear. Mr. Collinson was brought in with the tether still on his leg. He was in the jail for, I think, 2 days.
The cuts in the strap are wear and tear?
One of the cuts was, I think, already there. There was like a slit in it. As he wore it a few months ago, he noticed it getting worse. So that has been there for months, and there was no allegation that I did not receive a violation report that it was cut. And I think the second one is kind of similar. It seems to be about the same length as the first cut. And from the rubber in between is kind of looking like it's weakening to me. Again, it was not removed from his leg by him. It was removed by the services group that facilitates the tethers. So he got, the cut is deep, but there's no, if he wanted to, he could have gotten it off. I think, like I said, it's been looking like that for a couple months, and there was no prior allegations that he was tampering with it. He's been wearing.
Saying it is just by happenstance that these two cuts that are almost at equal distance happened, cutting through the one part of it that you're saying that's just wear and tear.
Yes,
Okay.
yes. I mean,
I had no-
again, if he wanted to get it off, he could have gotten it off. I don't understand
I had no reason to cut the top.
if he, if he was trying to evade tracking or anything like that, if he did do those cuts, he could have gotten it off, and he didn't. And he came to jail with it on and had it while he was in custody. He's had it since May, and there's been no other allegations of tampering with the tether or evading tracking or anything like that. Again, Mr. Collinson denies tampering with it at all.
Your Honor, I had no reason to tamper with the tether. I ran from the dentist the moment they told me they were going to discharge me. The biggest concern I have here, Your Honor, isn't going back to jail. It's losing the housing that I gained in my sobriety here. I have a lot of, through the blessing of the court, I've made a lot of successful gains. I've completed 74 days in treatment. I never had a behavioral problem at Dawn Farm. The new treatment facility, there was just turbulence. This all has to do with the dental appointment. That's why I get concerned when we're talking about tampering, because I thought this was all to do with being discharged from Oakdale on the leave of absence. I have the contract. I called Oakdale for pickup at 3:30. I was supposed to return to.
How about I'll start and you can add. So turning to the issue of discharging, I think what Mr. Collinson was starting to say is he went to Oakdale. He was at Dawn Farm from May to July. He moved to Oakdale because he got housing through HUD, which he would move to that housing at the beginning of August. He has plans for DTE to turn on the utilities on August 6th. So he moved to Oakdale, I think because the program was a week less, he could complete Oakdale and then move into his housing. I haven't been able to contact anyone at Oakdale. I've made a couple contacts and they haven't gotten back to me. But the reason why we think Mr. Collinson was discharged was because he went to this dentist appointment. The dentist appointment was longer than what his out time was supposed to be. And when he called, they said he was discharged because he misrepresented the time that he was going to be done. They thought he was going to be done at 3. He ended up calling them, I think, around 4 o'clock, that he was done with his dentist appointment. The other piece is that from Mr. Collinson's understanding, is that they didn't understand or believe his representations about the seriousness of his dentistry issue. Long story short, he has a tooth that needs to be surgically removed. It's rotting out of his mouth. When he was at Dawn Farm, they sent him to the ER. The ER can't really do anything because it needs to go through not a normal dentist, but an oral surgeon. Because of the severity of the emergency, they referred him to the U of M clinic. The clinic skipped the normal 4-month wait and got him in for a consult earlier than normal. So that's why he was there. He has referrals from another clinic that he was going to, saying that they couldn't do the service because he needed an oral surgeon, because they couldn't find an oral surgeon in his network. That is why he was at the dentist. He did, once he found out that Oakdale was discharging him because of this, he did go to Spera. He tried to get a bed at Spera, and they did not have a bed for him there.
You can look at the GPS coordinates, Your Honor. Sparrow is a safe place for me. Sparrow is inside the Don Farm community, which I just did all this time programming. I had no problem inside of Don Farms. The only reason I went to Oakdale, Your Honor, was to receive this housing. Don Farms is a very open treatment center, so I'm able to go out on weekends with my sponsor. My sponsor is the boss and owner of Home Solutions 101. He's given me employment. He's even helped me pay the DTE that's scheduled to turn on August 7th at Danbury. I'm not saying that what I should have done, Your Honor, is I should have called my facility the moment I found out that the appointment was at 2:30 and not 11:30. I didn't do that. And one thing Don Farm taught me was to own my part. And like I keep going back. I don't know why I didn't do that. It would have. I don't. They say I have a thinking disease, and I don't know why I didn't do that. I should have called them. The only thing I can tell you, Your Honor, is I have 120 plus days clean. I'm before you clean. And that means something to me, and I've gained a lot. I'm not asking for like a let go, but I am asking for like an alternative sentencing that doesn't expand on my homelessness. I messed up the probation you originally given me because I was homeless, and just in this short time to be 5 years homeless and to gain this significant opportunity is really huge for me. My biggest fear in this whole thing, in my thinking, is I don't want to lose this homelessness. I begged and cried on the phone for them to come pick me up. They didn't even give me a chance to show them the paperwork. They didn't give me a chance to drop for them. The wear and tear did start. I ran really fast from the school of U of M on Fletcher Street to Sparrow. Like, I mean, I'm talking, I ran really fast. I've been on tether before. I ran like a gazelle, man. I ran there trying to obtain bedding because my thought process was if I could get into rehab before the violation of tether, that I would be able to argue to you that I did the next right thing. Today I'm at your mercy. I just don't want to lose this housing, Your Honor.
So you're indicating that he's denying that he violated it in any way?
I think, I mean, I know Mr. Cousin is very sure that he did not, or very strong, I guess, in the assertion that he did not tamper with the tether. And I guess the discharge from Oakdale by his representation is a miscommunication about this dentist appointment and how long it was going to be, how long he was going to be there, the necessity around the dentist appointment.
I didn't tamper with the tether. I did not try to take off the tether. If you look at the coordinates, I'm not lying. I went.
Well, he wants a hearing on all of this then. Is that what he's telling me?
I mean, I'm asking Your Honor to, I mean, he's done, since he was on probation, he did 90 days in Wayne County. I know Your Honor declined to give him credit for that time. He's done time in our jail here in Washington County. He's been clean for, like you said, over 120 days. He's done almost 70 days at Don Farm and Oakdale of treatment. He has housing that he set up. He has employment through a sponsor that he has set up. I'm asking this court to relieve him of his obligations to this court in the remaining balance, given all of the good things that he has done in the last couple of months. I'm sorry?
I let him out to go to treatment.
I did 74 days of treatment. I'll finish treatment. I will. I'm not trying not.
Valera?
Your Honor, I just wanted to make the court aware. I know that Mr. Carlson is no longer on probation in this case. However, I am being advised by the tether agent, so the court is aware that right after he cut a strap and the agent noticed him not tracking anymore. He called and was told that he was kicked out of, treatment for a policy violation. They also indicate that they have photos of the tether of when it was installed, and it was a brand new strap, if the court would like to see those.
Well, okay, thank you. Well, I don't know if we're gonna have a hearing. I guess I'm gonna need to see them. I've been dealing with tethers, I don't know how long. I've never seen two parallel cuts or tears, I guess as you're trying to say they are, that are in the fashion that they're in.
And I've dealt with tethers not as long as Your Honor, but I
Wow, that was an age thing. Go ahead.
I do know, I mean, I think the biggest argument here, Judge, is that it didn't come off of his leg. I mean, he was tracked the entire time. He didn't, if he wanted to evade tracking, he could have. I mean, people cut them off all the time. And
That's the argument to make, but go ahead.
it wasn't cut off. And he's represented to me that there was an initial, tear in it, months ago, and
Through the metal.
No, not through the metal. There was a tear in the rubber, Your Honor. I noticed it. We went on a trip to Whitmore Lake from Don Farm. Where I was on a paddle.
There was a tear in it. Why didn't you go back over to community corrections and say, I need a new strap?
Honestly, the tear helped because it made it looser on my.
Yeah, on the back of your leg at your Achilles heel, right?
Well, no.
That's why it's cut the way it is.
No, Your Honor, it clonks on my, I have a bony ankle and it just clonks. Your Honor, again, I had nothing. Cutting off the tether would have violated me and that would have made me lose my housing. And my whole point and my whole day, if you look at I got discharged from Oakdale, Your Honor, on that day.
What I have heard is two. One is that these parallel cuts on the back of his tether strap, or on this tether strap, occurred by circumstances beyond your control. The other thing that I've heard is that you were discharged from Oakdale also for something involving the dentistry, and that was also beyond your control regarding the appointment. The only way I'm going to be able to resolve it is if you want a hearing on it. You're not admitting to these violations. And then I'll make a determination.
I don't think Mr. Collinson wants to admit to the violation, so I think we'd ask for a
And we'll
hearing.
set a hearing.
Wait, Your Honor. Setting the hearing is gonna, if I'm gonna lose the housing, I'm gonna lose the housing. Like, what would I be admitting to? Tampering with my tether? Is that what I would admit to, Your Honor? Is that what the violation is saying, that I tampered with my tether?
Correct.
You have two. One that you tampered with the tether. And the other one being that you left treatment.
But okay. I didn't leave treatment.
Sir, I have heard everything that you and your attorney have said.
I didn't leave treatment, so.
You want to keep talking, keep talking.
Just don't interrupt. Okay, I'm sorry, Simpson. I'm sorry.
I'll set a hearing. I mean, that's the best I can do. You can bring me everything and you're saying that there are reasons for all of this, and I'll hear those. But I will tell you with reference to, I don't know in reference to Oakdale, but certainly in reference to the tether, I have great skepticism in what's being told to the court. So,
If I may just explain to Mr. Collinson one thing, Your Honor.
I keep anyway. You just said those other things. Oh, no, we flipped over.
plead guilty. I mean, plead guilty, see what he does. Maybe he'll let me back to treatment.
Sure.
Yeah.
And I've explained to Mr. Collinson that he's entitled to a hearing on the violation. I also advised him that we can call witnesses. He can tell his side of the story to the court. And I think he wants to admit to the violations.
Well, if he's telling me all of this stuff that I just sat here for the past 15, 20 minutes listening to,
Have a hearing.
what?
Yeah, let's do the hearing. You're right. You're right. You're right. You're right. You're right. You're right, Your Honor. Your Honor, is there any way that I can be on house arrest to this new address during the hearing to sign the lease
House
agreement?
arrest will require a tether. We've had our problems with tethers, haven't we? I'll set a hearing in this matter, August 13th, 2025, 3 p.m. This bond will continue as denied until we get to the bottom of it. Thank you.
No bond.
Court calls case, People versus Mark Reed.
Good afternoon, Your Honor. Dan Garrett on behalf. What's your name?
Maureen.
Your Honor, I'll just start by saying Ms. Reed and I.
Karen. Court stands in recess. Your fault.
District Court for County of Washington State of Michigan is now back in session. The Honorable Judge Simpson.
You may be seated. You know why that happened on your case, Mr. Garrett?
Say that again.
You know why that happened on your case?
Yeah.
Huh?
Murphy's Law?
Well, no, we were in back, and so we all voted.
Yeah, let's hear this.
All right, and the reason is because when Miss Kearney got up and you didn't move.
Karma.
That's right, it's karma. I'm just saying.
But it should happen on Simon's watch then too.
What? Yeah, nobody really expected Joe to move.
That's true.
The court recalls the case of the People versus Reed.
Dan Garrett on behalf of Ms. Reed.
Come on, Reed.
All right, thank you. All right, go ahead.
As I was saying, Your Honor, at the time, we're asking to follow the recommendation. Ms. Reed would like to would be curious about, so.
All right, what do you want to tell me?
I've enrolled in classes for the fall semester.
Yay.
So I start those on the 25th. I'm also seeing a therapist that I think is a better fit for me. He's been really helpful. I also, since she did reach out to me about the recommendation she was going to give. I've looked at a couple of outpatient programs that would work for me, that are like in network with my insurance, and also AA meetings that would work with my class schedule as well.
How are you doing otherwise? I hear all the good things you're doing, but tell me how you're doing otherwise.
I'm doing okay. I'm just one day at a time.
Grieving's hard, isn't it?
Yes.
What's even harder, and I was trying to explain to you the last time, was it becomes even harder when you take all of those emotions, and most of them don't even have a name. They're just there, right? And you just start, you don't know what to do with it, so you just start tucking them inside. Right? And you just, and here comes another one, and you just tuck it, and you just do that, right? And then ultimately, and part of the reason you do that is so that you don't feel the pain, right? But then ultimately that pain kind of comes through, right? You worried me, young lady, you know that, don't you?
Yeah. I think I worried a lot of people.
Yeah, I'm sure. Is that your mom back there with you?
Yeah.
Hello. You worried her a great deal, I bet. What does she have to say to you about all this?
A lot. But the main thing that she wanted to say to me was that no matter what, like, she's here for me in that. No matter which way, like, I'm gonna deal with my grief and everything else, I have to do it with her. I can't do it with myself, and I can't do it quietly. And it's not gonna be peaceful, but I have to do it, and she'll be there to support me through all of it.
Some of that you already knew, right? But how old are you?
21.
21. You thought you knew it all though, right? Hmm?
Yeah.
Yeah, but life isn't a sort of solitary journey at times. All right. So you're back in school.
Yes.
Mom's happy about that, I bet.
Yeah.
Yeah. Okay. And you found somebody that's going to fit for you, therapy wise and everything. All right. How long ago did your dad pass?
That's in 2022.
And so you've been just holding it inside all this time.
Yes.
Yeah. Okay. All of it is okay. Your reaction, everything that you've kind of gone through, it all happens for a reason, but it's all okay. You're blessed to have your mother,
Yes, I am.
right? It's a good feeling when you don't have to sort of endure these things alone, right?
Yeah.
When you came in here the first time, did you expect that it was going to go that way with me?
No, I was really nervous.
You were really nervous.
Yeah.
What do you think was on my mind when I first saw you?
I think that maybe I was being a stupid kid.
Yeah, but I see a lot of those. There was something that said to me, something's going on with you. Because doing this as long as I've been doing it, some people you may expect to be here, and then others you don't expect to be here, and you almost have this curiosity as to why. Right? How'd your conversation go with Miss Polaro?
It was enlightening. It was a lot, but I think I kind of got told about myself, which I kind of got told about myself.
Miss Polaro told you about yourself?
About my recommendation.
Yeah.
Yeah, I think it was really enlightening for me and humbling.
It hurt in a way. You had to face some things.
Yeah.
And she explained to you that she was doing that because of what she saw and Deborah's lunch, right?
Yes.
Yeah. And it's difficult sometimes to accept those things about yourself. Right. But you don't think that means you're a bad person, does it?
No.
Everybody has challenges. Right?
Yeah.
That's a good one. The bad part is, and I don't know if Mr. Guerin told you or not, what was it, about a week after or so? Weeks after. Called him to the bench. Here's the bad part sometimes about coming in. I called him to the bench to ask how you were doing. He told me you're okay. Okay. Why do you think I did that?
I'm not really sure.
Yeah, me either. Sean. Here's the thing. And see, this is the bad part that I'm gonna explain to you. And Ms. Valera knows this. You now become one of those for me that I'm going to be watching. Not in a bad way. Not whatever, although if I do see a sign that you're kind of slipping off or not headed in the right direction, we have no problem grabbing you up. And if you don't want to voluntarily tell us how you're doing, we'll make you tell us. All right?
Okay.
So maybe out of all of the bad things and all of the stuff and turmoil that you've been going through, one of the good things is, and a blessing, I think, in a certain way, you got a whole lot more people supporting you. Right?
Absolutely.
You don't have a reason to fail. We're not going to let you fail. Okay?
Okay.
We got to walk that journey together. We'll walk it together. You're going to get to that place that you're destined to be. This is just a bump along the road, and you'll make it. Okay? But let yourself grieve. Let yourself go through that whole process. Let yourself just let it go, because no matter what, you're only human. Real feeling, right? Real emotions. That's who you are. So to let you know, I don't expect anything but the greatest. Because when you first walked in and I first saw you, that's what I saw. Somebody that can be great.
I will be.
There you go. Is your mom always quiet?
Yeah.
Is she?
Yeah.
Mom, did you want to tell me anything? You don't have to. You can come on up. Come on up and be with your daughter. I watched the two of you walk in. What's your name?
My name's LaShannon.
Okay. What do you want to tell me?
I appreciate what you just said to her, that you see something in her, because I think she needs to hear it, because she feels like I'm biased.
That's okay, you are.
Yeah, but I just think like not having her dad here to tell her that is a little bit, you know what I mean? And I don't really have any other male family member who does that. Not that they wouldn't, but like you don't know her, and I appreciate you even saying, Mr. Gary told me you followed up with her, and that says something. And I think that she needs, whether it's you and her therapist being a male, I just think she needs a little bit like someone who's a little bit tougher will call her on her stuff, because she says I'm a softie, I guess. But just thank you for that, because you don't have to do that. You don't have to do that. And that means more to me than anything else, really. So I wasn't expecting for you to say that.
Well, to the extent it's necessary, you're welcome. But I mean it at all. I mean, there's, okay. There, and the young lady, one of the things your mother just said is so true. Because I think I told you the last time I lost my dad when I was 16, right? And I always say my dad when I was 16, but there were 4 of us.
Thank you.
When your mom's talking about just, sometimes we get maybe too caught up in gender and things, but there's something to be said about the way a mom says something to you, the way a dad says something to you, right?
Yeah.
But I had 2 sisters. So when I lost my dad, I had 2 sisters that lost their father. And each of them had to kind of pull through and do that and find those role models, find those people that believed in them. Okay. I don't always ask why my paths cross with whoever it crosses with. I sometimes just thank the good Lord that it has. And so, again, well, this is a bad thing. I'm just thankful that our paths cross.
Me too.
Okay. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Particularly, the alcohol screening assessment identifies the benefit of intensive outpatient counseling, attendance at weekly AA meetings, and abstinence from all intoxicants. Probation, the court will therefore follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. It is therefore the sentence of the court. I will place you on 18-month probationary term. You are to pay $855 fines and court costs, $100 prosecution recovery cost, $100 police agency recovery costs, $540 probation oversight fees. When can you get that paid?
I can, if I can do a payment plan, I can do 1,000 today, the rest on a second.
1,000 today. Let me ask you, is that your money? Because you're 21. Whose money is that?
My mom's.
Your mom's money?
Yeah.
Cool.
I'm getting my associates in human services right now.
What?
I'm getting my associates in human services. I have 4 semesters.
Okay. And are you over at Washington or?
Yes.
So how much more do you have to go?
4 semesters.
Huh?
4 semesters.
To go?
Yes.
Ms. Valera, what were the total fines and costs? Well, let's do it. Somebody help me add. How many classes are you taking?
15.
Thank you. How many classes are you taking?
4.
4? What was your tuition bill?
It is around $3,000.
Pardon?
$3,000.
About 3?
Yes.
All right. You young lady, this is, I guess, the court's investment in your future. How about that? We'll do the 1,000. You make sure to do one thing. You make sure to pay your mom back. I'm going to waive $595 of it. So once the 1,000's paid, you're done. That's because you got that tuition bill. You got to make sure it's paid.
Thank you so much.
There should be no use of alcohol, recreational marijuana, or any illegal substance should be subject to random testing as requested by probation. You are to complete an intensive outpatient program, including all recommended aftercare or status reports to probation. You're to attend 2 A meetings per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. I will continue the scram tether until proof of the IOP IOP enrolled.
Good morning, Your Honor.
All right. 14A District Court for County of Washington, State of Michigan is now in session. All those having business before the court are near. The Honorable Judge Simpsons.
You may be seated. Really? Oh, I have the honor of the chief. Oh, excuse me. No, let me sit up. Go ahead.
Good morning, Your Honor. Victoria Burton Harris, Assistant Prosecutor appearing on behalf of the people. Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. We don't believe such a conflict exists. Makes this waiver and avoidance of being bound.
Thank you very much.
Good morning, Your Honor. Intern Malika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Permission to practice is granted.
Thank you, Your Honor. We do not believe there is any conflict between this honorable court and our office, and if any conflict is to arise, we waive that conflict so that this honorable court can hear these matters.
Thank you. And the court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the cases of the people of the state of Michigan versus Christopher Nutley.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Nunley. Mr. Nunley, will you please state your name for the record?
Christopher Nutley.
Thank you, sir.
Your Honor, we are asking that these matters be set for a preliminary exam.
All right, all discovery is complete.
Yes, Judge.
People have their witnesses available to 12.
That's fine.
All right.
Judge, is that enough time? I'm sorry, for a writ to be done? He is.
He is.
Yeah.
Jackson.
Preliminary examination in person, August 19, 2025, 9 a.m. That is before. Actually, it's at 12 p.m. before me.
Thank you, Judge.
Thank you. Bond will continue. Okay. Let's call the case of the people versus Jacqueline Jones, Washington.
Malika Fatima appearing on behalf of Jacqueline Jones, Washington.
Washington, Jones, can you state your name, please?
Jacqueline Jones, Washington.
Thank you.
Has the court received the report, competency report?
Is this a competency? Yes. All right. I have the report finding that the defendant is not competent to stand trial.
Yes,
Is that
we've
the
sent an
only?
order.
Pardon?
We've sent an order finding her incompetent.
Is there any other evidence?
On behalf of people, Your Honor, the report does says incompetent but likely to gain competency in the statutory.
Say that last part again.
I believe the report references the CFP is seeking time for treatment and they miss Jones, Washington can be restored.
They didn't put that in the front of the report.
At the end of the report.
I'm sorry.
It's at the end of the report.
Yes, okay, I see it. Very last one, I see it. She can be restored in the statutory time frame. All right. You said you sent orders in.
Yes, we have.
I do not have them, but what I will indicate is we'll set a competency hearing on this deal. I need 90.
October 23rd.
Set a review in this matter, October 23rd, 2025, 9 a.m. Bond will continue.
We need to by case only.
Your Honor, if I may,
We need an order on the 2025 case only.
Yeah, because it's separated from the other ones.
Got it.
was there an order sent back in May, I thought? The court doesn't have that?
Which order? Are you talking about the order on the findings? Not the findings, but we need the. Ms. Wilding?
I'm sorry, the 2025 case, there was an issue with the timing of it, so. the
Correct.
2025 case, so that's the one that needs the order.
Okay. So, okay,
Got it.
good, good, okay.
Got it.
So it's the 25 case that needs an order.
Yes.
Okay.
Thank you. Court does call the case. People versus Madden Delaney.
Your Honor, good morning. Joe Simon on behalf of Mr. Delaney.
Madam Delaney?
Go ahead, sir.
Your Honor, I made a proposal to Mr. Banis. Mr. Banis wants to have the opportunity to talk to the officers about the proposal I made. Wasn't able to make that happen by today. So where the parties are requesting an adjournment of the PCC.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. or as your invite indicates, bond continued.
Thank you, Your Honor.
Thank you. Thank you. Court does call the case. People versus Keandre Allen.
Alexander, on behalf of the people, Your Honor.
Robert J. Cole on behalf of Mr. Allen.
Your name, sir?
Keandre Allen. Judge, I saw Keandre last night. He wants to proceed to exam. We have the discovery.
Your Honor, the judge box when it's appropriate.
All right. You said discovery is complete, Mr. Philip.
Yes, Your Honor, 99% of it. We will get the phone calls this week.
People have their witnesses available to 12. Preliminary examination in person will be set August 12th, 2025, 9 a.m.
Judge,
That's before.
I'm sorry, I didn't mean to interrupt, but I have a circuit court trial starting on the 11th. Can we bump it past that?
August 19th, 2025, that's at 9. At 9 a.m. before Judge Moore. As to bond.
My testimony that since you've been arraigned, I haven't had a chance to listen to all the calls. I have 7 calls from, it's one of the calls I know for sure. The victims listed on the report, and even if this is kind of contempt. Judge Washington's court. After arraignment, so this time I would have to just go for the dispute vote.
Any response?
Judge, I spoke to my client last night. Assured me he has not made any calls. I would just ask you to allow him to
That
continue.
he's not made any calls?
Correct, is that correct? Not, pardon me?
Correct. Right.
Not to the victim, Your Honor. There's obviously been phone calls, but not to the victim.
Okay, were phone calls made to the victim's number?
No, Your Honor.
Our numbers restricted.
You're saying they were?
I have phone
They're
calls.
restricted on
Washington's court, and he mentions his hold out of Judge Washington's court.
So do you want me to listen to that? Because if I do, then not only would I revoke his phone privileges, but I will revoke his bond. And I find out
Judge,
what he's telling me not to be the case.
Just cancel the phone calls for now, Judge.
Defendant's phone privileges are hereby revoked, and I've signed that order. Bond in all other respects will continue. Thank you.
Thank you, Judge.
Court does call the case of the people versus Conrad Neary.
Good morning, Your Honor. Victoria Burton here, Assistant Prosecutor of the behalf of the people.
Your Honor, good morning again. Joe Simon on behalf of Mr. Neary. State your name, Conrad.
Conrad Neary.
You don't have to wait. Just step up, half step forward.
All right, go ahead.
We've reached a resolution, Your Honor. You should have both a plea sheet and an executed advice of rights form.
I do. Plea form indicates that the defendant will be pleading to an added count 3 of use of cocaine, 1-year offense. Upon a successful plea to that charge, counts 1 and 2 in this case will be dismissed. He's also agrees to plead guilty under 7411 and continue compliance with his recommended treatment as part of this agreement. Also, there is the prosecutor will recommend no upfront jail so long as continued compliance with recommended treatment while on probation. That's the court's full understanding of the agreement.
That's ours as well, Your Honor. Mr. Neary filled out an advice of rights form. He's ready to answer your inquiries, and I'm pretty sure the matter's remanded to Your Honor, which is why there's no sentencing judge waiver on it.
That is correct.
Thank you.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name.
Conrad Neary.
He's pleading guilty.
Yes.
Is that correct? Okay. Because I have him before. All right. Sir, it is this court's understanding that you are pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay, yes, yes.
You
I
understand that?
understand, I understand.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
To another court. You're not on.
Oh, no, I'm not. No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty?
Yes, Your Honor.
December 9th, 2024, at I-94 near South State Street in Pittsfield Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes.
Had you used it?
It was for your personal use.
Yeah, it was for my personal use.
Okay, and you knew what you had was cocaine, is that correct?
Yes.
All right, sir, I do have to advise you that if between the time of my taking your plea and accepting your plea, you commit misconduct as defined by the Michigan court rules between this time and the time of sentencing, that first of all, you would not be permitted to withdraw your plea. You understand that?
I understand.
And you also understand that the court would no longer be bound by any type of agreement or evaluation.
Yes.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Defense is not.
No.
She was concentrating. And have I complied with the court rule? It would be proper to accept this defendant's plea.
So satisfied.
Yes, Your Honor.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 27th at 12 p.m.
August 27, 2005, 12 noon, before me.
Thank you, Your Honor.
Thank you. Bond continue.
Thank you, Your Honor. Wait with your mom right outside.
Court calls the cases of the people versus Todd Rayberg.
Send in for Jay. Yeah. Oh, man, sorry. Yeah. Easy.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rayburn.
Cloud Burrell with and on behalf of Mr. Rayberg in the case ending in 0891.
Assistant Public Defender Jay Bellinger on all cases not ending in 0891, Your Honor.
Your Honor, so Mr. Rayberg has a number of other matters pending. So at this time, we are asking for an adjournment to allow everything to sort of catch up.
Yes, Your Honor, we have all the orders signed for his cases today. I understand there may be some cases pending, but as of today, we are just waiting on a bed availability for him.
All right, so you're asking for an adjournment also?
An adjournment also, Your Honor.
All right. You're looking for at least 3 weeks? Is that?
Yes, Your Honor.
All right. Probable cause conference in these will be adjourned to August 19th, 2025, 9 a.m. All right, that's a Tuesday, just short of the 3-week time frame.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case of the people versus Seth Priester.
Okay, originally, the people on this and on the case as well.
Good morning, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Seth Priester.
And Judge, not that anyone asked, but I'm the co-defendant's attorney, Mr. Henning. Just in case I'm needed, I'm here. Good morning.
You kind of snuck up there.
I did, yeah. A little shorter today.
How come you didn't do something? No, it was a threat to me.
Definitely a threat.
Do we have this?
We don't have a defender.
Well, what are we doing on Mr. Priester's case? And the other case, I guess we'll bring him out, but
Well, with regards to my case, I think Mr. Priester's case, I think we were ready to set for exam.
We were requesting an examination.
all right. Is everybody going to be ready to go on the 12th?
The 12th is okay. That works with Ms. Barnwell.
One
What
split
day?
second, Judge. One split
Why
second.
does,
I'm trying to.
when this case is called, it takes so long? Not looking at who might be the problem. No. No, it's okay. I guess.
Okay. You said the 12th, one split second. Oh. What do you know? The 12th is available. I'm available on the 12th. Thank you. So happy.
So in the Priester matter, until Mr. Henning gets out here, preliminary examination in this matter will be in person. It will be set August 12th, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. And hold on one more. Who do we have? You have Henning? Court calls the case of the people versus Henning.
And Christina Costantino on behalf of Mr. Henning, if I didn't already put that appearance on. Mr. Henning.
Sir.
Devasseer Henning.
Thank you. All right, and in this matter, your house, you have indicated requesting a preliminary examination, discovery is complete.
Yes, Judge.
People could have their witnesses available on that date. I can set preliminary examination in this matter for August 12th, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. Thank you.
Thank you, Judge. Would the court perhaps hear just a very brief bond argument? I'm just asking for a
Yes,
10%
among 200
provision.
cases I have today. Go ahead. I'd love to hear it. Go
I'm
ahead.
sorry, Judge. We're just asking if the court would at all consider a 10% provision of Mr. Henning's bond. He is obviously unable to post the bond where it's currently set. He has been incarcerated now for about 3 months. He has made the very most of his time incarcerated that he could. He's completed his GED at the Washtenaw County Jail, which is not a small feat by any means. He did that within the quickest time that it's even possible to do that. He very much wants to use his new GED to obtain employment upon release. He has wonderful family support. His family is present in the courtroom. They've been present at all court dates. I know that they'll be present in his life if he is to be released. We would ask if the court would consider a 10% provision in his bond.
Response. What was the weapon?
Firearm.
I'm gonna let what I'm gonna do at this time is I'm not gonna give it 10% provision. I think is, well, that would be 25,000. I presume, Ms. Barnwell, you're also making the.
Yes,
that same-
Judge. Yes, Judge. My client is, he's been very compliant while he's being placed at the juvenile facility in the compound there. His mother wants a tether, and I think that would be appropriate.
His bond is set at $250,000 at your client, Ms. Barnwell. Can I have that file back?
Yeah, that is excessive, Judge. I know that this court is aware of the presumption of innocence. And that it's not just a phrase.
Really? Didn't know. In both of these cases, I'm going to modify their bonds. There is a provision that if they're released, they are to go on tether. That will remain in effect. I will reduce the bond to 250,000. I'll give a 10% privilege on that.
And Judge, my client's bond, I believe, was 100,000. It was originally set at, or maybe it was originally set at 250, but it was at 100,000.
What do you have as bond? Well, what I'll do is if it's 100,000, I'm not going to get the 10% privilege on the 100,000. I'll give it on the 250,000.
Okay, Judge. Yes, we would appreciate that. Thank you.
All right. Thank you.
Thank you.
The court does call the case People versus Sherry Walker.
Yes, Your Honor, please, Your Honor, report Brandon Bird on behalf of Sherry Walker.
Sherry Ann Walker. What are we doing?
I'm just asking, you should have an adjournment.
I did. All right. Probable cause conference in this matter will be adjourned August 14th, 2025, 9 a.m. Bond continued.
Thank you. You and Your Honor, court have a great day.
Court calls case of the People versus Mary Collins.
However, on behalf of Mary Collins, who's back to the podium.
Thank you.
Ms. Collins, please introduce yourself to the court. To the podium.
Good morning. I'm Mary Collins.
Your Honor, so today's a date and time set for probable cause conference. We are working on getting some mitigation documents to the prosecutor that may take a little bit of time, so we're just asking for an adjournment.
You say it may take a little bit of time. What are you talking about?
3 weeks probably would be, you think, could be what we talked about?
August 19th, 2025.
Thank you, Judge.
And bond continue.
We don't know.
Thank you.
Court calls case People versus Oreska Dennis. Back.
I'm back, Judge. Christina Costantino appearing on behalf of Mr. Haruska Dennis, in case number ending in 1150.
Malika Fatima appearing on behalf of Haruska Dennis on the other cases.
All right.
Mr. Haruska Dennis, could you state your name for the court?
Zachary Haruska Dennis, Your Honor.
What are we?
Amy Reiser appearing on behalf of the people.
All right. And what are we doing?
Judge, this is the date and time set for PCC. We would be asking to have this matter set for an exam. I believe that discovery is complete.
The same would be for us. We would like to set this matter for preliminary exam.
People have available to 12. Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Judge.
Cases of the People versus Anthony Alfaro Callejas.
Good morning, Your Honor. Zach Bonham on behalf of the defendant who's joining us by Zoom.
Good morning.
Sir, can you please state your name?
Anthony Alfaro Callejas.
All right. What are we doing today on these?
Your Honor, we're
I also reached out, we have a discovery, technical issue that we're trying to resolve, so I wanted to put down ahead of everything. I believe, we are requesting an adjournment. I did extend an offer, which he has, discussed with his client, and they're still considering that as well.
That is correct, Your Honor. We're waiting on a little bit of discovery left over. We would ask for this to be reset And also, when we're done, I'd like to make an amendment to the bond that you granted at the last hearing.
Probable cause conference, August 14, 2025, 9 a.m. As to bond.
Your Honor, you granted home confinement at the last hearing. My client has went to that location. It is quite a distance from where he's working. He has a friend that lives much closer to where he works. I think it's about 15 minutes away. It's a walk for him. I provided an amended bond order that I sent over to your office, also to the prosecutor's office, so they could see that as well. There's the new address of, I believe it is 4822 Washington Avenue, Unit 15, Ann Arbor, Michigan, 48108. So we just asked that you would amend the bond to allow him to reside at that address for work purposes.
Any objection? All right, I will sign your order on that, counsel.
Thank you, Your Honor.
All right, thank you. Bond will continue in all other respects.
Thank you. Have a nice day.
All right, you too. Hold on now. Court does call the case, People versus Marvin Sullivan.
People.
Mark, Your Honor, Michael Vincent on behalf of Andrew Sullivan. Okay, good morning. Your name, sir?
Mark Sullivan.
All right. Good morning, Mr. Vincent.
Good morning, Your Honor.
You're requesting an adjournment?
Yes.
Oh, somebody's here with you. Good. How much time did you need?
A lot. Just for the court's information, over the night, we received 700 pages of a report. And more to, I believe, we're picking up even more information from this. So my comment would be cooperative with discovery. The court should know that.
I can, the 19th, which is a Tuesday, or the following week, 28th, which any objection from the people?
Okay.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. Bond in this case will continue. Court does call the case of People versus Amar Amadou. Amar Amadou? Who's on this? Shocking, it's canon. Welcome.
Thank you, Your Honor.
No. That was wrong on.
I messed up. Okay. Stephanie Cannon, on behalf of Mr. Amadou, keep your hands out your pocket. Your Honor, Your Honor, I am going to ask for an adjournment, and I will.
Are you?
Yes, yes, a 2-week
Took you
adjournment.
that long to
case.
decide?
I had to discuss something with my client, Your Honor, that's
just
all.
did that now?
Yes.
Okay.
Yes, that's the thing, yes.
How much time did you need?
I'm requesting a 2-week adjournment.
Are you?
Yes, please.
I bet you I don't have a green sheet.
You do not, Your
We're
Honor.
looking all around for one. One's not gonna magically appear. We'll wait. Not long. August
I'll do one, Your
14th,
Honor.
2025, 9 a.m. Bond will continue. That's okay. Mr. Brown was filling one out for you, but
I appreciate it. I'll get it done, Your Honor.
thank you. Hey, they're bringing more? We don't have enough? What? Court calls the case of the People versus Mario Amison.
Alexander, on behalf of the people, Your Honor.
Robert, on behalf of Mr. Amison, is approaching the podium. Amison, please state your name for the record. Mario. So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Freshour. Yes, that's the bond.
Your Honor, it's come to my attention that Mr. Amison has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What, 100 times?
100.
Hold on. Okay.
Let me talk.
So I would be asking that his phone privilege be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amison in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge. it was-
Kidding.
well,
My bad. Go ahead.
Technically, it was, Judge, because it was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond. Or to, I don't know, I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me,
Just-
can I talk,
just-
man?
What do you want to say?
She came to visit me, man. They let her come visit me, so it couldn't have been that serious of a non-contact.
So, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and the.
Say no domestic violence or nothing, man. It's a fraud case.
We got it. It's my understanding that the victim, that the complaining witness has reached out to him several times, and so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. So that at this point we are.
Let me ask this then. Other than those times where the defendant's alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor.
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up when she comes there and.
I got one more thing to say, man. You ain't wording it right, man. Excuse me, can I talk? I know how to talk. You feel me? I got you. She came.
Sure, go ahead.
She came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. She able to visit me if it's a no contact order, and I'm in jail.
That I don't know, and that's why I asked if there were, I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that. Then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
Right. I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir. I don't.
Because they telling you half the story, man.
I'm not gonna get that information right now. I'm not supposed to have that information, right? Anything else, Mr. Anything else, Mr. Burdell?
No, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making now, either from his own pen or from other pens, because that is not allowed and strictly prohibited. The defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination. Thank you.
You fired, man.
What'd you say?
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. I'm gonna pick up the next one and just. This is on your advice, because I got something to say. But I'm not going to. Court calls the case, People versus Nathan Bell.
Assistant Public Defender Council Movesi on behalf of Mr. Bell, but not with Mr. Bell. Nathan Bell? I have no explanation at this time. I had been in contact with him yesterday.
You were?
Yes.
How'd that go?
He wasn't on the bus, but we were gonna be asking for an adjournment, Your Honor. I have no explanation for.
Bench warrant, 10,000 cash surety. The warrant will issue immediately.
Thank you, Your Honor.
Thank you. I feel better. Thank you. Always looking out for me. Court calls the case, People versus Virgil Dunlap.
Corey Burton Harris, Assistant Prosecutor appearing on behalf of the people.
Your Honor, Edward Dukas on behalf of Virgil Dunlap.
All right. Your name?
Roger Dunlap.
Good morning, sir.
Your Honor, there's some outstanding discovery that I'm looking to collect. I'm asking for a few weeks to review everything. There are 2 different matters and search warrants and lots of reports, so I'd be asking for possibly the 28th of next month.
Is he held on anything else?
He is being held. I also have supplied the court with a consent order for a release to treatment and a
I
reduction.
signed that.
Okay. Nothing else is holding him.
Any objection to the 28th? Probable cause conference, August 28th, 2025, 9 a.m. And will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Robert Galett. Yep. Got it.
Asa Bashir for Robert Galett on matter.
Oh, I'm sorry.
Thank you.
Morning, Roger, on behalf of,
Could you state your name, please?
Robert Galett.
Okay.
Judge, I apologize. Ms. Riser, may I approach with our chiefs?
Here now. Both of you are requesting an adjournment.
Yes, Your Honor. We're still working with Avalon, trying to get housing. We have phone calls in the works, Robert.
And we'd request, if it's possible, to have a 1-week adjournment. I believe Mr.
If it's got to be 2 weeks, she's going to cover for me. I have a circuit court trial.
Someone from my office, Mr. Yeah,
What?
there's a trial. Mr. Killawald has a trial in 2 weeks, so it'd be possible that a 1.
Why don't we see what date he's picking, adjourn it?
Probable cause conference, August 14th, 2025.
Go with that.
9 a.m. Bond will continue.
Thank you, Judge, for
Thank
your
you.
understanding.
Court calls case of the People versus Malik Wallace.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Wallace. Mr. Wallace, could you please state your name for the court?
Malik Wallace.
Your Honor, we're asking the court to please set this for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Eduardo Benavides.
Victoria Burton Harris, she's the Assistant Prosecutor appearing on behalf of the people.
No, I'll wait. Eduardo Benavides.
Be conversing with the client on one last matter was coming up.
There was an issue that came up. I'd ask.
There was an issue?
Yes, sir.
That Miss I can really? That-
Yes. It's. No, she's not.
Oh, she's not the issue?
She's not the issue. Never.
Where is she?
Never.
Oh! Your Highness.
Good morning.
They were talking bad about you. I had
Not
you
Mr.
covered.
Brown, though.
Yeah. Oh, no, Mr. Brown was saying the worst stuff. He said you had issues. That's how I heard it.
You shouldn't.
Apparently they didn't finish.
Assistant Public Defender Chinad Really, Your Honor, on behalf of Mr. Benavides. Mr. Benavides, state your name for the record, please.
Eduardo Benavides. Thank you.
Judge, we're asking for an adjournment today.
All right. Will the 14th work for you?
That should be fine.
All right. During the matter, August 14, 2025, 9 a.m. bond continued.
Thank you.
Thank you. Let's call the case of the people versus Brandon Bowman.
That is on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Constable Bates on behalf of Mr. Brandon Bowman, who's present to my right. You state your full name for the record, please.
Brandon Charles Bowman.
Today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
And if I could address bond, Your Honor.
Are you going to address the conditional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right, you want it set for exam
Yes, Your Honor.
and you have the discovery.
To my knowledge, yes.
Would people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fresh Hour. As to bound.
Your Honor, I believe the defendant is in custody on a no contact order of bond violation originally. After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report. Since being put back in for violating the law.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that,
Your Honor, I haven't seen anything about these calls. My client is saying that he's.
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull it up my internet is not.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Rovesi, you can talk to the prosecutor's office regarding that. If they did come from, I'm gonna, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay, so get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up. Real quick now.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are two different pins that are being used, but not close.
And none of the calls were connected?
Correct.
All right. I'm gonna deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing if.
That I would not be sentencing him to the 8 days on it.
Understood.
I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes. I need one for different.
Okay. Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. Once I check your history. Yeah, man, I'm just a figurehead. Clerk calls the case People versus Anthony Miller. The keys in.
Your Honor, Alexis Pluma appearing on behalf of Mr. Miller.
Mr. Miller, can you state your name, please?
Anthony Lavelle Miller.
Thank you.
Your Honor, I am going to ask to address bond first, if you would allow it.
It's gonna have to be brief.
Okay,
Otherwise, you're gonna have to file a written motion, show back up at 4.
okay, understood. Briefly, Mr. Miller's bond was originally set because he failed to appear for a hearing last fall. I do have proof here that Mr. Miller at that time was incarcerated in the Wayne County Jail. He was in from September 2024 to April 2025. I would like you to consider a personal recognizance bond on his behalf because he has a part-time job.
How did he
and
come back into custody?
I believe he was picked up.
So he didn't
from-
walk in after
from-
he left his time in jail?
He was in Wayne County, then taken to Oakland County, then transferred here. So he was released from Wayne County at the end of April of this year, then went to Oakland, and then was transferred here. So he was not out of custody at any point in time.
That's what I'm asking.
Yeah.
Said he was picked up.
Picked up from another jail, is I guess what I
Oh,
meant
okay.
to say. And he would be staying at the Delanis Center if released, but he does have his sisters who live in the area.
Any response from the people?
Your Honor, in the court's discretion, charged with retail fraud, so he's in custody. This isn't his fault. I mean, retail fraud.
What was his previous bond setting?
He had a personal recognizance bond prior to failing to appear last fall.
Why do I have 25,000 cash surety? Well, doesn't matter. I'll grant that motion. I'll set his bond at $25,000 personal recognizance bond previously declared.
Understood. And Your Honor, I do have a green sheet for him. We're just requesting a 2-week adjournment.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continues. Thank you.
Thank you.
Case People versus Robert Carl.
Andrew Childers appearing on behalf.
Your Honor, Alexis Kumar again on behalf of Mr. Carl. Mr. Carl, could you say your full name?
My name is Robert Martin Carl.
I have before me a plea form that the defendant is going to be pleading to guilty to account 2 of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right. May I have him sworn?
Okay.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? So help
I'm
you
sure
God?
I do.
State your name.
Name is Robert Martin Carl.
All right, sir, it is its court's understanding you're going to plead guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost.
I want to be accountable for that, sir. Yes, sir.
What?
I want to be accountable for that, sir. Yes, sir.
Okay, so you understand the maximum penalties in the charge?
Maximum should be a year.
Will be up to a year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir, I do.
All right. And understanding that, do you still wish to plead guilty?
Yes, I do, sir.
All right. You understand also, sir, that I will not, while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Parr in the 14A2 District Court. You understand that, sir?
I never know that, but okay, sir.
All right. Did you want to discuss that further with your attorney?
My attorney,
You're gonna be sentenced in Ypsilanti.
Mhm.
Judge Bar, that's where all your other cases are.
Mhm.
So Judge Simpson's not gonna send you. Come back with me, Ypsilanti.
Or we'll just do it here.
Everything. Yes, sir.
All right. You want to proceed?
Proceed.
All right. So to that charge, how do you plead?
Plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
That is correct, sir.
All right. You signed an advice of rights form. Is that correct?
I did, yes, sir.
Okay. You have any questions regarding any of those rights?
No, I appreciate your consideration and I'm accountable for the thing.
Okay. I need you to look at paragraph 5 on that form. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir, I understand clearly.
You understand you're giving up your right to appeal of right.
That'd be part, yeah, no
You
comment.
understand that?
Yeah, I take that, yes.
All right. Are you on probation or parole?
That's incorrect, sir. It's a hard no, sir.
Okay.
I mean, no.
Okay. Okay. I'll try that again because I want to make sure the record.
No,
is
sir.
clear. Are you on probation at all at this point?
No, sir.
Okay. Are you on parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No promises made that I did not.
All right. Has anybody threatened you or coerced you in any way?
No, sir, they haven't.
You're doing this voluntarily?
This is the,
Okay. You're doing this of your own free will?
Yes, sir, that's correct.
All right. And you're also doing it because you believe that you're guilty of this offense, sir?
I am.
Okay. All right. On the date of March 27, 2024, at the location of 220 Pearl Street, City of Ypsilanti, Washtenaw County, State of Michigan, were you in possession of cocaine?
Yes, but no. No, yes, I was. I just go with that. But yes, I was.
Okay, let's try this again.
Yes, I was, sir.
Okay, let me ask the question. On the date that I just mentioned and at that location,
Yes, sir.
did you have cocaine in your possession?
Yes, sir.
Well, did you?
Yes, sir.
Okay, did you use the cocaine?
Given a chance, I would have.
Okay, so you didn't use it.
I did use it, 'cause I was using cocaine. I had cocaine and I was using it.
So you did use it?
Yeah,
Okay. Did you know what you were using was cocaine?
I was very advanced on that information. Yes, sir. Yes, sir. Keeping it simple.
So, sir, if any of what I just say is incorrect, let me know. On that date and at that location, you had cocaine in your possession, you used it, and you knew it was cocaine. Is all of that correct?
That is all correct.
Thank you. All right. Now, sir, I have to advise you that if between the time of this plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, nor would the judge be bound by any evaluation in this case. You understand that, sir?
Yes, sir, I do. Correct.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have I complied with the court rule and would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be August 13, 2025, 10 a.m. before Judge Barr.
And Your Honor, very briefly, if the court would consider a personal recognizance bond now that Mr. Carl has pled, he does have just recently got his own home in Ypsilanti through a EA housing voucher, and he is concerned about potentially losing that housing if he stays in custody. He does know what he would need to do in order to get out, and this is the only case that's really holding him. He does have other cases out of 14A2 with low nominal bonds set. He could afford to post those, but not the bond on
I'm
it.
gonna leave that choice up to, I'm gonna deny the request at this point. I will leave that to Judge Barr, who will be able to take everything into consideration regarding this gentleman. So your motion for bond reduction is denied at this time.
Understood. Thank you.
Court calls case People versus Jerry Bigham. So it must have been, he must have been at the time.
Andrew Benz.
Austin Lubley, on behalf of the defendant, Your Honor.
Jerry Bigham, don't bang on my podium. What are we doing?
Yes, Your Honor. At this time, my client is wishing to waive his preliminary exam and seek an offer in circuit court.
Sir, is that correct?
Yes.
Do you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed?
Yes.
Thank you, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive the right.
The people who have the right.
Preliminary examination having been waived, defendant bound over to circuit court on both counts. Mr. Belbis.
Your Honor, we acknowledge the information. Thank you. At this time, my client waives formal readings and stands mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pre-trial will be set for
September 18th at 1:30, Judge Slay.
September 18th, 2025, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Sean Dorsey.
Andrew Childers, on behalf of the people.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Dorsey, who's here to my right and beat me here by a mile. State your name for the record.
Dorsey.
Your Honor, this is the first PCC. We are requesting a brief adjournment so that I've had a chance to speak with Mr. Childers so that we can continue to discuss this matter. We're also going to see if we can't work a release to a treatment in this case.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Court does call the case of the People versus Michael Boyce Smith.
Good morning. Thank you, Vice Chair. On behalf of the people. I believe this is.
Yes, it's Miss Ackenrule's case once again.
She was just reviewing the video.
What, she's reviewing what? Video?
The video of it. She couldn't get it open, but ours open.
Oh, was she in with, were you in with your client reviewing video?
I was, Your Honor.
You've had
but
quite a week.
It's, I have, you know.
Yeah, I know.
Yes.
Because all of it's happened in front of me.
We've been
It's
together.
been a
all
mess.
week.
I'm surprised you're still standing.
Hold it together, Judge. Try it. Good afternoon. No, it's still morning. Good
It's still
morning, Your Honor.
Yes, it is.
Assistant Public Defender.
You want me to pass it so you can look at?
No, it's okay, Judge.
Okay.
Yes.
What would you like to do?
We would like to adjourn this matter. The court should be in receipt of a green sheet.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m.
Thank you, Judge.
Thank you. She's had a day. It's only been 2 days, but.
And I had a docket after we left.
What'd you say?
I had a docket after we left till 6:30 yesterday.
Did you? You are my hero. Court calls the case, People versus Robin Finney.
Andrew Childers, on behalf of the people.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Ms. Finney, who is standing to my right. Please state your name for the court.
Yes, Robin Lee Finney.
All right.
And Your Honor, I am hopeful that we will be able. I did send over pretty substantial mitigation, including this newspaper article about all the work my client's done in the community to Mr. Childers. So he is reviewing that, and I think gonna have a conversation with his witness. So we're asking for a brief adjournment.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continued.
Okay, August 14th, we'll be in touch. Good luck. Thank you.
Court calls the case, People versus Savannah Bradley.
Corey Burke, prosecutor of your own.
And Lori Yagi, Assistant Public Defender, with and on behalf of Ms. Bradley, who's approaching. In terms of the substance, the PCC, Your Honor, we're requesting an adjournment. Ms. Bradley is very eager to get into treatment. We have spoken, unfortunately, she works a lot, so we played some phone tag. I do want to address the bond issue.
So do I.
Yes. So initially, when I first spoke with her, she indicated that she was not aware that it was such a tight time frame within 24 hours of her release, that she was expected to do an intake. She followed up with them, and she did make contact with them, scheduled an appointment. Unfortunately, she didn't realize it was the same time as a psychiatric appointment she had. So she went to her psychiatric appointment, and then she was basically calling them and calling me, waiting for them to call her back. There was a misunderstanding there. I think it was 2 days ago or yesterday, I told her, just go, don't even wait for them to call you, just go. And she was at work and she wasn't able to get there before they closed. So I did tell her first thing this morning to go, but by the time they opened, she was already here. And so we are asking for the opportunity for her to go test today, or for her to check herself in.
But after that point in time, she had no further contact with them.
So she is saying that she did call them repeatedly after the 23rd. I know that's not in their report, but that is what she is saying, is she called them and she left.
Very clearly says she failed to report for her intake appointment as ordered. No further contact has been made.
I understand that's what they say. She's saying she tried to call them. Her dad is with her in court today.
So, and when she tried to call them, what'd they say to her?
She left a message, I think.
And nobody called her back?
That's what she's saying.
Really?
I just want to make two other points. So first, she is a working mom. She is a 9-year-old. I believe she's sole care 9-year-old, right?
If she went over, would she test clean?
I don't know. I think so. I mean, based on my conversations with her, I will also
I
say,
think it's like a clearest question one can ask.
okay, she's saying she would test clean. And she's saying she is prescribed Adderall, and that's what she would test for.
And that's the only thing that's gonna show up?
Should, yeah.
Will or should?
Will,
That's it.
yes.
I tell you what I'm gonna do, I'm gonna give you a shot. She needs to go over right now to community corrections, do her intake, take her test, and if you could let them know she's on her way over. If anything, tell them also that if anything comes, you need to come back over here, but if they get the test before you get back over here and something else shows up, take her into custody.
Understood. She is prescribed the medication, like I said, but
I heard.
understood, Your Honor.
Get over to community corrections, I'll pass the matter. Court calls case, People versus Matthew Fonseca.
People.
Good morning, Your Honor. Public Defender Carson Lubez on behalf of Ms. Fonseca, who's present to my right. Can you state your full name for the record, please, Matthew?
Matthew Fonseca.
Thank you.
Your Honor, today is the date and time set for probable cause conference. At this time, we're respectfully requesting to step for exam on both matters.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available the 12th. Preliminary examination, August 12th, 2025, in person, before Judge Valvo in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case, People versus John Altcott. Yes.
Stephanie Kane on behalf of Mr. Occult, who's appearing by Zoom. Mr. Occult, could you please state your name for the record?
John Paul Alcoa.
Your Honor, at this time, we are asking that this be set for a preliminary exam.
Discovery is complete.
To my knowledge, yes.
And would the people have their witnesses available to 12? Pardon?
That's fine.
All right. Preliminary examination in person, August 12th, 2025. 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Continue. Thank you.
Thank you.
Court does call the case of the People versus Nathan Gubachi.
Requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Ron Brown.
But you thought you had to be right next to her, not in the room?
Where you want me to leave?
Yeah. No, it's always a pleasure seeing you, Mr. Brown.
My pleasure, sir.
All right, so you just stay right there. All right, that makes me happy. All right, what are we doing on this case? Permission to practice it.
Thank you, Your Honor. We're requesting to adjourn this matter awaiting medical records for our office to receive his medical records.
His medical.
Yes, Your Honor.
I mean, I could put it out 2 weeks since he's in custody, but I don't, how fast are they?
May we approach? Prosecute.
Yeah, come on. Came up, that was what it's gonna end up being. Oh, what'd you say? I got it. Should reflect the kind of frequent content.
May I address bond, Your Honor?
Yes, you may. Let me, go ahead.
I
I was
think,
gonna put it out to August 19th. You're
Thank you.
Seeking medical records. Go ahead.
Your Honor, my client is currently housed at the jail with no bond. In October, he had some medical issues and he has serious medical condition. I'd ask the court to consider at least 250,000, 10% bond so that he can address his medical needs.
Any response from the people?
He would ask the bond remain, that's good.
The magistrate set the bond and denied bond in conformity with the Michigan court rules. I don't find at this point, at least based upon the information for the court, that this court could determine that to be an abuse of discretion. Most where bond reduction is denied, bond will continue as denied.
Thank you. See you on the 19th.
August 19, 2025, this bond will continue. Got it. Court calls the case People versus Jacob Halfacre.
A.P.A. Rachel McDuffie for the people.
Good afternoon, excuse me, good morning, Your Honor. I'm appearing on behalf of Mr. Halfacre.
All right, our understanding is Mr. Halfacre is refusing to be seen.
That is the people's understanding, not only for today's hearing, but for his review with the CFP.
My information, he claims he has a presidential pardon. I did not know.
What?
A presidential pardon. I did
did he
not
get
know
one?
he was a politician. Sorry about that.
Okay. All right, so what do you want me to do? Adjourn this?
Well,
I can't really do much if he's not here.
yeah, December 5th, you referred to a competency hearing.
I did.
January 10th, he was found not competent but able to regain competency. January 30th, competency hearing, a 90-day review set. April 11th, 90-day review report, still not competent. May 1st, competency hearing set, 90-day review due to competency update. July 3rd, competency hearing adjourned to allow 90-day review. And July 14th, update from Forensic Center, no update, defendant refused to speak. I'm asking, he has grandparents who are interested in his well-being. I'm asking for some type of bond so he can get out of jail. He's been in there for months. It's a aggravated stalking charge of 5-year felony. But he's been in there for months now. So I'm asking for some type of bond that can be worked out.
Well, I don't really need a response because I might consider a bond if he were cooperative in the process, but I mean, I can understand, his grandparents. Certainly they're concerned, but if he's not cooperative with this process while in custody, I'm not clear how that's gonna happen if he's out of custody and we can't do anything.
I will contact the grandparents, see if some inroad can be made there.
All right. So what I will do is, I'll have to, I mean, do they need a new order to see him? Do we know?
I can check one moment. Don't think so. I recall reading that they felt like, in their opinion, he remained incompetent until they learned that he first.
Got it. Well, right, his status would remain as it was on the original finding, so. Well, let's do this. I'll adjourn the competency review hearing. It's my last date in September, because he's got to see somebody and then a report. I'll set the review date to September 25th, 2025, 9 a.m. If we get a report before then, certainly we can move that date up.
Thank you.
Okay, thank you. It might say he was giving me a party. Court calls the case of People versus Jordan Hartmeyer.
Assistant Public Defender Natalie Pate with him and on behalf of Mr. Jordan Hartmeyer. Please state name for the record, sir.
My name is Jordan Hartmeyer.
Thank you, Your Honor. To my understanding, discovery is complete and I have reviewed and discussed that with my client. At this time, he is wishing to set this case for preliminary examination.
Would people have their witnesses available to 12? Preliminary examination in person will be set August 12, 2025, 9 a.m. before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Okay. Court does call the case of the People versus Deontay Clifton.
Edward Dukas on behalf of Deontay Clifton.
Mr. Clifton, can you unmute and state, oh, there you go. Can you state your name, sir?
Deontay Clifton.
Thank you.
Thank you, Your Honor. There's some outstanding video that I'm looking to obtain. I'm asking for an adjournment. I am also now on the approved list, so I can speak with him up in the Newberry facility.
Okay.
I have court with him next week, so certainly I will have contact with him by then, but it's been about 2 weeks since I've been able to have contact with them, so.
All right, you want the 19th then?
I'd prefer if we could go.
I can do the 14th, but that means, are you going to be able to get everything you just said done?
I don't think by then. I'd prefer you had said which date?
Well, I can do the 19th or I can do the 28th.
I'd ask for the 28th.
28th. Any objection from the people?
Objection.
Probable cause conference, August 28th, 2025, 9 a.m. Bond will continue.
Thank you, Ron.
Okay, thank you. Thank you, Mr. Clifton.
You can give me a call. I'm on your approved list now.
Court calls case, People versus Robert Jameson.
Asli Bashir on behalf of Robert Jameson is approaching. And
Your name, sir?
Robert John Jameson II.
Thank you.
Your Honor, we're requesting the earliest available preliminary exam date,
All discovery is complete.
to our knowledge.
People have their witnesses available to 12. Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Freshour. Bond will continue.
Your Honor.
Thank you. Court calls the case of the people versus Lester Braggs, is it?
Michael Gaddy, assistant public defender for Mr. Braggs. I believe he's on Zoom, Judge.
Mr. Bragg, there he is. Can you unmute and state your name, please?
Lester Braggs.
Thank you.
Your Honor, we're asking for a brief adjournment in this matter. I believe we have it resolved. It's a matter of posting some restitution. I'd ask the court for 2 weeks to accomplish that.
2 weeks, he'll be able to do that.
Yes, he'll be able to post it in 2 weeks.
Exactly. Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
I'll be in touch, Mr. Braggs.
Okay.
Thank you. Court does call the case People versus Chad Jones, all 4 of his cases.
And Laura Yagi, Assistant Public Defender with and on behalf of Mr. Jones, state your name for the court.
Chad Jones.
And Your Honor should have a STIP and proposed order to release to treatment in his 4th case, which is the newest one. It's the first PCC for that case, even though it predated his arrest. He's been in custody for the past several
In
months.
his
But
4th case, which number on that?
the number is apologies, Your Honor. It is the 25F55162.
Okay, I do see, and I'll sign off on that. That I don't have a problem with. All right. And then you want this, you're seeking an adjournment of these proceedings?
Yes, Your Honor.
How much time? I mean,
I think, I mean, he's going to court in Canton in just a few minutes to ask to be released to treatment on that hold. So hopefully a couple weeks, but I
can do the 14th or 19th.
I guess the 14th. Thank you.
You're welcome. August 14th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Calls the case of the People versus Dominic Brewer.
Andrew Bannister. Assistant Public Defender Jay Bellinger on behalf of Mr. Brewer, who approaches. Mr. Brewer, can you please state your name for the record?
Dominic Brewer.
And Your Honor, I just got good contact information from my client who was recently released from a different county, so I'm just asking for some time.
Probable cause conference, August 14th, 2000. Well, why don't we do August 19th, a Tuesday?
Thank you, Your Honor.
2025, 9 a.m. Bond continue.
Thank you, Your Honor.
You, sir. Court does call the cases of the People versus Vincent Lambert. No, wait. No, go ahead. I'm sorry.
Like Fatima appearing on behalf of Vincent Lambert.
Your name, sir?
Vincent Lambert.
Thank you.
Your Honor, at this time, we are requesting for adjournment. We are awaiting discovery for 2 of the cases.
All right.
All right. I'm okay with bonding over at Funky right now. Okay. I'm just trying to speed it all up.
Mass, yeah. Your Honor, we would like to address bond when appropriate.
Briefly, I will probable cause conference in these cases will be adjourned to August 14th, 2025, 9 a.m. All right, Esteban.
So we'd like to modify the bond to reflect a similar bond by Judge Kunke, in circuit court.
What?
Like to modify the bond to reflect a similar bond, to what Judge Kunke has ordered in circuit court for treatment.
Okay, so I'm supposed to guess on that, or what was it?
And Judge County courtroom is allowed to be released to treatment. He's on probation in those cases. And there's-
So he can be released on a PR to treatment?
Yes, Your Honor. The people wouldn't have an objection to his release to treatment if there was a tether. We do have some concerns. Mr. Lambert does have multiple cases in front of this court. Defense counsel and I have been emailing back and forth, and I think there's some more coming. But
More what coming? Cases?
Yes.
Oh, boy. So, do you have an objection if he's on a tether? Don't ask Brown. Do you have an objection
No,
if
we
he's
don't
on
have
a
an
tether?
objection. No.
Don't? Okay, so I don't have any objection to release to treatment for anybody. You guys just include the tether language in, and somebody will sign it. I mean, I'll sign it.
I have a question.
Sure.
When being released with tether, they require for you to have a phone. Is that going to be a requirement for treatment as well, even though I'm being released to treatment? Because you can't have a phone in treatment, but I don't have a
Correct.
working phone.
And that may be, so let me put it this way. If you have the tether and you guys can work it out, I'll sign the order either way. But that may limit his options of treatment.
No, I'm saying that I don't have a working phone in my property, and tether, the last time I was released, required for you to have a phone before you can.
Correct.
Okay.
And so that's gonna cause a problem for you. But somebody may be able to solve that problem. The other problem that is caused is some facilities do not allow the tether and then do not allow the phone, which you would have to operate. Everybody got that? Okay, so he can be released to treatment on a PR. And I'll sign that order. I don't have a problem with that. And so his bond will continue with that modification, so, okay?
Okay, thank you, Your Honor.
Court calls the case People versus Anna Bowman. He's what?
Your Honor, Alexis Plumey appearing on behalf of Mr. Bowman.
Mr. Bowman, can you state your name, please, sir? Yeah, Mr. Bowman, can you state your name?
Need to talk to my lawyer.
Pardon?
Need to talk to my lawyer.
Mr.
He
Bowman,
apparently want to state his name or follow the orders of the court. Go ahead.
I didn't hear you. I'm sorry. I didn't hear you. Dr. Adam Baldwin.
thank you. And Your Honor, I do have a green sheet here. We are requesting just a brief adjournment, and Mr. Bowman would also like me to address his bond if you would allow
Well, he
it.
started out on the right foot for that, but go ahead. Take it your best shot.
Understood. Mr. Bowman is currently being held on a $50,000 bond on this case. This is the only case that is holding him currently. He is asking the court to consider a personal recognizance bond. He doesn't have a history of failing to appear for court. He does attend all of his hearings. And primarily, his request is because he's currently enrolled in school at Wayne Community College, and is worried that he is going to default on his loans if he remains in custody, and also worried that he wouldn't be able to get another loan in the future because of this. He would stay away from the University of Michigan Hospital as well, which is where he was seeking psychiatric treatment when this incident occurred.
Response.
The people would request a bond remain as currently set on defendants on the sex offender registry to expose himself to staff at the hospital. There's in a lot of very explicit threats to staff, including threats of sexual assault, violence against them. Very well maybe related to mental health issues. Those are clearly not currently in checks.
Anything else? Ms. Fuller?
No, Your Honor, thank
Motion for bond reduction is denied. Bond will continue.
you.
Thank you.
Your Honor, what was the next court date?
14th. Trick question. Yes, 14. Case of the People versus Alicia Cargill.
Children's appearing on behalf of the people.
On the splits, she's listed as a PD compact, but I don't know what the Hightower Brown's office.
So I don't have,
So the PD is the attorney of record currently.
because I don't have
So
it.
Lauren Brown, Deputy Chief Public Defender. I believe that we determined that this is a conflict for our office.
Ms. Cargill?
Yes.
Okay. Hang on one second, but I don't have an order nor an attorney for Ms. Cargill.
We've sent it out. I think Mac is probably working on appointing someone. Do you want us, you want me to send someone down there and have? them-
Yeah, but well, we don't have.
I've spoken to Hightower Brown. I don't believe she has what she.
coded.
No, it is a conflict.
She went, she's okay, so she's a co-defendant in a case where we already represent with Anitra Kuma.
Right, but I get it, but I have no paperwork.
Okay. So
do that. The co-defendant's case is set for what time? 12:30 this afternoon, but I can't do that with.
Right. Do you want us
Do
to?
you have any, do you know what you're gonna be doing on the co-defendant case at this point? What?
I believe she's entering a plea.
Okay, so it may not matter what I do here. All right. Ms. Cargill, here's what I'm gonna do. Okay, right now, there's a conflict with the public defender's office. I don't know if you were overhearing that conversation.
Yes.
Okay, so I usually get an order down with a new attorney appointed, so I can tell you who that is. I don't have that. So what I'm gonna do is I'm gonna adjourn your case out 2 weeks, because even if I had an attorney, they're gonna need to talk to you. So I'm gonna adjourn your case out 2 weeks, which is the fastest that I can do it. We'll get that order down today, signed, and there'll be an attorney that will contact you, okay?
Okay.
All right, very good. So probable cause conference will be adjourned to August 14th, 2025. 9 a.m. Bond will continue. All right, thank you, Ms. Cargill. Court does call the case, People versus Nicole McCauley.
Hi, viewers, the people.
Asli Bashir for Nicole McCauley.
Nicole McCauley.
Thank you.
Thank you. And Your Honor, we have a green sheet.
All right.
We're requesting a brief adjournment just to confirm some information for further negotiations.
August 14th, 2025, 9 a.m. Bond will continue.
Thank you.
Court calls case of the People versus Xavier Briggs Sumner.
Asli Bashir on behalf of Xavier Briggs Sumner.
Xavier Briggs Sumner.
And Your Honor, we are requesting an adjournment to review discovery in this matter, media discovery that we did.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continued. Court calls case of the People versus Ervima Magbury.
Children's appearing on behalf of the people.
Oh, Jerry.
Assistant Public Defender Chinazi Carey Akinruli on behalf of Mr. Averma Magbury. Mr. Magbury, state your name for the record, please.
Thank you. I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of cocaine count. Upon his acceptance of that charge, count one would be dismissed. Prosecutor will recommend and have no objection to the sentence. The defendant is currently under VOP sentence by Judge Conlon and will be in the Washington County Jail until November.
That is correct, Your Honor.
All right. He has signed off on this. Did you mean to check the sentencing judge waiver box?
I did mean to check that.
Pardon?
Is it checked?
No.
Yeah,
That's why I asked.
I intended to check it.
Did you?
I
Okay,
did.
then I'll do that for you.
I appreciate that so much,
All right.
Judge.
May I have him sworn?
Ryan, you solemnly swear the testimony about the guilt to be the truth and all. So you got.
I do. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced in the 15th District Court before Judge Valvo. You understand that?
Yes.
All right. Now, understanding all of that, you still wish to plead guilty? Yes? And to that charge, how do you plead?
I didn't hear you.
To that charge, how do you plead? Guilty, not guilty?
Just kill
Guilty? Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights? Please look at paragraph 5. Those are your rights. You'll see a copy there on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you? You're doing this voluntarily
Yes.
of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
June 23rd, 2023, at the location of 900 South Maple, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes.
Did you use it?
Yes.
Did you know what you were using was cocaine? Finally. All right. Sir, I do have to advise you that if I accept your plea and between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, that you would not be allowed to withdraw your plea, and any sentence or recommendation or evaluation by the court would no longer be bound by. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements
No, Your Honor.
that have cost? You want to let me finish? You want to go ahead? That was your way of sort of preemptively saying that you're not aware of anything else.
We are not
All
aware
right.
of any today.
Are the people aware of any threats, promises, inducements that have led to this plea?
The people are not.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
And defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be August 26, 2025, 9 a.m. before Judge Valvo. Bond will continue. Thank you.
Thank you, Judge.
She said that so nice. It's not like Ann. He's on June, Judge. Court calls the case versus Anthony Turner. I'm gonna let her know.
Maybe Richard McDuffie people.
Stephanie Cannon, on behalf of Mr. Turner.
It's all just a surprise sometimes.
I couldn't hear you.
Yeah, it's okay. No, I'm just.
I couldn't hear you.
Mr. Turner, can you state your name, please?
Anthony Turner.
Thank you, sir.
And Your Honor, we have actually reached a plea in this matter. However, they didn't bring my client over, so I couldn't get him to sign the plea form. Your Honor, if it's okay with the court and okay with my client, I'd ask that I be allowed to sign it with his permission.
I had a pen.
No, I'm not gonna do that. The plea form
Yes, Your
and
Honor.
everything.
It's all right here, Your
Has
Honor.
he read it?
We discussed it last week, but
Did you go through it in detail with him?
I could not, Your Honor. They did not bring my client, so no, Your Honor.
Well, where is he?
He is currently,
He's downstairs.
yeah, he's downstairs. I can go downstairs if you want to call it maybe later today. Is that okay?
Oh, no, that's not happening.
Oh, well, there's that.
There's,
So there's that. There's that. Your Honor, I went to the jail to see him prior to getting the plea form.
I know,
So I'm
I
sorry.
get it.
Okay.
I get it. And you weren't able to get that and go through all of his rights and go through everything with him. I
That's-
prefer that you do that. I will, although I don't want to, I will give you just a 1 week adjournment. Is he
Perfect.
held on anything else?
Nope, Your Honor, it's just this. He's going to
He's
mental
just on
health.
this one?
Yeah, he's going to mental health court. He's already been, it's all right here.
It's all been, okay, so let me do this. Let me kick it out 1 week.
No, it's not. Pay attention.
Thank you, Your Honor. What's the date you're adjourning it up to?
2025.
You see, he wouldn't let me borrow his pen. I was
What?
like, you see how he wouldn't let me use his pen?
You didn't bring your own?
You know what, Your Honor?
Bond will continue. All right, thank you. Thank you, Mr. Turner. She'll be down to see you and go through those forms with you, okay?
Yeah.
All right, thank you, sir. Court calls the case, People versus Lawrence Buckner. I don't know why you thought you were gonna get support here for this.
Alexander, on behalf of the people, Your Honor.
Yeah, it's just a public defender for Buckner who's in the courtroom, Your Honor, making his way to the podium.
Oh, there.
And if you're ready.
Lawrence of the family of Buckner.
Your Honor, we'd like to set this matter for a preliminary examination.
Discovery is complete.
To the best of my knowledge, Judge.
Here, thank you. People have their witnesses available on the 12th. Preliminary examination in person, thank you. Will be August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue, and I might suggest that before his preliminary examination, that he's properly attired or appear before Judge Valvo. Thank you.
Yes, Your Honor, thank you.
Thank you, Your Honor.
Court does call the case.
Here.
People, Brenton Morrison.
Andrew Childers, appearing on behalf of the people.
Really? Can she stay in the courtroom or no? She's coming.
Assistant Public Defender, Chinazi Carey, I can rule, Your Honor, on behalf of Mr. Britton. Mr. Britton, state your name for the record.
My name is Britton Morrison, sir.
Thank you.
Mr. Morrison.
Mr. Morrison. Britton Morrison.
Yeah, it's okay. It's okay. You would have known that had you been in court.
You are
But that's okay.
right. Judge, we're requesting an adjournment. We're in negotiations with the people. The people would like to know a little bit more about my client, so I want to get some mitigation information together for him.
For the 14th, be enough time for you to do that?
I think that's fair.
August 14th, 2025. 9 a.m. Court calls case People versus Dorian Bulow.
And Assistant Public Defender Jay Ballinger on behalf of Mr. Bulow, who approaches, Your Honor. State your name for the record.
Dorian Bulow.
And Your Honor, my client has been tendered an offer. The offer is contingent upon him paying significant restitution. I'd be asking for 3 weeks at this time.
Pardon?
I'd be asking for 3 weeks at this time.
Okay, so I have like 2.5 weeks or 4.
Okay, I think
So-
if, I would prefer for,
That-
thank you.
Any objection from the people in that regard? Probable cause conference then will be adjourned August 28th, 2025, 9 a.m. Bond continue.
August 28th, let's say then, okay? We'll talk.
Okay, thank you. Court calls case People versus Melvin Morrow.
If we were to have people.
Or yeah, the Assistant Public Defender with and on behalf of Mr. Morrow, who is approaching. Mr. Morrow, can you say your name for the court, please?
Melvin Morrow Jr. Thank you, sir.
And Your Honor, I apologize. This one I didn't submit before the docket started. In terms of the substance, the PCC, we are requesting an adjournment. I just emailed Ms. McDuffie this morning about a piece of discovery that I think would be relevant. I would ask to address bond if possible.
August 14th, 2025, 9 a.m. Briefly, go ahead.
Yes, Your Honor. So Mr. Morrow is here because he missed court just last week. I believe it was just last week that he missed court. He was unfortunately not aware of his court date. He said he was released from the jail without papers and he doesn't have a working phone, but he gave us his case manager's phone number. He's going through an eviction right now. And so things have been really tough. I did talk with him and have a very serious conversation that if he needs to check in with the court every single day, he will do so he doesn't miss another court date. I believe this is the only case that's holding him right now. Is it? That's what XGL is showing. Yes, it's just showing this case. When I met with him last night, he indicated he's willing to have on a tether to alleviate flight risk concerns. GPS tracking tether. He's
Are we
really
sure it's his only case? Only because the bond initially was set at a nominal amount, which leads me to believe that he had something else.
So he does have a case pending before Judge Kunke, but it should be a personal bond. And so XJail is showing this as the only case that's holding him in jail.
Well, does anybody know what the bond is before Judge Kunke?
I'm looking right now, Your Honor. My last recollection was that, and let me just confirm this real quick, because I don't know. Yeah, Your Honor, there was a bench warrant issued in that court too. However, he was told that he could do a walk-in on the warrant at any time before Judge Kunke.
Has he done that?
It was for a failure here. He has not been able to do so yet because I was able to get a hold of him, so.
So how did he come back into custody?
I believe, he said he was getting off the bus in Ypsilanti, heard the officer calling his name, or I'm sorry, Ann Arbor. So the officer knew him. So I don't think there's any new allegation of criminal
But he didn't turn himself in.
activity. That's correct. Your Honor.
And he didn't appear before Judge Kunke.
So that's correct. My information from him was that he was in the hospital. And so he's had some health issues going on. He's had a lot of family members pass away recently and he's been evicted, going through that process. So he's had a lot that he's been juggling. But
At this time, I'm going to deny your request and then you can certainly bring it back before the court once Judge Kunke rules on his and he gets before her.
Understood, Your Honor.
Take another look at it.
Okay.
Bond will continue. Thank you. Calls case People versus Kevin Burden.
Assistant Public Defender Jay Bellinger on behalf of Mr. Burden. Mr. Burden, can you please state your name for the record? Kevin Burden, sir. And Your Honor.
Waiting response for the mitigation packet.
That is correct, Your Honor. We're still working on that. I think 2 weeks would be sufficient if that works with the court.
Probable cause conference August 14th, 2025, 9 a.m. Bond continue.
Thank you. Thank you.
I just let you know that. I'm just pointing out facts. Court calls the case People versus Stefan Wainwright.
Oh, it's unmuted. Hey, Your Honor, before my attorney speaks, I want to change something. Because
Want to do what?
I want to change something. So I signed yesterday to have my preliminary exam waived, which I don't want. We actually spoke about an insanity plea thing, and I wanted to move forward with that because I am insane and I was looking to get help.
Hey, well, hey, all right, Judge. Go ahead, wait. All right, thank you, Mr. Wainwright. Yeah, go ahead.
Student Attorney Kara Rosencrantz requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Mr. Wainwright.
That is the first time you've done it reluctantly. But permission to practice is granted.
Thank you, Your Honor. I suppose we'll be requesting an adjournment in this matter.
All right, Mr. Wainwright, here's what I'm gonna do, because obviously you did something with your attorneys before, and I thank you for pointing that out. I'm gonna adjourn your case out so they can talk with you a little bit more about what exactly is going on right now, okay?
Thank you.
You're welcome.
Thank you, Judge.
Probable cause conference, August 14th. Will that be enough time, or you want the 19th?
14.
Whatever's. Oh, he says 14.
Okay. But given what he said, is that who I should be listening to? Never mind, don't answer. August 14th, 2025, 9 a.m. Bond will continue. Thank you, sir.
Thank you. Have a good day.
No, Miss Cannon, you should make that admission sometime. Court calls the case, People versus Brian Gerard, excuse me.
Andrew Childers appearing on behalf of the people.
What? They're not at the door. He's in custody. All right, let's go to this next one. Court does call the case of the People versus Maurice Burgeons.
Victoria Burke Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
And Laura Yagi, Assistant Public Defender, with and on behalf, hopefully of Mr. Bergens. Mr. Bergens, can you unmute yourself and state your name for the court?
You have to be here first, right?
Yes, I was talking with his partner, who I had thought was logged onto Zoom earlier. I would ask if the court would consider briefly passing so I could give him a call. Or waiting until the end of the day to issue the warrant. Please, Your Honor.
Bench warrant will issue 10,000.
Your Honor.
Just listen.
Okay.
No, go ahead. You now interrupted.
No, I'm sorry.
No, go ahead.
I was just gonna ask if I'm able to get in
This
contact.
bishop
with
was
him.
appalled. Go ahead.
If I'm able to get in contact with him, and I have an explanation for what's happening by the end of the day, would the court consider recalling the warrant?
Yeah, but I didn't finish, so I was gonna do that. But Ms. Yagi, man, thought I might do something really good.
How you like your stickers?
I do. I put the sticker on already. Thank you, ma'am. Did I get to the bench warrant part before she interrupted me?
I will be honest, I
Oh,
don't know.
don't know. I'll start over. Bench warrant will issue for defendant's failure to appear by the amount of 10,000 cash surety. Ms. Yagi, that warrant will not issue until Monday, the 4th.
Thank
So
you.
now you have nothing to say, right? All right.
Now I say thank you. Thank you, Your Honor.
Court calls the case of the People versus Brian Gerard, 2 cases.
Andrew Childers appearing on behalf of the people.
I'd like to talk about appearing with and on behalf of Brian George. Please say your name for the record.
Brian George.
At this time, we are waiving to circuit court for global resolution.
So he's waiving on both of these cases.
Yes.
All right, sir, is that correct?
But, yeah, yes.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
So I'm doing right now is waving. Yeah. I didn't know any of that. Yes.
All right. You understand you will not have that hearing on either one of these cases and that you'll proceed to circuit court for further resolution.
Yes.
And that's what you want to do, sir?
That's what I got suckered into yesterday. Yep.
Okay. People also waive their right on these cases.
Yes, sir.
Preliminary examination having been waived in both cases, defendants bound over on the single count, each one.
Yeah, we got civil prison.
Counsel, you acknowledge receipt of the information waiver to reading? Or not? You're not listening. Go ahead.
We acknowledge the receipt of the information and we waive its formal reading, and the client will stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. A pretrial in this matter will be set for
August 11th at 1:30 with Judge Simpson.
August 11th, 2025, 1:30 before Judge Hamud.
I'll be there.
Yeah. We'll provide the transportation. Bond will continue. All right, sir, thank you.
Thank you, Your Honor.
This one, just like this one. They need to go down, so then they can sign off on it. So just do that other one, hand those to Alan, so you take over. Court does call the case, people of the state of Michigan versus Michelle Campbell.
Thank you, Rich. May the court people.
And Assistant Public Defender Jay Bellinger, on behalf of, but not with Michelle Campbell, Your Honor, I made several attempts to get a hold of her. I know, in talking with Ms. McDuffie, we were planning on adjourning this matter. I would ask for that. I understand she had some health problems last time she was here, so my concern is for that at this time.
That she had what?
She had some health issues last time she was here. So I'm concerned about her well-being at this point. I have not been able to get a hold of her.
Are you rooting for him? People have any objection to an adjournment?
No, thanks, sir.
Really? Finally, the first case, you're gonna be cooperative. Never mind.
If you-
Never mind, never mind.
I have some available.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m.
Thank you, Your Honor.
Bellinger, if she doesn't show, I'm taking you.
Yes, sir.
All right.
Thank you. I know you have a whole arsenal, so.
I sure do.
Court calls the case, people versus, is it Ibid Timmy Abuzulu?
Alexander, on behalf of the people, Your Honor.
And Stephanie Cannon on behalf of Mr. Abguzulu, who is to my right. Could you please state your name?
Ditimi Alexander Ogunzulu.
Okay, what are we doing?
Your Honor, we're just asking that this be set for a preliminary exam.
Discovery is complete.
Yes, Your Honor.
Terrible stuff. People have their witnesses available under 12. Preliminary examination, August 12th, 2025, 9 a.m. before Judge Freshour.
Your Honor, my client is wanting to know whether or not the court would kindly allow him to have his calling privileges back. He understands that he should not have made any calls. He will not be doing so in the future, turning the complaining witness.
Your Honor, I would object at this point, given the nature of the calls and why his phone privileges were revoked. I would ask this to be something that could be addressed at exam, given that he was trying to have third parties reach out to the victim. So I would ask that that his privileges stay revoked at this time.
Anything else?
Nothing, Your Honor. Thank you.
All right, I will deny the defendant's request for modified bond. Phone privileges will remain to vote. So Case people versus Kimani Hamilton.
Okay, Richard McDonough for the people.
Good morning, Rob Dickel on behalf of Mr. Hamilton. Monty, can you state your name for the record?
Monty Hamilton.
Judge, I've had a chance to speak with him. We set an exam in this matter, Your Honor.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 12.
Judge, I have a trial that day. We make it the week after.
Oh, that's right. So the 19th.
That's possible.
Preliminary examination, August 19th, 2025, 9 a.m. It's in person before. It's actually will be at noon, 12 noon, and that's before me.
All right, thank you, Judge. Monty, I'll come and see you.
Bond continue. Thank you, sir. Court does call the case of the people versus Stefani Cash.
And Public Defender Natalie Pate with and on behalf of Ms. Cash, who is present via Zoom. Ma'am, can you please unmute and state your name for the court?
Cash, you have to unmute.
Tiffany Cash.
All right.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I am respectfully requesting an adjournment. I did discuss this matter both with my client and the people. We believe we're missing some photos from discovery, so we are asking for an adjournment to get those.
August 14th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you, Ms. Cash. That's for today.
Thank you.
Case people versus Abdel Osmond. Okay.
Only again, Your Honor, Constable based on behalf of Ms. Rabbi Mohsen Osman, who is present to my right. Can you state your full name for the record, please?
Abdel Mohsen Osman.
I heard it. You did it. That was perfect.
Exactly.
Your Honor, we're going to be requesting the briefest of adjournments. We just need discovery. He was recently arraigned, so we did put in the request. We're just awaiting.
August 14th, 2025, 9 a.m. Bond will continue. So you'll wake up. Close the case. People versus Antonio Cornelius.
I'm Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Cornelius. Mr. Cornelius, please state your name for the record.
Antonio Cornelius.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. I've had a chance to speak with the prosecutor in this matter. Both agree that mental health court referral is the most appropriate. So we'd like to adjourn this matter while we get that referral going. I think what the amount of time, 3 to 4 weeks.
To get the whole, because you got to get the screening. Okay.
Right.
Any objection from the people?
Okay.
August 28th, 2025.
August 28th?
Yes, sir.
All right, thank you.
Bond
very
will
much.
continue. Thank you.
Yes, sir. Thanks for waiting. It's been a while.
Court calls case people versus Glenn Pennington.
Andrew Childers appearing on behalf of the people.
Lady.
Ashley Bashir on behalf of Glenn Pennington. Mr. Pennington, if you could say your full name.
Oh, Glenn Pennington.
And Your Honor, we're requesting a brief adjournment, just to make sure that we can get some medical information for Mr. Pennington.
Said medical.
Yeah, for negotiations and also to potentially
Are you-
address bond.
Okay, I get that, but are you trying to retrieve that from a health facility, healthcare facility?
Yes, yeah, we need to get some our releases signed.
All right. Now, adjourn this probable cause conference to August 19th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
All right, thank you.
Yeah, the way you said
Court calls the case people versus Donald Wicks.
Andrew Childers appearing on behalf of the people.
Oh, she showed up.
Asli Bashir on behalf of Donald Whitsett. And Mr. Whitsett, if you could say your full name for the court.
Donald Deontay Woodson.
Thank you.
And Your Honor, today's the date and time set for a probable cause conference. My understanding, and you can correct me, Mr. Childers, I'm wrong.
Your Honor, there was, Mr. Whitsett had some cases pending in front of Judge Mood in the circuit court. There was ultimately a resolution on those that was supposed to include a disposition on this. This case basically was authorized kind of in the error. It was supposed to not have been charged. People would be moving to this case.
No objection to that.
No objection, Your Honor.
Case is dismissed. We'll need a volley. Okay. Thank you, sir. You're all set.
Okay.
Court calls case People versus Garrett, Pinnacle.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Finagle, who approaches. Can you state your name for the record, please?
Garrett Pinagle.
He's waiving preliminary.
He is waiving preliminary examination, Your Honor, and at the appropriate time, I would just ask to address bond.
All right, sir, you're waiving your right to have a preliminary examination in this case?
Yes, sir.
And you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive the right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We have formal reading, stand mute at this time.
Defendant every way from a reading standing mute, court will enter a not guilty plea. Before I set the pretrial, go ahead, argue bound.
Your Honor, my client has been entered into the sobriety or the recovery court in the circuit. He is an individual who would benefit greatly from that. However, I am asking for an opportunity for him to be released in the interim on a sober link device. I have talked to Mr. Childers about that, who didn't seem to have a problem with it. And I asked that for reasons. There are some underlying safety concerns in the jail that have been brought to my attention regarding my client. And I can provide to the court that he does have a place he can stay in Whitmore Lake with a family friend who has been present for him in court every time that he's had court.
Any response?
Your Honor, the people leave it up to discretion of the court. I would not have an objection provided that Mr. Phelps on either silver link or strength.
Is he with Judge Hunky's court currently? Is he in that program?
I don't know if it's going to be on, I believe that might be on Judge Slay's track, Your Honor.
Got it. Okay, so, but I guess what I'm saying is he in the court, or the sobriety court?
Yes, he has been accepted.
He's been accepted. Okay, and that's Judge Slade? Oh, gotcha. Okay. All right. What happened? Did he not show up for me or something? How did he end up in custody? Because I have his original bond, well, bond was denied. Did we have, we've already had a violation, haven't we?
Your Honor, I believe, my understanding, if I recall correctly, was that he did not come at a certain point. He was an earlier FTA on the case.
Yeah, this was in.
Well, no, there's a community corrections violation.
I remember something from March.
Yeah, so here's my problem. I would have. I'm gonna deny the request because I have a previous community corrections violation from March. And then at some point, he also then failed to appear.
Okay. So
while I'd be inclined to do it, given that, I'm going to deny the request for any modification of bond. His bond will continue.
Oh, we're waiting on a date.
All right. And so then in custody, pretrial date will be set.
August 12th at 1:30 with Judge Simpson.
August 12th, 2025, 1:30 before Judge Conkey.
Okay.
Thank you.
Thank you, Your Honor.
Court calls case People versus Mario Crawford. And we reached.
Stephanie Cannon on behalf of Mr. Crawford. Happy this time. Oh, you know what?
Am I gonna need that?
Mr. Allen, take this one too. This is the other one.
These are late ones. Oh, Scott and then Crawford. Wait, I can't see it. What?
That was difficult. That was like,
What was it? Is this the one you didn't turn in that you're not trying to turn in?
yes,
Is that it?
yes.
What took so long? That was like hours ago.
Chinado.
Okay, so that one goes into a file that's probably long gone. All right, so we're back on Crawford.
I'm just requesting an adjournment. He's in.
Why you?
He actually is no longer in custody. He was released.
Wait, I talked to him. Okay,
What?
nothing.
You said, no, you were about to yell at Ann. Go ahead.
No,
Let's see
no,
how
I
that
would
works.
never.
No, you were about to, Ann said something, you were like, I mean,
That was a
no, you were looking at it like,
vocalizing
no, you
astonishment.
got it wrong. That's how you were looking at it. So I wanted that to go ahead and see how that worked for you.
Yes, Your Honor, my client was in lockup on Tuesday when I went to see him regarding this case. We were asking for an adjournment for mitigation purposes.
You told him when his court date was.
I did say we had court this Thursday, yes, sir.
You for that its failure to appear.
Thank you, Your Honor.
Bond will be set in the amount of 10,000 cash surety. I don't know why I'm doing this. I will not issue that until the 4th, so you can try to find him.
Thank you, Your Honor.
Court does call the case People versus Stephen Ruggs.
Alexander, on behalf of the people, Your Honor. Mr. Ruggs, could you state your name?
Stephen Ruggs. Thank you.
At this time, Your Honor, Mr. Ruggs is requesting that the court set a date for his preliminary exam.
Okay, it's all discovery complete.
Yes, to our knowledge.
People have their witnesses available to 12.
Yes, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge
Valvo.
Valvo. Bond will continue.
All right, thank you, Your Honor.
Thank you. Court does call the case of the People versus Christopher Kniper.
Alexander, on behalf of the people, Your Honor.
Apologies, Your Honor. Assistant Public Defender Jay Ballinger on behalf of, but not with Mr. Nieper. Your Honor, I have had a contact with my client as of yesterday, understanding that there's a bond violation in this case. He and I had a heart-to-heart. He is checking himself in, and I did show some form of proof to Ms. Zenda regarding his admittance to Bear River.
That's correct, Your Honor. I did see that verification.
So is he in and headed up there?
He's already up in Traverse City, Your Honor.
So they've already taken him.
They will be taking, he's in that process. He's a day away from it, is my
Stay
understanding.
away from the Bear River.
Yes, Your Honor.
So what would you like me to do?
Your Honor, I would ask for an adjournment at this time I would ask for 2 weeks, just so that I can make sure that he's in, and that he sends us the admission paperwork.
Any objection from the people?
No, Your Honor.
Probable cause conference, August 2025, 9 a.m. bond continue.
Thank you, Your Honor.
Thank you. Case People versus Barrage Scott.
And as the public defender, Shanazi Carey, I can move it, Your Honor, on behalf of the Barrage Scott, who is approaching. Mr. Scott, when you reach the podium, could you state your name for the record, please?
Yes. Well, I was on take, Scott. All right. Did you hear me?
Yes, I can hear you.
Okay, I'm sorry.
No, it's okay.
Judge, we are requesting an adjournment today.
Okay.
It's my understanding that Mr. Scott is going to be arraigned on Monday. Arraigned on a, I think it's an older charge that was just authorized. Could you confirm that?
I didn't see. I don't know where that is.
Well, Judge.
Maybe when I looked earlier, I think maybe there's.
So another felony?
That's my understanding, Judge.
So, and if he's arraigned on Monday, the 4th, and he would get the 14th. Okay. So let's adjourn these out. I'll wait for the green sheets.
Okay.
But let's do August 14th, 2025. And if he does get arraigned on Monday or sometime in that week, they'll set it for the 14th. If you could note, so he doesn't get 2 dates, just to have whoever the arraignment attorney requests at the magistrate set.
Absolutely, Your Honor. Thank you very much, Judge.
All right, thank you.
I'm not gonna see you.
Bond will continue in both cases. I mean, yes. Is that her?
I didn't receive anything for that.
What did she say? Or- This is my last. Out. Court does call the case, People of the State of Michigan versus Savannah Bradley. Recall.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
And Laura Yagi, Assistant Public Defender with on behalf of Ms. Bradley, who's approaching. Ms. Bradley, can you state your name for the court?
Savannah Bradley.
We have her test results.
We do, Your Honor. And it does look like the only positive is the amphetamine, which I think would be consistent with Adderall usage. Every single day she takes her Adderall. I know there are numerical values for some of the other substances. However, the outcome is listed as negative. So
It doesn't meet a threshold. I understand how
Yeah.
it works.
So I would ask the court to, and I have had a very real conversation. Ms. Bradley, in all candor, was very terrified of being arrested in court today, and she came to court knowing there was the violation report, knowing the likelihood and possibility of arrest, and we had a conversation about that. She understands how serious it is to call community corrections every day and test. And she is very interested also in seeking help. So that's something that we're working on together. So I would ask the court to continue her bond and adjourn the PCC.
During the PCC to the 14th, 2025, 9 a.m. I won't. Did you get yourself enrolled?
I
You
will, I'm
were
going,
over
I can today.
today. They enrolled you?
Wait.
So did they give you like a color?
Oh, no, sorry.
Okay, we may need a new order. So you need to go back over there. I'm gonna prepare a new order so that you get yourself enrolled and that you do then, as Ms. Yogi is indicating, call them every day and follow their instructions. You understand that?
Yes.
What did I put that? Okay. Bond will continue.
Thank you.
Thank you.
Court does call the case People versus Marina Sexton.
Bailey's in on behalf of the people, Your Honor.
All I have is.
Yes.
To do this.
Thank you, Your Honor. Costin Bill Basie on behalf of Marina Sexton, who's present to my right. Can you state your full name, Marina?
Marina Sexton.
Thank you.
Your Honor, we're going to be requesting an adjournment for Padilla reasons, as well as to continue negotiations with the prosecutor's office, and I'd like to address bond when appropriate.
Yeah, you can. I'm gonna. Okay. Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Yes, go ahead. Esteban.
Yes, Your Honor, I'm going to be asking for a PR bond for my client. Your Honor, my client has no criminal history. She's been in for 11 days. She's currently pregnant. She also has been served divorce papers while she's been in jail that are related to this case. She wants the opportunity to be able to seek counsel for that. She's willing to go on a tether. She's even willing to submit her passport for the court to hold if they deem that
Counsel
appropriate.
approach. Right, in this matter, record should reflect your advance conference in this case. Probable cause conference, I'm going to actually adjourn this to the 14th, 2025 at 9 a.m. With reference to the defendant's bond, was there anything else from the people?
No, I was just on the record that we would object, on the record.
All right. I am going to, I'm going to grant the defendant $25,000 personal recognizance bond. So I'm going to lower her bond. I will, the defendant is to report over, well, I want a GPS location tracking tether prior to release. Okay, thank you.
Thank you.
All right, and ma'am, your counsel will explain to you some other implications that I explained. So, okay.
Thank you, Your Honor.
Thank you. Court does call the case People versus Collins Spry.
Andrew Bannis.
I'm Assistant Public Defender Natalie Pate with and on behalf of Mr. Colin Spry, who is approaching. Please state your name for the record, sir.
Colin Joshua Spry.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. Mr. Bannis did relay to me yesterday evening that the people have authorized a new case against Mr. Spry. However, it has not yet been sworn to. Me and my client, I have discussed this with him. He is hoping to keep his cases together. So I'm asking for an adjournment. I would not frankly know how long, maybe a couple weeks, but I don't know if it'd be accomplished by then or not.
Here's what I'll do. So that I'll put him out to August 19th at 9. So that if it does get arraigned, put it on the 14th. From the 14th, we can move it to the 19th.
Sounds good.
Maybe with this one. All right. I guess the only thing is if it gets set for the 14th, then we'll just kick it out to that day. Okay.
Thank you, Your Honor.
Bond will continue. Court does call the case People versus Derek Stevenson.
Morning, Your Honor, Jacob Kennedy for the people.
How you doing, Your Honor? I'm doing well. Yourself?
Mr. Gaddy.
Assistant Public Defender Tanazi Carey, I can really, on behalf of Mr. Derek Stevenson, for Mr. Mike Gaddy, Judge. I apologize, Mr. Gaddy just told me. How you doing, Mr. Stevenson?
How you doing? All right, you're requesting an adjournment.
We are, Judge.
Probable cause conference, August 14, 2025, 9 a.m. Bond continue.
Yeah.
Thank you.
Thank you. And get a seat at the table. Slow in custody, they're not there yet. So who's wasn't told to lunch? One of the people were fooling around. What'd you hear? Why, you know what? Calls case, People versus Fred Willis.
And so there's a hearing on behalf of the people.
We're ready. Jake, can I bring that people 183 matter?
Brown, Deputy Chief Public Defender, appearing with it on behalf of Mr. Willis. Mr. Willis, please state your.
Fred Willis.
And I believe that will be, well, we still need additional discovery. I believe that's already been requested. So there'll need to be adjournment in this matter.
Probable cause conference will be adjourned August 14, 2025, 9 a.m.
Thank you very much, Your Honor.
Bond continue. Let's call the case of the People versus Douglas Wren. Oh, we'll wait. I'm sorry.
For Jackie, Assistant Public Defender, with and on behalf of Mr. Wren, who's approaching. Mr. Wren, can you state your name for the court?
Douglas Allen Wren.
Requesting an adjournment.
Yes, Your Honor.
So there's a question about his participation.
So he's in recovery court, but I
All right. Once again, District Court for County of Washington, State of Michigan, now back in session, the Honorable Judge Simpsons.
You may be seated. Court does call the case of People versus Anitra Comer or Coomer.
Andrew Childers appearing on behalf of the people.
I'm sorry. Apple. Says Anitra.
All right. Once again, District Court for County of Washington, State of Michigan, now back in session, the Honorable Judge Simpsons.
You may be seated. Court does call the case of People versus Anitra Comer or Coomer.
Andrew Childers appearing on behalf of the people.
Sorry. Apple. Anybody know where Miss Apple is?
Here, I can cover.
Okay.
Your Honor, Alexis Pluma appearing with and on behalf of Ms. Coomer, who I believe is going to be entering into a plea agreement today.
Yes. Miss Coomer, can you unmute and state your name? Can we get her unmuted?
Assistant Public Defender Hannah Apple on behalf of Ms. Coomer, Judge.
We're just trying to get her unmuted here. We're trying to force it.
Yes, sir.
There you go.
Okay. Ms. Coomer, can you state your name, please?
Anitra Coomer.
Thank you. I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of assault and or assault and battery, 93-day offense. Upon her successful plea to that charge, count one would be dismissed. That is the court's entire understanding of the agreement.
That is correct, Judge, and I did have a chance to review that as well as the advice of rights from my client, and she did give me permission to sign both of those on her behalf.
All right, very good. All right, ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again, please.
Anitra Lynn Coomer.
All right, Ms. Coomer, it is this court's understanding that you are going to be pleading guilty to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
I do.
And understanding that, do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
Miss Apple went through an advice of rights form with you. Is that correct?
She did.
And you understand that all of those rights you went through are rights that you'll be waiving as a result of this plea.
Correct.
Did you have any question regarding any of those rights?
No, sir.
You understand you're giving up your right to appeal of right.
Correct.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
I am.
And also because you believe that you're guilty of this offense?
I do.
August 5th, 2024, at the location of the Huron Valley Correctional Facility in Pittsfield Township, Washtenaw County, state of Michigan. What did you do involving a Bridget Gifford that makes you think that you're guilty of this offense?
Your Honor, may I voir dire?
Yes.
Thank you. Ms. Coomer, on that date and time that the judge stated, did you make contact with Ms. Gifford?
I did.
Okay, and you, by pulling her hair?
I did.
Okay, and you did not have permission to do that?
I did not. No.
And that act upon her was not in self-defense?
Correct.
Defense is satisfied.
All right. And ma'am, you understand that if you commit misconduct as defined by the Michigan court rules between the time I accept your plea and the date of your sentencing, that any agreement, although there isn't any regarding sentencing or any evaluation of your case, the court would not be bound by, and also that you could not use that as a basis to withdraw your plea, or would not be permitted to withdraw your plea. You understand that?
I understand. Yes, sir. Yes, sir.
Counsel, are there any other promises, threats, or other inducements which you believe or you know of that have led to this plea?
No, Judge.
All right. Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Normally, I can't do it on this case because it's victim's rights case. So a pre-sentence investigation and report is ordered. Sentencing in this matter will be,
13th at 9 a.m.
can't do August 13th because I need 2 weeks for a video writ. It's going to be the
August 27th at 9.
August 27th, 2025, 12 noon. And that's before me. Bond will continue. All
Thank you,
right.
Judge.
All right. Thank you, ma'am.
Thank you. Thank you.
Court does call the case of the people versus Jennifer Lindsay.
Sorry, Lori Jackie, Assistant Public Defender with and on behalf of Ms. Lindsay. Ms. Lindsay, can you state your name for the court?
Jennifer K. Lindsay.
You're requesting an adjournment.
Yes, Your Honor, for some additional discovery.
Probable cause conference without objection, August 19th, 2025, 9 a.m.
Thank you.
Bond will continue. Thank you, Ms. Lindsay.
Thank you. Thank you.
Court calls case people versus Justin Duffany.
Victoria Burton Harris, Assistant Prosecutor appearing on behalf of the people.
Kyle Burrell on behalf of Mr. Duffany, who's approaching the podium as we speak. Mr. Duffany, please introduce yourself to the court. Thank you, Judge. Today's the date and time set for probable cause conference. I was just appointed on this matter yesterday afternoon. So we are asking for a brief adjournment for discovery and for plea negotiations. At this time, there's also a bond violation or a.
There is.
Yes, Judge. So I spoke to Mr. Duffany. He went to community corrections yesterday at 4:20 p.m., but he did not have the money to test, so he was unable to. We did discuss today. He's going to go immediately to community corrections after this. I do have an email from community corrections to confirm that he was
Is
there.
he going to test clean?
I believe so, Judge. Yes. He's on what?
Are you going to test clean?
I'm on Suboxone. I'm prescribed Suboxone.
You're prescribed it? I'll pass it. He needs to get over there and test and then come back.
So thank you, Judge.
I'm not doing it anymore. Take some long. Just go on. Court calls the case, people versus Jonathan Faith.
Good afternoon, Your Honor. Bovis with and on behalf of Mr. Faith, Jonathan Faith, the court.
Mr. Faith, can you state your name, please?
You gotta unmute. Jonathan Faith. Judge, this is first PCC. I just got the discovery. I subbed in this week. I'm asking for a brief adjournment as well.
As soon as the prosecutor puts her appearance on, we'll be happy to proceed.
I was trying to wait.
I know you were gonna start, but he just kept talking. Go ahead.
Sorry, Judge.
Victoria Burton Harris, Chief Assistant Prosecutor, again appearing on behalf of the people.
Do you have any objection to the adjournment?
I do not, Your Honor.
Probable cause conference in this matter will be adjourned August 19th, 2025, 9 a.m. Bond continue.
Thank you, Judge. Good seeing you.
Thank you.
Bye.
Court calls case people versus Andrew Gendy.
Good afternoon, Your Honor. Andrew Santa on behalf of and with Mr. Gendy.
Good afternoon, Mr. Fanta. Long time no see. Hope you're doing well, sir.
Thank you, Judge, and you as well. And Your Honor, I just received discovery and I would like to get this matter adjourned. Would that be on a Tuesday or a Thursday, Judge?
Well, this month we have both. I have Tuesday, the 19th. It would normally be adjourned to a Thursday. So I have the 14th, the 19th, or the 28th.
I can't do, could we adjourn it to Thursday, September 4th?
Wow.
I know I'm going to be out of the country and I'm going to be in northern Canada, and I don't know whether I will have any internet connection.
I hear they cut it off for all Americans. No, I'm kidding. I don't know what happened. Didn't used to happen that way. All right. So wrong. Well, give me this. The people, September 4th. Any objection to the September 4th date? All right. I will do that for you, Mr. Frantz. We'll adjourn this to September 4th, 2025, 9 a.m. or as your invite indicates, bond will continue. Right?
Thank you. Thank you so much, Your Honor, and
Thank you. All right. Safe travels to you.
thank you, sir. Bye-bye.
Bye-bye. Court calls the case of the people versus Naya B.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Lee, who's coming up. Ms. Lee, could you please state your name for the court?
Naya Lee.
Others? All right. Anyway.
Your Honor, we're asking for an adjournment to review discovery. A bit past 2 weeks if possible. We're waiting on some things that might take a while to be produced, so.
Without objection, August 19, 2025, 9 a.m. Bond will continue. Thank you, Mr.
Thank you.
Court calls case of the people versus Jaquan Holland.
Stephanie Cannon.
No, we'll wait for you to have the conversation. Are you talking about his shorts? Lack of pants?
Yes, Your Honor.
You are?
Yes, I was.
What'd you tell him?
I told him that we have to dress appropriately for court from here on out, not to wear shorts.
Did he
I know.
understand you?
He understands, Your Honor. He's apologetic. As soon as he leaves here, he's going to work, but he'll make sure he's dressed appropriate next time.
All right, what are we doing on this case?
Your Honor, I'm just asking for a 2-week adjournment or actually, you changed your mind. You said you want to go to exam, correct?
Yes.
Your Honor, my apologies. When we spoke yesterday, we were adjourning. Today, we are going to go ahead and set it for a preliminary exam. I'm going about the wall.
That was dramatic.
I'm sorry, Your Honor. Also, Your Honor, can I address bond when you're ready? I'm sorry.
He's out.
He is.
Oh,
That is accurate, Your Honor.
okay.
He is on tether, though we'd like to ask for the tether to be removed. This case it
Set
happened.
the preliminary exam first.
We
Thank
absolutely
you.
can.
Discovery is complete.
Yes, Your Honor.
Would people have their witnesses available to 12? Preliminary examination in person, August 12th, 2025, 9 a.m. That is before Judge Valvo. Yes, that's the bond.
Esteban, Your Honor, we'd ask for the tether be removed in this case. This case actually happened over a year ago, more than a year ago. He's had no contact with the complaining witness. He's not going to have contact with the complaining witness. He comes to court. He's in front of Judge Hammoud. He's never missed a court date, so that's not going to be an issue. He is not a threat to her or to the community, Your Honor. We are asking for the tether to be removed.
Response.
People that are asked for the tether to stay in place. I did do the arraignment on this. We are asking for that tether to stay in place for the safety of the complaining witness. The only restriction that this tether has, based on my notes, his arraignment, is he's not allowed to go to that particular site. So I don't see how that inhibits him in any way.
Your Honor, she doesn't even live in Michigan anymore.
Well, I don't know that. I mean, I know you're telling me that.
I understand, Your Honor.
I don't. The motion to modify bond at this time is denied. Certainly, you can take it up after preliminary examination with Judge Bravo on the.
Is it Valvo or Fresh Hour, Your Honor?
What did I tell you? You didn't write down what I told you. did you?
I wrote Fresh Shower, but you just said Valvo, so I want to make sure.
Which judge did you give me? Valvo, right? That's what you said, and then I said it.
And Your Honor,
Oh, you said Valvo, I said Valvo, she wrote Fresh Hour.
I'm getting old. It's my hearing. It's going.
So it's Valvo. All right. Court calls the case, People versus Antoine Coleman.
Good afternoon, Your Honor. Kelma Dadush on behalf of Mr. Coleman. Mr. Coleman, can you unmute and state your name for the record and remove your hat, please? Thank you. You have to unmute first.
There it is.
Alan, can you get me that last one?
Now I have it.
Yes, we can hear you now. Can you state your name for the record?
Antoine Coleman.
All right. I have before me, hold on a second. Couple. Is it the one that I have before me a plea form that indicates that the defendant will be pleading guilty to an added count 3 of operating while intoxicated, second offense, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be 1 and 2 would be dismissed. That is the court's full understanding of the agreement on this agreement form. I do have in here a memorandum of understanding regarding transfer of jurisdiction. Is part of the plea.
Right, it's not contingent on anything else at this point. It was just contingent on the screening and referral process that's done. So it's just as is.
Very good. Is that your understanding?
Yes, Your Honor.
All right. Sir, if you could please raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name again for the record, please, sir.
Antoine Coleman.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. The court could order any community service or rehabilitative services the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
I do.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty, sir.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those?
No, sir.
Please look at paragraph 5 of that form. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you in any way?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
August 24, 2024, at the location of 528 East Clark Road, Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
You recall what you had and how much?
I had approximately 3 shots and probably maybe 3 to 4 beers.
All right. Were you stopped by the police or was there an accident?
No, sir. I was sitting at the gas pump.
Okay. And the police arrived?
Yes, sir.
All right. Somebody had called?
Yes, sir.
Are you disputing the right of the police to stop and or detain you in this instance?
No, sir.
All right. Were you ultimately arrested?
Yes, sir.
All right. Were you taken to the police station or the hospital?
The hospital.
All right. Was there a blood draw?
Yes, sir.
And what were your blood test results?
Pretty high, sir. I don't know the exact number.
If council is willing to stipulate, Your Honor, have blood results of 0.164.
We stipulate to that, Your Honor.
All right. And so you don't have any reason to dispute those blood test results, do you?
No, sir.
All right. And had you previously been convicted of operating while intoxicated on or about September 7th, 2021 in the Third Circuit Court and or of operating while intoxicated on or about October 16th, 2017 in the Third Circuit Court and or operating while intoxicated on or about August 11th, 2017 in the Third Circuit Court?
Yes, sir.
All right. Sir, you understand that between the time of my taking your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that any evaluation or sentencing by the judge would no longer apply and the judge would not be bound by that. You understand
Yes,
that?
sir.
Any agreement? Okay. You also understand that you would not be entitled to withdraw your plea.
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, to the people.
All right. And has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B District Court. Sentencing in this matter will be
September 4th at 10 a.m. with Judge Washington.
September 4th, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you.
Your Honor.
Thank you.
Court calls the case, People versus Monica Collins.
Andrew Banner.
Hello.
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 Assistant Public Defender Natalie Pate with it on behalf of Ms. Collins. Ms. Collins, can you please state your name for the record?
Monica Collins.
Thank you, Your Honor. I'm respectfully requesting an adjournment. The phone number I did have for Ms. Collins was her friend, who I believe did help her get to the Zoom today. However, I am needing to have a conversation directly with my client. I'd ask for an adjournment for that to happen and also request that Ms. Collins call the Public Defender's Office to update with the best phone number if possible.
Probable cause conference without objections adjourned to August 14, 2025, 9 a.m. Bond will continue. Ma'am, do you have the number to the Public Defender's Office?
No, can I actually get it right now?
Yes, I'll be more than happy to give it to you. You got something to write it down with?
I'm gonna write it in my notes. I'm actually on my notes right now.
Pardon?
I'm gonna write it in my notes.
I believe on her phone, her phone, Your Honor.
I know, I'm not that old. Thank you. Number is area code 734
7
222
2
6970.
6970. Thank you.
You're welcome.
Thank you, Ms. Collins. Thank you, Your Honor.
Yeah.
For the record, I'm really bad at technology. I'm probably worse than you.
Oh, I know you're worse than me. You're in my court. All right. Court calls the case, People versus Christopher Cummings.
Abigail Nyswanger requesting permission to practice pursuant to MCR 8.120 under the supervision of APAG.
I thought we got all that over with this morning. No, I saw you. You came in late. Yes, you did. I saw you walk across right there. I did. And I said, hello. Nice of you to show up. Wow. All right.
She made that with the utmost respect.
Is it? Yeah, she still got that permission to practice hanging in the balance. Permission to practice is granted.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Cummings. Mr. Cummings, could you just say your full name?
Christopher Cummings.
All right. And I have before me a plea form defendant will be pleading guilty to the charge of assault and or assault battery. On his successful plea to that charge, count one would be dismissed. Defendant also agrees that there will be no deferred sentence agreement. There will be alcohol counseling, sex offender assessment, and probation, no contact with victim and alcohol assessment. The prosecutor and defendant agreed to a sentence agreement of probation with conditions, no deferred sentence agreement. That's the court's full understanding of the agreement between the parties.
Yes, Your Honor. Sorry.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Christopher Cummings.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, that you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of January 5th, 2024, at the location of 3344 Grove Road, Ypsilanti Township, Washtenaw County, State of Michigan, what did you do with reference to a Bethany Conde that makes you think that you're guilty of this offense?
Gave somebody a hug. And I guess they didn't want me to. Yes. He said, what did I do?
Well, you
Yeah.
just told that to me.
Yes.
Did you want additional water? I'm not.
Yeah, so you made physical contact with her.
Yes.
She did not want you to do that,
Yes.
and she did not give you permission to make contact with her prior to making contact with her.
Correct.
All right. Sir, you understand that if I accept your plea between today's date and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, number one, you could not withdraw your plea, and any sentence agreement or evaluation, the court would no longer be bound by. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right. Have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Your Honor.
Your Honor, we would just ask if the victim's name be placed on the record.
Pardon?
We just ask if the victim's name be placed on the
Good.
record. Oh, right.
I know. Plead guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 4th at 10 a.m.
September 4th, 2025, 10 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Here's
I mean, you were doing just, well, why did Kennedy even get up and get in your ear?
Well, I just wanted to make sure that I knew what I was doing, Your Honor.
That what?
That I knew what I was doing.
You were just fine, because if you didn't know it, I would have called you out. I don't know why he got it.
We appreciate
He was just, no, he was interfering. Shouldn't have been. Court calls the case, People versus Parker Davis.
Assistant Public Defender Jay Bellinger on behalf of Mr. Davis, who approaches. Mr. Davis, can you please state your name for the record?
Parker Bradley Davis.
Your Honor, we did provide an earlier adjournment request. However, we did provide today a waiver form.
So you don't want it adjourned?
We do not. That is a little dramatic.
It's me today. All right. Sir, you are waiving your right to preliminary examination?
Yes, sir. Yes, Your Honor.
All right, you understand the preliminary examination is a proceeding where people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand that you'll not have a hearing in either one of your cases and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right, people also waive the right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We formal reading and stand mute at this time.
Defendant every way from a reading, standing mute, court will enter not guilty plea. Pre-trial will be set for
September 23rd at 1:30 with Judge Simpson.
September 23rd, 2025, 1:30, Judge Simpson.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bond. Pardon?
Sorry.
You said a single count.
Yeah, single count in each case.
That's where I got confused, but then,
That's where you got confused?
and then I.
What did that mean to you?
I thought it meant one count.
There's an issue over here now on this side.
All right.
No, it's okay, Ms. Douglas. I got you. Bond,
Thank you.
we'll continue. Thank you. Court calls the case, People versus Bruce Dinkins.
Hey, Peter, we're jumping down for the people.
Cameron Dadish on behalf of Mr. Dinkins. Can you state your name for the record, please?
Bruce Dinkins.
My first client wearing shorts.
Is it?
It is
Feel special?
a special moment right now. Your Honor, he won't appear in front of you before, but I'll make sure that whoever he appears in front of next, he is
It
not
will
wearing
be
shorts.
me,
Okay,
and I
then,
have a great memory.
okay. He will make sure not to wear shorts.
I sure will.
I have before me a plea form that indicates that the defendant has been plead guilty to the charge of larceny by conversion, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the.
Honor.
May I have him sworn?
Right hand. Solemnly sworn to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth. So help me God. I do. State your name. Bruce Dinkins.
Sir, it is this court's understanding that you're going to plead guilty to the charge of larceny by conversion, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would be the maximum fine. You understand that?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
You understand that?
Yes.
You understand you're giving up your right to appeal of right? Is that a yes?
Yes.
Are you on probation or parole?
Probation.
Okay, were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
January 26, 2023, at the location of 2201 Hogback Road, in Pittsfield Township, Washtenaw County, State of Michigan. What did you do that makes you think that you're guilty?
I misused by not charging my tether.
Permission to voir dire, Your Honor.
Please.
All right, the tether was given to you to use for a lawful purpose of testing your levels, correct?
Yes.
Okay, but and the value of the tether was $200 or more.
Yes.
Okay, and instead of using the tether in the manner that you were supposed to, you failed to do so by failing to charge it, correct?
Yes.
Could the people want to hear a bit further, Your Honor?
Somebody better.
Mr. Jenkins, while you had that tether and you were being supervised by the courts, did you at some point abscond from supervision, as in not show up to have anyone look at your tether?
Yes.
Okay, so did you essentially fail to return that tether to the people who gave it to you?
I returned it.
He returned it eventually.
Okay, was there a long period of time that happened when you kept that tether and didn't return it?
No.
Is there a period of, when you weren't using it in the way you were supposed to be using it, did you return it immediately or did you wait a period of time before returning it back to probation?
I returned it immediately. Oh, no, I did return it.
They asked for it back immediately.
No. No, I'm gonna pass the matter. You can have a
Thank you,
more
Your Honor.
detailed conversation with your client.
Thank you, Your Honor.
Thank you. Court calls the case, Buell versus London Daughters.
Good afternoon, Your Honor. Victoria Burke Harris, Chief Assistant Prosecutor, here on behalf of the people. That's my, that's being the counsel make her way to the podium.
Ultimately.
Assistant Public Defender Chinazi Carey Akinruli, Your Honor, on behalf of Mr. London Daughtery. Mr. Daughtery, state your name for the record, please.
London Daughtery.
I have before me a plea form. Plea form indicates that the defendant, well, he has two cases.
That is correct, Your Honor.
Your Honor, the people are moving to dismiss case 22 FB 1318 as a part of the global resolution with him pleading guilty under 1651. The nominee is making his way to your staff.
Okay, so what I'm gonna do is I'm gonna add to the form that they're gonna dismiss 22 FB 1318. All right. So form indicates that he's going to plead guilty to the charge of improper possession of a firearm in or upon a motor vehicle, the 90-day offense, and involving mandatory forfeiture of the weapon or device. Upon a successful plea to that charge, count one in that case, which is the case ending in 1651, as well as 22 FB 1318 would be dismissed. That's the court's full understanding of the agreement.
That's
correct, Your Honor. And I apologize for not blending that together.
No, it was Ms. Akinruli's fault, don't worry. May I have him sworn?
Right here. Part of the testimony about to give be the truth, the whole truth, and nothing but the truth, so. State your name.
London Daughtery.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of improper possession of a firearm in or upon a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that, sir?
So,
all right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and that you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
yes, sir.
All right. And understanding all of that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
February 8, 2022, at the location of La Forge near Warburg in Ypsilanti City, Washtenaw County, state of Michigan. Were you in a motor vehicle?
Yes, sir.
Did you have a weapon?
Yes, sir.
What kind of weapon was it? Really? You want to get that?
Sorry. That was a 9
So you had a pistol, was it loaded?
No, sir.
Where was it in the vehicle?
And I think located in the back seat.
In the back seat? Did you have any authority whatsoever to carry that firearm in that fashion?
No, sir.
All right. And you knew it was there in the vehicle?
Yes, sir.
All right. Sir, if I accept your plea, you understand that if you commit misconduct as defined by the Michigan court rules between the time of this plea and the time of your sentencing, that you, first of all, would not be entitled to withdraw your plea, and any evaluation or sentencing recommendation to the court no longer would be bound by. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
So satisfied.
Defense is satisfied as well.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 District Court probation. Sentencing in this matter will be
September 4th at 10 a.m.
September 4th, 2025, 10 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Oh, and I should also say 22 FB 1318 is also dismissed.
Thank you very much, Judge.
We actually gave you the wrong sentencing date.
Hold on, that's the wrong sentencing date because that was Judge Washington's sentencing date.
I don't actually know.
It's Judge Washington.
It Judge Barr was on August 27th.
August 27th, 10 a.m. Thank you. Bond continue. Court does call the case of the people. I should also just finish that before I did that. Case FB 22 FB 1318 is also dismissed as part.
Thank you.
Court does call the Cartier Reigns.
And for that was the people.
And Laura Yagi, Assistant Public Defender with, and on behalf of Cartier. Mr. James, can you unmute yourself and state your name for the court?
Also files for this block.
Harbin. I'm James Harbin.
APA Rachel McDuffie for the people, on Mr. Harbin, Mr. Dushman.
Why are we calling Mr. Harbin? I didn't call that case. He did. He said something. Mr. Drains, can you state your name, please?
I, Cartier Amani Drains, hereby declare that I am a living, breathing human being, a natural person distinct from any legal or corporate entity or fiction. I do not consent.
Okay.
To be represented or binded by any assumed legal identity or straw man. I assert my full rights under natural law and constitutional protection as a sovereign individual. I stand before this court to represent myself, all legal matters pertaining to the charges brought against me. I reject any notion or claim that my person may be divided, operated or substituted by any separate legal entity. I affirm that all statements, evidence, and arguments I present are made on behalf of my living self, fully understanding my rights and responsibilities as a free individual.
Hey, you finished? All right, the court on its own motion is going to adjourn this because we're going to have an issue here. I have a feeling. I'm going to adjourn this probable cause hearing next week, August 7th, 2025. That's at 9 a.m. That is in person. He must be here so that I can hear him clearly in terms of what he wishes to say. Bond at this time will continue. Thank you.
Thank you. I'll follow up with you. Thank you.
Court does call the case of the people versus Samuel Freeman.
Anna Mackey on behalf of Mr. Freeman, who is to my right. Please state your name for the record.
Samuel Freeman.
Requesting an adjournment in this matter, Your Honor. We're waiting for discovery.
Waiting on discovery. All right. Probable cause conference in this matter will be adjourned August 19th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you, sir. Does call the case of the people versus Stephen Javon.
Anna Mackey on behalf of Mr. Javon, who's approaching.
They did have my social security backwards and everything. Had me at the wrong birthday. I was born on Christmas, 12/25/66.
APA Richmond, that's for the people.
Your Honor, we're requesting to adjourn this
Can
matter.
State your name for the record, sir.
Red Crockett. Haven't had any income or nothing. They shut down. I didn't put my name at this. I didn't put my
Hang
birthday.
on a second, sir. Have you ever gone by the name of Stephen Javon?
Yeah, they had me listed at that name. That's my.
They had that listed as your name, but you're saying your name is something different now?
They had me listed at that name. I didn't know. I woke up from what they were doing to me. I had attempts to kill me, man. I hadn't had a night's sleep or nothing. Right now, my health is down, man. I'm suffering from a gunshot wound from segregation, in which I'm
Okay,
still going
no,
through
no.
stuff. I left a hospital with open wounds. Something
Okay.
happened
Okay, but I just
not
need
too
to
long
know.
ago. And then you were part of something. I'm really excited conflict of interest with this. I'm really just excited to kill this case, man. Because this case is, they got me the last day of the art fair. The last day of the art fair, I'm asking you to kill the case.
What art fair?
That's what happened to me. They made a false report and they got me.
Okay, all right.
Doing this stuff, crazy
Hold on,
stuff.
hold on. At some point, I myself or some other judge will hear all of your complaints. I just need to know, do I have the person in front of me that this complaint pertains to? So that's why I'm asking you. You've been known by the name Stephen Javon before at some point, correct?
Yeah.
Okay,
Before I was.
all right. Counsel, what do you want to do on this?
Don't be approach, please.
No.
May we
I can't keep going
approach?
because I ain't had no income. I can't keep going that stuff with it. Just doing stuff. Yeah, I've had.
This is going to be
cases
important.
this year.
Okay, yeah, come on.
This is
Okay.
open and shut state. I shouldn't be.
All right. Go ahead. Okay, what are we, record to reflect, you had a brief bench conference in this case. What are we doing with this man?
Your Honor, the people would like to request that there is an order for a competency evaluation. That is on a people's motion. I think that given what we've just heard from the defendant, it's an appropriate request at this time.
Any statement?
Evaluation, and they almost killed me. Man,
Sir,
better get me out this
Sir,
room, man. They
sir,
almost killed me, man.
sir,
I can't keep
sir.
going through this, man.
Sir.
I'm not gonna go
Sir.
through no evaluation because I got an education, man. I'm not going through that no more.
Sir.
You did this last time to me, man. It's already a conflict of interest. Yeah. I'm just saying.
I'm gonna say,
he got
sir. Sir, one
I
more
had a
time.
Reaction to that.
Sir?
Almost was dead from that allergic reaction, man. You and Collins, man. Already a conflict of interest.
I'm gonna order a competency evaluation, forensic
I'm order you
evaluation.
for a competency evaluation, man. Pretty, I'm finna sue y'all, man.
You wanna know
Leave
what?
here.
You keep talking, we're gonna have a problem.
I'm
Because
not
I'm
gonna
gonna
get no
get- I'm
evaluation
gonna
from
get
you.
through-
You're not gonna do
I'm
to
gonna
be a
get
demon.
through this hearing.
Yeah.
All right?
Not
If
gonna-
you don't want to conduct yourself appropriately, then we'll sit you in back until you can come out and conduct yourself appropriately.
I ain't going to no competency evaluation. I don't need no competencies. I had medication I shouldn't even have in me. I almost
I'm gonna
died,
let you
man.
go
I'm not
on
gonna
and try
be
to
in
get
no,
it
I'm
all
not gonna
out.
be under no pressure with no medication. I'm not gonna be taking something that I'm not.
All right, I'll
you know.
tell you what I'm gonna do. I've given you 2 warnings. I'm gonna pass the matter. Mr. Allen, you can place him in back. I will decide on what his bond is and everything else. You need to go with my bailiff, sir.
Man, you sitting there, I'm gonna
You
get
need
you
to
in trouble.
go with
Okay.
him. Call
I'm a-
security, call security down.
Man, that's what I'm saying. You a part of something that he is up to me, man.
You guys might want to go check back there. That I don't know what's gonna happen.
That's his back.
What?
Backpack.
What about his backpack?
Oh, it's your backpack? Oh, I was like,
You can take it home with you. I'm not, well, they'll get it.
yeah.
Just leave it there. I am not worried about that backpack.
Should be.
I'll pass this matter and we'll come back to it,
Thank you.
maybe.
Don't make it.
Court calls case People versus Jean Gray.
Andrew Manis for the people. Michael Gaddy, Assistant Public Defender for Mr. Gray, who's approaching, Your Honor.
Right. Your name, sir?
John Gray.
All right. And what I have before me is a plea form that indicates that he is going to be pleading guilty to the charge of false report of a misdemeanor, the 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. There is a sentence agreement, which I can't, well, I don't know, of no upfront jail, probation at least 12 months. This is actually between the prosecutor and no probation of at least 12 months with HIDA. Got it. Okay. That is the court's full understanding of the agreement.
That is correct, Judge.
All right, I see what the sentence agreement is. This court, it's my case. I'm not necessarily agreeing to all of that. I need parties to understand that.
Yes, sure.
May I have him sworn?
Right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. John Gray.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of false report of a misdemeanor. That's a misdemeanor itself, punishable by up to 93 days jail, $500 fine plus court costs. You understand that, sir?
Yes.
All right. And understanding that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're indeed guilty of this offense?
Yes.
March 31st, 2025, at the location of 3000 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
Your Honor, may I have one, dear?
Please.
Mr. Gray, on that date and time, were you working at a gas station?
Yes.
And did you call the police?
Yes.
Did you use the fellows of a crime to the police?
Yes.
And that wasn't true, correct?
Was true, but it said that something that was true that they didn't do, like threaten me.
Did you accuse them of threatening you with assault?
Yes,
And did they in fact not assault you?
no,
I believe that's,
Oh, did they make the threat of assault?
did they threaten to assault you?
no,
So you accused them of assaulting you, but they didn't do it.
no, I accused them of saying like they were gonna assault me, but they didn't do it.
Did you accuse them of making threats of bodily harm?
Yes,
And they in fact did not do that, correct?
no,
And they did not make any threats to harm you in any way,
No.
correct?
Okay, and you reported something false in that regard to the Pittsfield Police Department, is that correct?
yes,
All right. Sir, you understand that if I accept your plea in this case, misconduct in the time of my acceptance of the plea and the time of your sentencing, you would not be entitled to, one, withdraw your plea. You would not be entitled nor receive the benefit, and this court would not be bound by any type of agreement or evaluation of your case. You understand that?
yes.
Counsel, are you aware of any other promises, threats, or other inducements that have caused this plea in this case?
No, Your Honor.
No, Your Honor.
And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Defense is satisfied, Judge.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
At 12 noon.
August 27, 2025, 12 noon. For me. Bond will continue.
Thank you, Your Honor.
Case People versus Lamia Grisham.
Ally Zen on behalf of the people, Your Honor.
I said her name wrong.
Hannah Mackey on behalf of Mrs. Gresham, who's to my right. Please state your name.
Lamaya Gresham.
Your Honor, we're requesting.
Lamaya?
Yeah, it
Really?
is.
That is not how that's Lamaya. Never.
It's Arabic. So
Is it?
yeah.
That's why. See, you're trying to trick me. Okay, go ahead.
It's like that.
What are you looking for? Go ahead, counsel. I'll wait.
Your Honor, requesting to adjourn this matter. I will fill out a green sheet shortly if I could.
You've got like 50 of them. None of them apply to this case?
I don't know how I missed that.
Poor Lamaya. All right. You're not worried, right? Okay. All right. What is the purpose of the?
We haven't received all discovery yet.
You haven't? Okay. Probable cause conference
Okay.
will be adjourned. I'll just do August 19th, let you get all that and go through it with the client. 2025, 9 a.m. Bond
you.
will continue.
Thank you.
All right. I'll remember the next time you're.
Okay, perfect.
All right. No, I won't. Alan, you have little faith, man. Court calls the case, People versus Jennifer Gray.
Thank you, Richard McDuffie, for the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Gray, Your Honor.
Oh, okay. She's right there. You Miss Gray?
Yes.
Okay, come on.
I was in a car accident, so I'm just moving a little slow.
It's all right.
Hi,
Your name?
Jennifer Gray, Grey.
All right. And what are we doing?
Your Honor, I'm asking the court to adjourn this matter so I can discuss the case with Ms. Gray.
I saw Nick earlier. I must have missed.
Okay. Your Honor, I believe 2 weeks will be ample.
August
And what
14th,
date would that-
2025, 9 a.m. Bond continues.
It can't be the 14th.
I believe Ms. Gray has a conflict on the 14th, Your Honor.
Oh, you do?
Yeah, I'm
The
bringing
19th?
puppy to be spayed. My new baby. I have an appointment at the Curry.
So if I were to ask the puppy, he probably doesn't want to go. I got you. Will the 19th work?
Yes, that'd be any day but the 14th.
Gotcha. It's probably what the puppy's saying. August 19th, 2025, 9 a.m.
Thank
All
you.
right, thank you, ma'am.
Thank you, Your Honor.
Clerk calls the case, People versus Taiwan Griggs.
And Lori Yagi, Assistant Public Defender with and on behalf of Mr. Griggs. Mr. Griggs, can you state your name for the court?
Mr. Griggs, okay, there you go.
Apologies, Taiwan Griggs. Sorry about that.
All right, thank you. It's all right. You're requesting an adjournment.
I am, Your Honor.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond will continue. Thank you, Mr. Griggs.
Thank you.
Thank you guys. Have a blessed day.
Court does call the case, People versus James Lee Harbin.
APA Rachel McDuffie for the people.
Kedma Dadush on behalf of Mr. Harbin.
Mr. Harbin, can you state your name, please?
James Harbin.
Thank you, sir.
Your Honor, we're asking
Thank
for
you.
a short adjournment. Your Honor, may we approach? Really quick.
Sure.
Thank you.
It's Scott. That's the one I want.
Yeah.
Okay. Probable cause conference in this matter will be adjourned.
Okay. I lost. That would you go, it's fine. We don't need to.
Is it going or not?
I pressed the button.
Before you guys do something else, August 14th, 2025, 9 a.m. Bond continued. Thank you. Thank you, Mr. Harmon.
Thank you, Your
All
Honor.
right,
Thank you, Mr. Harbin. I'll call you.
All right, thank you.
Court calls versus James Heron.
And Maggie on behalf of Mr. Heron, who is approaching. Please state your name for the record.
Mr. James here.
I have before me a plea form that indicates that he's going to be pleading guilty to use of a controlled substance, that they're 1-year offense. And upon a successful plea to that charge, count 1 would be dismissed. That's court's full understanding of the agreement.
That is correct, Your Honor.
That is complete.
I have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So be God.
Yes, sir.
State your name.
James here.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of a controlled substance, that being a Schedule II. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that?
Yes, sir.
All right. And understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form?
Yes, sir.
Any question regarding those rights?
I don't know.
Look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you
No, sir.
to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you're indeed guilty of this offense?
Correct.
On the date of November 7th, 2024, at the location of Huron Valley Correctional, Pittsfield Township, Washtenaw County, State of Michigan. Did you possess methamphetamine or ecstasy?
Yes, sir.
Did you use it?
No, sir.
Okay, were you intending upon using it?
Yes, sir.
All right, you knew what you possessed was methamphetamine?
Correct.
All right. Sir, you understand that if I accept your plea, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be allowed to withdraw your plea. Additionally, any evaluation or sentence recommendation, the court would no longer be bound by. You understand that, sir?
Yes, sir.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's
You have,
plea?
Your Honor.
People are satisfied.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
August 27th at 12 noon.
August 27, 2025, 12 noon. Before me. Bond will continue. All right, thank you. Court does call the case, People versus Kyle Humphreys.
Back in Mr. Humphreys, who should be appearing via Zoom.
You got him? Kyle Humphreys?
He's at Don Farms, Your Honor. I sent them the Zoom information yesterday and they said they would get him on.
I don't have him on. Is he at Don Farms?
He is.
I'll pass it if you can get Don Farms to do that, as long as they're not gonna get on the bus to do anything. You don't like my joke. Court calls the case, People versus Calvin Johnson.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Hannah Mackey on behalf of Mr. Johnson.
Oh, there.
Who is to my right, Your Honor. Please state your name.
Calvin.
Your Honor, requesting to adjourn this matter. We are currently negotiating and need some more time to.
14,
Okay,
August 14, 2025, 9 a.m. Bond continued.
thank you. I'll call you.
Court calls the case, People versus Alvin Jones.
Andrew Banish.
Attorney here once again on behalf of Mr. Jones, who is appearing by Zoom.
Really?
Yes. I spoke with him yesterday, today.
Impressive verbal. We're going, right?
Yes.
I don't,
He's not there. Your Honor, I have been in contact with him. Could we pass so I could give him a quick call or
I
get in touch
can't-
with him, please? Please, Your Honor.
is he gonna come down?
He's supposed to be appearing on Zoom, so I'm gonna try to call him really quick and get him on there. I'm not sure what the problem is.
How is he not here? Pass it.
Thank you, Your Honor. Appreciate it.
Court does call the case, People versus Desmond Jones.
Andrew Banish with the people.
Ashley Bashir for Desmond Jones, please me.
Your name, sir?
Desmond Jones.
You're requesting an adjournment,
Yes, Your Honor.
August 14, 2025, 9 a.m. Bond continued. Thank you. Court calls the case, People versus Nathaniel Jones II.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Jones, who's here to my right. State your name, Mr. Jones.
Nathaniel Jones.
Your Honor, Ms. Burton Harris and I have had an opportunity to discuss this matter. I think we'll be able to resolve it pretty amicably. I'd ask to adjourn this matter to the next 2 weeks so that we can put
Probable
together.
cause conference, August 14, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Thank you.
Court calls the case of the People versus Lamine Kaba.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Kaba, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Lamine Kaba.
Got him.
Yeah. Thank you, Your Honor. I'm respectfully requesting adjournment. I need to have a conversation with my client. And I have had brief conversation with his mother and she was able to help him get onto Zoom today. So I would ask for a 2 to 3 week.
August
adjournment.
19th, 2025.
Yeah, I'm sorry.
9
It
a.m.
was breaking.
Oh, that's okay, sir. We will talk.
August 19th, 9 a.m. Ron, continue.
Thank you, Your Honor. Thank you, Mr. Cobb. I'll give you another call and we'll talk again. All right. Thank you, sir.
Court calls the case, People versus Dominic Kelly Payne.
Assistant Public Defender Hannah Apple here on behalf of Mr. Kelly Payne, who I do not see in the courtroom, Judge. Unfortunately, I believe he had court this morning in drug treatment court, and the last I heard, he had not appeared before Judge Kunke.
Got it.
I don't know that a warrant issued or he ultimately failed to appear, but I haven't heard a response and I haven't spoke with him. So for the record, I'd ask for an adjournment.
Bench warrant.
I was just gonna say, I did check the register of actions. The register of actions was showing that court for him was yesterday and that he did not appear, that there was a bench warrant issued.
No. We'll join the pile. Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately. Court calls the case of the People versus Paris Lester.
Edmund Dodge on behalf of Mr. Lester.
I just forward that to the parties.
Got it. Okay. Go ahead. He has a violation report. The last, as of 11:15, we understand he was at U of M hospital receiving treatment. He had been picked up by AAPD.
He was doing treatment and then he got picked up by AAPD from the
I
hospital.
think other way.
He loved treatment based on the things that he loved treatment, and then his other at U of M, which is certain one because it's on the case, it's not but on the case that he has up to date actually has to do with an RNO resulting police tried to remove him from U of M because of trespassing. There's several trespasses there.
Right, but is he at U of M for medical treatment? Do we know?
Who said that?
All I have is the.
Right.
He was arraigned about an hour ago and he was at the hospital then.
He was
I was
arraigned an
told.
hour ago? Before our magistrate?
Yes, Your Honor. I don't know all of the details, but Ms. Kearney arraigned him.
Parenting's involved?
Yes, she arraigned him about an hour ago.
All right, why don't I do this? Because you gotta, God pass it. You guys give me the information. Let's figure out what we're gonna do before I issue a bench warrant on.
Thank you.
Court calls the case, People versus Amanda Lewis.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Sorry, Student Attorney Kara Rosengren on behalf of Ms. Lewis. Record, please.
Lewis. Your Honor, we are just requesting an adjournment in this matter as we're awaiting video discovery still.
August 14, 2025, 9 a.m. Bond will continue.
Okay, thank you, Your Honor.
Thank you. Court calls case, People versus Austin Lubestall.
Hey, here, Richard McDuffie for the people.
Your Honor, Alexis Plumey appearing with and on behalf of Mr. Labastall, who I believe is present over Zoom. Could you say your full name, sir?
Austin Lobestall.
Your Honor, I do have a green sheet here. We have come to, I believe, an agreement, but myself and Ms. McDuffie will just need to iron out a stipulation regarding restitution.
Probable cause conference, August 14, 2025, 9 a.m. Bond continue.
Thank you.
Thank you.
Case, People versus Eugene Lewis.
Alexander on behalf of the people, Your Honor.
Oscar on behalf of Eugene Lewis.
Do I sit in?
Eugene Philip Lewis.
Thank you, Your Honor. Today we would like to request a preliminary exam date and also an opportunity to address a condition of bond.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available the 12th.
We'll do our best, Your Honor.
Preliminary examination in person will be August 12th, 2025, 9 a.m. That's before Judge Freshour. Esteban.
As to bond, Mr. Lewis currently has an order to refrain from going to his former residence on Hidden Valley Drive. And additionally, an order to a tether, an exclusion tether for that location. And finally, a no contact order with the complaining witness in this case, Bridget Lewis. Bridget Lewis has contacted our office, and I understand that she's spoken with the victim's advocate. She's present here today. She has communicated that she would like to have that no contact order lifted. Both Mr. Lewis and Mrs. Lewis, they're married, so Eugene Lewis and Bridget Lewis reside at that address. They also have a business that they operate from that address, and it is hurting their business, is my understanding, because they have clients who they need to visit and they need to coordinate. So I would request that the court consider lifting the no contact order according to the wishes of both my client and the complaining witness, or alternatively allow a consensual contact order and reconsider the tether.
Response.
Your Honor, Ms. Lewis is here.
All right. He's gotta go over that way. Right. See. Hello.
Hello,
What's your name?
Bridget Lewis.
All right. What would you like to tell me?
Sorry.
What would you like to tell him?
I would like the no contact order lifted, please.
All right. You don't have any fear of this individual at
Not
all?
at all. No.
Not at
He's
all.
no fear, no danger.
All right. And are you're at the Hidden Valley address?
Correct.
Okay. All right. That's a marital home?
Yes.
Okay. All right. Okay. Thank you. Anything else?
No, Your Honor.
All right. I'll order no non-consensual contact with the victim in this case, which would be Bridget Lewis. All right. I will delete the provision about no contact and add that. I will also delete the no go to provision to the Hidden Valley address.
Thank you, Your Honor.
Thank you.
And as to the tether, exclusion zone tether.
All right, we'll change the tether. We'll do a new order. He'll still have to wear the tether, but there will only be location track.
Okay. All right. Thank you, Your Honor.
Thank you.
Thank you.
Thank you, Your Honor.
Oh, yeah. And then go to yeah. Okay. Court recalls the case People versus Justin Duffney. Yeah.
Good afternoon again, Your Honor. Victoria Burke here, Chief Assistant Prosecutor appearing on behalf of the people.
Can I put it back on the record with Mr. Duffany? Justin, please state your name for the record.
Justin Duffy.
I've seen the results, Judge, and I have gone over them with Mr. Duffany.
He doesn't have a prescription for cocaine, Mr. Allen.
I would assume no. Gonna be all right. Gonna be all right.
All right, I'm going to adjourn the probable cause conference to August 14th, 2025, 9 a.m. His bond at this time, given the violation, his bond is revoked. Defendant's remand.
Thank you, Judge.
I know, but I don't know if anyone, I don't know why I passed them. That was a very condescending. There was. I know you said that to make me feel better. It didn't. I'm gonna act like a petulant child. Are they ready? That's as good an answer as any. Court calls the case of the people versus Amanda Scarderos.
Victoria Burton Harris, Chief Assistant Prosecutor, again appearing on behalf of the people.
Kenma Dadush on behalf of Ms. Scardutis. Amanda, can you state your name for the record, please? She's not unmuted. Okay.
Can you hear me?
Yes, ma'am.
Okay, I'm sorry. Amanda Lynn Scardutis.
Scardutis. All right.
Yes, sir.
I have before.
I know
me
it's a little
plea form.
tongue twister.
It is. It's been that kind of day. I have before me a plea form that indicates she's going to plead guilty to the charge of use of methamphetamine as a 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. The condition that she is admitted to the drug rehabilitation treatment center as part of her sentence. Not sure how that's going to work. And the prosecutor recommended immediate sentencing with agreement to no jail time and agreement that defendant is admitted into. How am I going to do that second part?
Sorry, Your Honor, how are you gonna do what?
If I do immediate sentencing, I don't know how I then have any control over her admission to drug rehabilitation and treatment after her release from DOC.
Could it be a probation requirement, a condition to her?
Well, when is she going to get out?
So she's was set to be released, but then this case came up. So until this case is resolved, she can't appeal in front of the parole board, but that would be her next step. That this case gets resolved and she can go in front of them. They told her that essentially as soon as she resolves this case, she's out of the MDOC.
Okay, when they say resolved, are they saying all the way through sentencing?
I believe just sentencing, yes, Your Honor. Because they're also supportive of her going to treatment. I believe.
Got it. I mean, I don't mind doing this. I'm just trying to figure out the mechanisms by which I would do it. Yeah, I could give her an immediate sentence at this point, but I think I know how I can do it. All right. Well, I think the only way I'm going to be able to do this, but I don't know if it's going to mess up any chance of parole, is to put her on probation so that I retain jurisdiction to do so.
I don't believe probation would hold her back. Ms. Scardutis, do you have any idea? I believe she should be fine. We've talked about putting her on probation and this being a condition of her probation. And she said that that should be good.
All right, ma'am, can you please raise your right hand?
Sure. Is there a possibility you can? I'm sorry. Is there a possibility of talking to the pro board maybe? Or no?
Well, I can't. I mean, I could, but I'm not going to.
Right. I wanted this before I even got this charge. I wanted to go into long-term treatment. I want that for myself. So I asked the pro board for this beforehand. So I don't know how probation will work unless if that is my probation.
Ms. Cardutis, I can talk to you after court. I think Judge was, I mean, your question was if Judge can notify the parole board. I think you'll have to do that. You'll have to notify them of what happened on this case, okay? But
Okay.
I'll talk to you next week.
Okay.
Okay.
All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
All right, state your name again. You can put your hand down.
Thank you, sir. My name is Amanda Lynn Skardutis.
Right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that, ma'am?
Yes, sir.
And understanding all of that, do you still wish to plead guilty?
Absolutely.
And to that charge, how do you plead?
I plead guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Your counsel went through an advice of rights form with you, is that correct?
Yes, sir.
And you gave her permission to sign that?
Absolutely.
Do you have any questions regarding any of the rights on that form?
No, sir.
And you understand that you're giving up all of those rights except with particular attention to your trial rights. You understand that?
Yes, sir.
You're not on probation or parole,
Not yet.
correct?
Not as of yet, sir.
Not as of yet. Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Absolutely.
On the date of January 30th, 2024, at the location of Huron Valley Correctional, did you have in your possession methamphetamine?
Yes, sir.
Did you use or intend to use that methamphetamine?
Yes, sir.
And did you know what you had was methamphetamine?
Yes, sir.
All right. Ma'am, if I accept your plea and you commit misconduct as defined under the Michigan court rules between the time of this, my acceptance of your plea and your time of your sentencing, you understand that you would not be allowed to withdraw your plea. You understand that?
Yes, sir.
And you also understand that any evaluation by the court would not be bound by or any type of sentence agreement. You understand that, ma'am?
Yeah.
Okay. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am not, Your Honor.
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
So satisfied, Judge.
Defense is so satisfied, Your Honor. Thank you.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. What I'm going to do in this case, and I think this will probably work out better for her. I'm not going to immediately sentence her. I'm going to refer over to my probation department, get a report. That way we can put her on probation with the condition that with the treatment condition. And so she can also then have something to show the parole board when she gets there. I think that may be our best way to do that. Okay, ma'am?
Okay.
So they'll come over and talk to you. Sentencing in this matter will be August 27th. August 13th. Well, I can't, there's no way. I can't do it. I gotta have 2 weeks. August 27th, 2025 at 12 noon. That's before me. All right, thank you.
Thank you, sir, so much.
Thank
All
you.
right, thank you, ma'am.
Thank you.
So
Thank you so much.
whatever, Court does call the case of the People versus Heather Booth.
APA Rachel McDuffie for the people.
Good afternoon, Your Honor. Sydney Rushing appearing on behalf of Ms. Booth with the case ending in 0913.
And Assistant Public Defender Natalie Pay on behalf of Ms. Booth in the case ending in 5683.
Okay. Ms. Booth,
Your Honor,
we need to
and,
get you muted somehow. We're trying.
Ms. Booth, you should be able to push the unmute button on the tablet right there in front of you. Looks like a little microphone.
I don't know if she can get to it or not.
Usually they have access to it. Yeah, just knock on the door, Ms. Booth, and let the deaf know you need to be unmuted, please.
That's fine.
I'm not touching.
You know, if this case was gonna be delayed, rushing would be involved.
You know, Judge, that's probably true.
Well, I see Miss Pate on your case. I don't know why she's not unmuted yet, but I see on your case, you're asking for an adjournment.
Yes, Your Honor. I just learned, I believe it was on Tuesday, that Ms. was in Wayne County, so I'm asking for an adjournment so I can meet with her.
And Ms. Rushing, what are you intending on doing?
Same thing, Judge.
Same thing? Okay.
Yes, Your Honor.
So what? I don't know how long she intends on being in Wayne County.
I do not have her
Your Honor,
out date,
she's
Your
there
Honor.
on Your Honor, if I may, she is there on a cash bond right now. I believe it's a $2,500 cash bond. So unless that gets posted, that's where she's gonna be during the next, I think, several weeks.
All right, let me do this then. Probable cause conference, I will adjourn to August 19th, 2025 at 9 a.m. And then let's see where she is. Did you, ma'am, can you hear me? If you can hear me, please wave your hand. All right. Did you hear I've adjourned your cases to August 19th? You got that? Okay, fantastic. Her bond will continue. Thank you.
Thank you, Judge.
Thank you,
And
Your
if I
Honor.
learn that she is released or moves places before that day, I'll notify the court.
All right, fantastic.
Have a great day, Judge.
Thank you, Ms.
Thank you.
Ms.
You
Booth.
too.
Thank you, Your Honor.
Probably too late. All right. We'll stand in recess. Let my staff get that together, figure out about these recalls, and then I'll come back and we'll just keep moving forward until we drop. All right, recess.
You'll see the
No, we didn't.
I didn't say anything.
All right. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Jason.
You may be seated. Court calls the case, People versus Kyle Humphreys. And from the other side, crickets. This is Ron Brown's case. Yes. What did I Oh, right.
Oh, Brown, on behalf of Mr. Humphries. He's appearing by Zoom now.
You on there?
Mr. Humphries? We tried. He's in treatment.
I don't have him. You don't have him, do you?
I do not have.
Yeah, we're requesting an adjournment. He's in treatment.
Oh, but I don't. Do I have anything that indicates he's in treatment other than you?
Well, we sent over a Zoom request because he was in treatment, so that kind of backs up what I said, because you appear on Zoom, right?
It does.
Because that was your decision.
What was my decision?
To allow him to appear on Zoom, because he was in treatment.
Okay, it was represented to us that he's in treatment. So you can appear via Zoom. Do I know if he's in treatment? I ain't been there, so I don't know.
I've been in court all morning.
Benchmark will issue 10,000 cash surety in each case. What I will do, Mr. Brown, is I will not issue his bench warrant until August 4th, 2025, Monday. If you can get proof to the court that that's where he is, then we'll reset him.
Thank you.
Thank you. It's kind of if you want enough, maybe you get what you want. No, nothing. Go ahead. No, we're good.
Recall, he's here now.
Court calls the case People versus Alvin Jones.
Student attorney Kara Rosie on behalf of Mr. Jones, who should be appearing by Zoom.
Mr. Jones, can you state your name, please? Okay, yeah, I see your lips moving. You need to unmute.
Might be muted.
Okay, there you go. Can you state your name?
Alvin Jones.
All right.
Thank you, Mr. Jones. I just want to put on the record to Your Honor that it was 100% my fault that Mr. Jones didn't appear earlier. So he had the wrong passcode and that was on me. So to get into the meeting. So I just wanted to take responsibility for that. And we're going to be asked.
I kind of knew that.
Yeah, I figured, but I just wanted that on the record, Your Honor. And we are requesting.
How everybody else knows.
That's okay.
I was just gonna let it.
I like to own up to my mistakes, Your Honor.
Don't
So
do that. You won't make a good lawyer.
so we are requesting an adjournment. To my knowledge, we're just waiting for some video discovery to be uploaded into DD so that we can review it.
August 14th, 2025, 9 a.m. Bond continued.
All right. Thank you so much, Your Honor.
Thank you. And
Thank you, Your Honor.
and the other thing that counsel you did is when I was debating whether to issue the bench warrant, you just kind of looked up and said, please. So that helped.
Puppy dog.
All right.
Thank you, Your Honor.
You're welcome. Court calls the case People versus Bruce Dinkins.
Keith Madalish on behalf of Mr. Dinkins, who is approaching.
Okay.
Let's try this again.
Your name, sir?
Bruce Dinkins.
Okay, I think we were at the point of the factual basis for the plea.
Your Honor, may I voir dire again?
Go for it.
Mr. Dinkins, were you given a tether by the probation department?
Yes,
And when you received the tether, you were instructed that the tether must remain charged at all times, correct?
yes,
And you were told that if it was not charged, the probation department would not be able to get the transmitted data from the tether, correct?
yes,
And you allowed the tether to run out of charge. You knew it did not have charge and you did not recharge the battery, correct?
yes,
And you knew that while the tether did not have charge, the probation was not receiving the data,
yes,
and you did not have authority to do that, right?
yes,
Okay, still don't see a larceny by conversion.
Well, higher charge is the tampering. Your Honor, we were trying to, this is for the higher charge, the tampering. With it.
Could charge it tampering?
It's circumventing,
What?
it's circumventing the purpose of the tether by not charging it. My God. Should I try the other one? Okay, try one more time. Mr. Dinkins, you were given a tether by the probation department, correct?
Yes.
And you effectively absconded from probation by not charging your tether and not returning your tether, correct?
Yes.
Okay. Until July 9th, 2024, which was more than a year after you absconded, correct?
Yes.
Your Honor,
Yeah.
let me offer this on behalf of the people. If the attempt is to do that, then
If what?
if the attempt is to use the higher charge and it's a matter of Mr. Dinkins not keeping a charge, that would fall under the next.
How long did he not keep a charge?
Mr. Duke?
He received it 10 days later. They stopped receiving any.
What?
So he got the tether around 10 days after he got the tether. They stopped receiving. So that's when he had stopped charging.
Okay, so he stopped charging, it's 10 days, and then when did they catch up to him or do whatever?
1 year.
Ow. Now I see, maybe you should have led with that.
Yeah.
So that would qualify for the larceny by conversion that I think you've been trying to get.
And
You just have to return it for 1 year.
I'll take the larceny by conversion and take the absconding as the higher charge and have him plead to that, but I don't know that that's even larceny by conversion. They got their tether back.
Yeah. Actually. Are we good?
That's a relative word. All right. Sir, you understand that if I accept your plea to this lower charge, that if you do commit misconduct between the time of my acceptance of this plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and any sentence agreement or evaluation, the court would no longer be bound by. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None by the people, Your Honor.
All right. And have I complied with the court rule?
Yes.
Defense is so satisfied, Your Honor.
Okay. Court will accept the defendant's plea to count to accepting the higher charge. Pre-sentence investigation and report is ordered at 14A1 probation. Great. Sentencing in this matter will be August 27, 2025, 12 noon. Bond will continue.
Honor.
Court calls case People versus Paris Lester.
Sorry, Your Honor. Can I judge on behalf of Mr. Lester? Okay, Your Honor. It is my understanding that Mr. Lester, well, first of all, I haven't had a chance to speak with him about this because he was at treatment. Miss Lauren Perenni did arraign him, but she did not get a chance to speak with him before to understand the circumstances behind the alleged violation or where he was. Therefore, we are going to be asking not to address the violation today. We were going to be asking for an adjournment. From my understanding, he was trespassed from 1200 Broadway and on 1 mile radius outside of that. And I believe the U of M hospital is outside of that radius. Anyway, we did try to understand what happened at the treatment center, but we don't have that yet. He is at the hospital. When he got arraigned, he was admitted to the hospital as a patient.
But is he still there?
Yes, as of an hour ago, he was there. I can call and ask if he's there right now, but he was admitted for medical help.
Do you have any objection if I adjourn this?
Your Honor,
You do.
based on, I don't. I was gonna give a long yes.
Oh, okay.
Your Honor, he is still on the GPS tether, I believe. If he leaves the hospital, there would be a way to track him.
Why is she, I don't know why you're still talking.
I'll just
I was
stop
gonna give
talking.
you an adjournment.
Thank you.
All right. Probable cause conference, August 14th, 2025, 9 a.m. Bond continued.
Thank you.
Court calls the case of Anthony Hamilton, People versus Anthony Hamilton.
Good afternoon, Your Honor. Robert Agasinski for the prosecution.
Good afternoon, Judge. You and your staff, Robert Burton Harris, on behalf of Mr. Hamilton, who's also present.
Your name, sir?
Anthony Hamilton.
All right. And what are we doing, Joe?
Judge, we're asking this matter to be scheduled for preliminary examination. I spoke with your staff.
I know. They didn't like it. Okay. No, I'm kidding.
Well, I was gonna say, I spoke to your staff and 19th is available.
Yeah, they told me.
And I think that date is.
Will that work for the people?
Yes, Your Honor.
All right. All discovery is complete.
Yes, Judge, as far as I know.
Preliminary examination in person will be set for August 19th, 2025. And that is going to be at 12 noon on that date, and that's before me. So it doesn't start till the afternoon.
And Judge, just for completeness of the record, I think Brother Counsel has 4 witnesses.
I expect 4 witnesses for that exam.
Lengthy witnesses. I'll tell you what the only thing about putting it on that date is it is another split date for me where I have PCCs in the morning and then exams in the afternoon. And I can't tell at this point how many exams are going to be set on that date. So.
I wouldn't be surprised if it took 2 hours.
Wow. Okay.
I would be surprised if it took 2 hours.
You would be surprised?
I think so.
Okay.
You think it's going to take longer?
No, I think 2 hours should be sufficient, especially if me and Brother Counsel are gonna agree on some.
Well, we'll put it there and we'll try to get you guys in on that date. I just can't tell what it entirely looks like, but we'll get you done. All right? Bond will continue.
Thank you, Judge.
Court does call the case, People versus Jamie Foxx.
On both cases.
Michael Gaddy, Assistant Public Defender on 25 F22223, Your Honor, and standing in for Mr. Friedman on 24 F21502 with Ms. Fox's permission.
Is that correct, ma'am?
Yes.
All right, very good. And what are we doing on this?
Your Honor, may we approach briefly?
Can I stop you? No, come on.
Thank you for the bench conference, Your Honor. I am asking for a 3-week adjournment in this matter so we can locate and review some medical records.
Well, and my understanding is now the medical records, have they been located and then provided?
Well, that depends, Judge. I believe the prosecutor says that we picked them up on July 18th. We say we don't have them, so we're trying, I sent someone back over to the prosecutor's office this afternoon again.
Right, and I'm just saying, let's move this ahead. So if they're as we sit here right now, do you have them does the PD have them in their possession?
I don't believe so, Your Honor. But the prosecutor's office has told us that we do. But I am endeavoring to locate them and review them.
Got that. Okay. So I just don't want to get here on the 19th. And then I go through the same thing. So what I'm going to order is I'll adjourn it out to the 19th. But if by Monday, the PD doesn't have them, then that redacted copy, there needs to be another copy presented. And if people got to go down there and witness the change of it, then they need to go down and do that.
Thank you, Your Honor.
Your Honor, I'll just say, I have no problem at all, of course, getting another copy of the public defender's office. I just want to say on the record that we've had those documents available on DVD for public defender's office since June 26th. But I have no objection to the adjournment, and I was even going to suggest that if they don't have them for whatever reason, I'll make sure we get another.
Okay, I'm gonna hold the attorneys responsible to make sure that those documents get there. I wasn't there. I don't know who's got what, and I can't stay. All I know is that it needs to be exchanged. I have no reason to disbelieve either side in terms of we gave it to you, or the public defender says we don't have it. I don't have any reason. It just needs to get done. August 19th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Tell
That all myself and Ian wasn't here. Double files. Court does call the case of the people versus Kristen Ramirez Fernandez.
Good afternoon, I'm Marie Tim. I was taking training back to people. From the mirror now. What's here? Is Carla Miracle? She's not her.
She's not on?
No, she was.
Okay, but she's not right now.
Yeah, sorry.
Pass it. Court calls case of the people versus Alonzo Reddick.
Thank you. AP Richmond, Deputy for the People.
Good afternoon, Your Honor. Edward Lucas on behalf of the defendant.
You're requesting an adjournment.
I'm asking for an adjournment. There's some outstanding video. That would be fine, Your Honor.
Without objection, probable cause, August 14th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case of the people versus Catherine Marcoux.
Can't advance the people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Marcoux, who appears via Zoom, Your Honor. Ms. Marcoux, can you please state your name for the record?
Catherine Camilla Marcoux.
You're also requesting an adjournment.
That's correct, Your Honor. We should hopefully have a resolution in the next 2 weeks.
Without objection, probable cause, August 14th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the people versus Derek.
Your Honor, we're asking for an adjournment of this matter.
For sure.
We're still looking for some discovery on this case. Wait.
What discoveries?
So,
There's some video that we are missing that we need to get from the police, but we have some video, but we don't have all the video. And so I have to get that too.
Got it. Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continued.
thank you so much, Your Honor.
Your Honor, this is Attorney
Okay,
Marable. You call my case.
Oh, the one that I read, okay. Terry Maxwell,
It should be on Zoom, Your Honor. Assistant Public Defender, Tanaka Carey Akinrumi, on behalf of Mr. Terry Maxwell. Mr. Maxwell, if you're there, could you please unmute, turn on your camera and state your name for the record, please?
you got it. Oh, there it is.
Terry
State your name,
Maxwell.
sir. Thank you.
Your
What do
Honor,
we do?
we are asking for an adjournment. I am still reviewing discovery with Mr. Maxwell.
You have green sheets, or I don't.
I-
Probable cause conference, August 14th, 2025, 9 AM, seeing a pattern.
Thank you, Your Honor.
Court calls case of the people versus Kimberly McPherson.
Student Attorney Kara Rosengren on behalf of Ms. McPherson. Mr. Pearson, can you say the record, please.
Kimberly McPherson.
Thank you.
Your Honor, there is an offer on the table that Ms. McPherson is interested in accepting. However, the offer comes with a restitution in full payment upfront. So we're requesting an adjournment of 3 weeks so that she can pull that together.
Is she gonna be able to do that in 3 weeks, you think?
Yeah, she believes 3 weeks would be enough.
Well, let's do this. That's August 28th. Maybe a little bit longer, try to get it in there and make sure it's done.
Thank you, Your Honor. That would be great.
August 28th, 2025, 9 AM, bond continued.
All right. Thank you so much, Your Honor.
Thank you. Court calls case people versus Michael Agbana.
Victoria Burton Harris, Super Assistant Prosecutor here on behalf of the people.
Where'd they all go? This morning, I couldn't throw a stone in this room without hitting a PD. Where's Blue Eye?
Oh, I apologize, Your Honor. I'm covering her case.
Okay, good job there.
No, yeah, that's on me. Is this Mr. Ogbonna?
Yes.
I apologize. Your Honor, Laura Yagi, Assistant Public Defender, on behalf of Mr. Ogbonna, I do have a green sheet prepared by Ms. Mai.
You're asking to adjourn it?
I'm asking to adjourn it, Your Honor, for immigration referral. I don't have any.
I don't believe Sister Counsel meant to say that on the record, Your Honor.
I apologize.
August 19th, 2020. Bond continued.
Thank you, Your Honor.
Court calls case people versus Jonathan Perry.
Public Defender Natalie Pate with and on behalf of Mr. Perry. Please state your name for the record, sir.
Jonathan Perry.
Thank you, Your Honor. I have discussed this case both with the people and my client. I believe all discovery is complete. I'm respectfully requesting to be set for examination.
People have their witnesses available to 12.
We'll do our best here.
Preliminary examination in person, August 12th, 2025, 9 AM. That is before Judge Valvo. Bond will continue. Thank you.
Thank you, Your Honor.
The court calls the case people versus Ever Ramirez Martinez.
Andrew Banas for the people.
Chairman Addis, on behalf of Mr. Ramirez Martinez. Mr. Ramirez Martinez, can you please state your name for the record?
Ever Ramirez Martinez.
And we're asking for an adjournment for plea negotiations, please.
Probable cause conference, August 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Edward Reed.
Good afternoon, Your Honor. Rick Tennant, the Western District. How are you?
Ron Brown appearing on behalf of Mr. Reed. Hunter.
You want him to introduce himself?
Hmm?
You want him to introduce himself?
Sure. Edward Reed.
We're here for a PCC and a bond violation.
Yes.
I received a Monroe County police report, shared it, set it for a hearing on the bond violations contained.
This alleged stalking from Monroe is the same individual. Is it not?
Yeah, Your Honor. And Your Honor, we would have no problem setting it for hearing, however, we'd ask that the case of violation.
Prosecutor, I'll be short.
Come on. All right. Record should reflect that a pre-bench conference in this case. What did you want to, I mean, I can address we can try to address the bond violation. You want a hearing on that? I don't have a problem setting it for a hearing. You want me to adjourn the hearing out to the
Next
well
week.
as the PCC?
Next week.
I don't know.
Why?
Why?
No, I didn't say why.
Why?
No, I didn't say
Did you
that.
say why?
No. No, I didn't say why. I said, well, I'd asked for that date.
And this is the latest count you have for next week?
That's what I was provided yesterday afternoon. Yes, sir.
Okay.
It will also include stays and custodies as well. Your Honor, we may need some more time to, if we're gonna have a full hearing, you know, the officer from Monroe.
Well,
got it.
If I get the information, maybe we can not have a hearing. I can share it with my client.
Well,
But if we can set it out, and then if Mr. Brown wants to contact us,
probable cause hearing, I'll adjourn to, it's not gonna be any better, but August 14th, 2025 at 3 p.m. That will be also the bond violation hearing. Will also be at that time at 3 p.m.
Yes, Your Honor.
As to bond.
I've shared information that I didn't want to place on the record with the court and the prosecuting attorney. I'd ask the court to consider that in addressing bond.
and Your Honor, we'd ask if you remanded. This is a case where it's extremely concerning. The stalking behavior also has additional factors of telling the victim he was going to rape her in front of their child, that he was going to threaten her throat. I could go on and on. I don't think it's necessary. It's extremely concerning behavior. The fact that he then decided to violate his bond very quickly after being informed of those bond conditions is just adding to our concern for victim safety, community safety. So we'd ask if you're remanded.
Just wanted to see my daughter.
Anything else, Mr. Brown?
No, Your
Honor. The court has reviewed, at least preliminarily, the Monroe police report and looked at it and having heard the arguments in this case. Let me just very simply put that this is a stalking case, and then there is stalking behavior, which is clearly delineated, continuing against the same victim. I've set it for the 14th. At this point, given what the court has seen and pending the hearing, defendant's bond is revoked, defendant's remand.
Honor. Court.
Court does call the case People versus Kevin Riggs.
Andrew Bennett.
Possibly Bashir for Kevin Riggs, who's a
Kevin Riggs.
Thank you, sir.
In your honor, I have a green sheet. We're requesting a 3-week adjournment if possible. The prosecution has notified us of a potential of a newly authorized matter that we'd like to track with this one.
Okay, when has it been sworn out and has he been arraigned? I mean,
Your Honor, I authorized the charge yesterday. It's being processed. I still need to sign it, swear to, and an arraignment. I assume I'll be able to sign it today or tomorrow.
what I'll do, counsel, is I'll put this on the 19th, okay? 2025 at 9. If it doesn't get through, I'm not gonna have a problem pushing it out to the 28th. Let them all try to catch up. We'll just,
Thank you, Your Honor.
we'll work with you to try to get that done.
Thank you, Your Honor.
You're welcome. Take care. Court calls case People versus Alexa Rushing.
Okay, I'm here.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Rushing, Your Honor. She is present by Zoom.
Okay. All right, what are we doing?
Your Honor, I'd ask the court for a brief adjournment. Ms. Douglas and I have had some discussions about settlement. I think we're very close.
We'll adjourn the probable cause conference. August 14th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
You're welcome. Case the People versus Abdul Scott.
Andrew Dennis for the people.
Stephanie Hand on behalf of Mr. Scott, Your Honor.
Your Honor, I have attempted to reach out to my client. I have not had any communication with him. I'm asking for an adjournment.
Abdul Scott, right here, bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor.
You're welcome. Court calls case of the People versus Derek Shipman.
APA Richard McDuffie for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Shipman, who's approaching, Your Honor.
Derek Shipman.
He knew it. All right.
Your Honor, I haven't had a chance to go over this matter with Ms. McDuffie. She has made an offer to Mr. Shipman. I'd ask for a brief adjournment so I can go over that offer with Mr. Shipman.
August 14th, 2025, 9 a.m. Bond continued.
Thank you. I'd ask. Obviously, thank you.
Thank you, sir.
So, thank you.
That's an incus. Court recalls case People versus Tristan Ramirez Fernandez.
Good afternoon. Good afternoon to this honorable court. Attorney Carla Marable on behalf of my client. Please state your full name for the record, sir.
Christian Josué Ramirez Fernandez.
All right, what are we doing?
Yeah, I do have discovery and I would like to set it for a preliminary exam. And I also need to address the issue of bond.
Address an issue of bond? All right.
Yes, Your Honor, my client, he owns a construction company and he needs to travel out of the state on August the 2nd. And I have all of the information for the court to pick up some equipment. It's just a one-day trip to Pennsylvania to pick up some equipment and he would be coming back.
Have you reached out to the prosecutor's office regarding a stipulation to that travel?
You know what? He just recently told me about that and no, I did not. because
All
I knew
right.
we was in
Well,
court.
if you get it to the prosecutor's office, get the information that you have provided to the court, see if you can reach a stipulation. If you can't, then send the information to the court and I'll address it. But if the parties can stipulate to his travel for one day, I don't foresee that being a real problem.
Well, can we do it now on the record?
Can he do what?
Can the prosecutor now stip to the, him traveling? It's just for one day.
How are they
On
gonna
August
do that any more than I can when I don't have any of the information?
Okay, thank you, Your Honor.
If defense counsel wants to email me today, I can try to look at it today. Best I can do.
Okay. Can you put your email in the chat?
Yes, ma'am.
Okay, thank you.
Any other demands you want?
Well, there's a lot that I want, Your Honor.
Well.
But now, will I get it?
No,
Now,
I'm getting very good at saying no. So I'll let you keep listening.
Okay,
All right.
okay. And
I'll
on
send-
this case, Your Honor, we do have discovery. And we're just asking for a preliminary exam date, Your Honor.
People have their witnesses available the 12th. Preliminary examination in person will be set for August 12th, 2025, 9 a.m. That will be before Judge Fresh Hour.
Thank you, Your Honor.
Thank you.
Thank
And I
you.
will send the stip over to the prosecutor office as soon as I get.
All
the
right,
email.
bond will continue. Thank you.
Thank you.
Thank you.
Court calls the case of the People versus Ashley Nader.
Good afternoon, Honor. Ray Jones, the prosecuting attorney on behalf of the people.
Good afternoon, Robert J. Cole on behalf of Ms. Nader. Actually, would you state,
Ashley Nader.
Judge, I was appointed 2 hours ago. This is what I understand the situation. Ms. Nader left the state.
She did.
She did. It was for 2 days.
And we tracked her all the way to Tennessee. But go ahead.
For 2 days, when she found out that what she did was against a court order, she turned herself in. There have been no violations as to the tether or her contacting the victim in this matter. It's my understanding that she has no vehicle. She has made no contacts with the victim. And what we're asking for is for you to release her, hopefully without a tether. She lives in St. Clair Shores. He lives in Whitmore Lake. If anything, he's contacting her, and she knows she cannot speak to him. So what we're doing is we're asking to adjourn this PCC 3 weeks. I'm asking her to be released on jail on a PR bond without a tether.
Response from the people.
Thank you, Your Honor. Your Honor, no objection to adjourning the matter as far as the bond matter. I'm going to leave that to the court's decision. I don't have any reason to believe there's been a violation of lawful contact, and I'll rely on counsel's representation for perhaps not.
All right. We'll adjourn this matter to August 19th, 2025 at 9 a.m. Ma'am, why'd you leave the state?
It was my family reunion and my oldest aunt is like passing away. So my entire family was going down there. It was planned for like the last 6 months. And I honestly just thought I couldn't go to Dustin's house. I didn't know I couldn't do anything. I've never been on tether or in trouble before.
You still have the tether on?
I do.
I'm gonna believe you because we saw you going all around everywhere while you were in Tennessee, and there have been no reason to try to leave the state. I mean, it was clear to me you weren't trying to abscond. And I don't know how you missed it, but I believe you that for whatever reason, you weren't thinking that you couldn't leave the state of Michigan. So I'm going to reinstate your bond back to a personal recognizance. I'm going to release you with the same conditions. Do you understand that?
Means no contact, the same conditions.
Same conditions that you had before you decided to take off south. All right?
She's asking me, does she still have the tether?
Oh, yes. Because if you didn't have the tether, we wouldn't have known that you left the state. Right? So I believe that you did what you did that you weren't intending to try to do everything, but I still see a necessity for the tether. So I'm gonna leave the tether on, all right? And certainly then we can deal with it at the 19th or whenever this case begins to resolve, all right?
Thank you.
Place their personal recognizance 5,000 we had before with the conditions. And we'll see you on the 19th.
Okay, you're gonna get out when you get out. Give me a call. Okay.
Court calls case People versus Michael Ware.
Victoria Burton Harris, Assistant Prosecutor of Area after people.
Edward Drucas on behalf of Michael Ware.
You're waiving your right to a preliminary examination, sir?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Drucker.
We will acknowledge receipt of the information, stand mute to the charge, and ask for a pretrial date.
Defendant able waive from reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
September 23rd at 1:30 with Judge Simpson.
September 23rd, 2025, 1:30, Judge Conkey.
Thank you.
Thank you.
Bound continues. Oh. Sign off on the information. Court does call the case of the People versus Dwight Williams.
Andrew Van should be.
Mr. Kilowald's case. Are you Mr. Williams? Come on up.
Sorry, Judge.
Take your hand out of your pocket.
Good afternoon, Judge. Robert Jekyll on behalf of Mr. Williams. Judge,
Your name? Dwight Williams.
Judge, I was just appointed on this matter. Can we get the August 19th date again, Your Honor, please?
Probable cause conference, August 19, 2025, 9 a.m. without objection. Bond continues.
Thanks, Judge. Appreciate it. Thank you.
Court calls the case of the People versus, is it Uni Singletary?
Victoria Burton Harris, Chief Assistant Prosecutor appearing on behalf of the people.
The attorneys.
Ashley Bashir,
Ron Brown Green on behalf. Thanks.
Ms. Singletary, can you unmute? Thank you. What- Thank you.
We're requesting adjournment for additional discovery.
What's still missing?
I have to go through the file to remember because I have so many.
Probable cause conference will be adjourned August 14, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, man.
Thank you.
Court calls case People versus Elani Smith. I think I got it. What?
Stephanie Cannon on behalf of Ms. Smith, who is appearing to my right. Ms. Smith, could you please state your name for the record?
My name is Leilani Smith.
I'm asking for adjournment in this matter.
Trying to see.
I have,
Everybody remembers when you get it wrong.
okay, I remember this code.
So which one?
Probable cause conference August 14, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Court calls case People versus Kirby Snyder. Kirby Snyder.
Michael Gaddy, Assistant Public Defender for Ms. Snyder. Your Honor, I called in the courtroom, I've called in the hallway. I haven't seen Ms. Snyder. She did contact my office this morning and said she was at urgent care, and then she contacted her a while ago and said she was on her way. I don't have any explanation as to where she is. So I'd ask for her to show cause.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000. Cash surety, that warrant will issue.
Thank you, Your Honor.
Case of the people versus Devon Sykes.
Herman Dadush on behalf of Mr. Sykes, who's appearing by Zoom. Mr. Sykes, can you please state your name for the record?
Devon Sykes.
Your Honor, we have come to a resolution with the prosecutor's office. However, we are going to be asking for an adjournment for Mr. Sykes to come up with restitution so he's able to take advantage of the offer.
Okay,
We
so
would-
how much time is he gonna need to do that?
So the agreement is, I mean, hopefully we can adjourn it out a month and he'll have it all paid by then.
You think you can do it within a month?
Yes, no problem.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Does call the case of the people versus Leo Taylor Jefferson.
Prosecutor appearing on behalf of the people. And Assistant Public Defender Chinazi Carey-Akinruli on behalf of Mr. Khalil Taylor Jefferson. Khalil, can you turn your camera on, unmute and state your name for the record, please? He's on Zoom, Judge. Thank you. State your name, Khalil.
Khalil Taylor Jefferson.
Thank you. Your Honor,
Khalil
the court.
Taylor Jefferson.
Say it again. Your Honor, the court should be in receipt of a referral to the sobriety court. We'd like to ask for an adjournment and yes, and ask ask the court sign that so we can see if Mr. Taylor Jefferson is eligible to enter the treatment court.
And this morning. All right, I've signed that. And how much time are?
I know,
All right, here's what I'll do. I'll adjourn it out to the 19th.
Okay.
Let's just see where we are.
that's fair, Your Honor. Thank you.
Bond will continue.
Thank you, Your Honor.
Case of the people versus Darnell Taylor.
Good afternoon, Your Honor. Retained Assistant Prosecuting Attorney on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Taylor, who's approaching now. Please state your name for the record.
Darnell Taylor. All right,
Your Honor, we're asking that this matter be set for a preliminary exam.
all discoveries complete.
Yes, to our knowledge.
People have their witnesses available to 12. Preliminary examination in person will be set August 2025, 9 a.m. That is before Judge Valvo. Bond continue.
Thank you.
Court calls case people versus Shaquise Tillison.
If you're Richard McDuff for the people.
Crown prosecuting on behalf.
You get my green paper?
I did not.
Jacqueline Tillison.
Requesting an adjournment.
Yes, Your Honor. Body worn camera. Media.
Probable cause will be adjourned August 14th, 2025, 9 a.m. Bond continue.
Thank you.
Court calls case people versus Keandre Vaughn.
Maybe Richard McDuffie for the people.
And good afternoon, Laura Yagi, Assistant Public Defender with and on behalf of Keandre Vaughn. Mr. Vaughn, can you say your name for the court?
Keandre Vaughn.
And Your Honor, I apologize. I didn't hand this up. I have a green sheet and a referral form for the court, for mental health court.
Probable cause will be adjourned to August 19th, 2025, 9 a.m. All right. Bond will continue. I've signed your referral also.
Thank you, Your Honor.
Court calls the case of the people versus Tyrell, is it Volks, Estera?
Maybe Richard McDuffie for the people.
And Assistant Public Defender, Navi Carey, Your Honor, on behalf of my client. Harold, say your name for the record, please.
Terrell.
All right, I have before me a plea form. Is that what we're doing today?
That is what we're doing, Your
The
Honor.
plea form indicates that the defendant would be pleading to an added count 2 of attempted check, no account, a 1-year offense. On a successful plea to that charge, count 1 would be dismissed. Defendant agrees to pay $1,900 restitution to Huntington Bank if requested, as ordered by the court. And there's no objection to HIDA. Is this the one, did we finally resolve that issue of the funds?
Your Honor, this is the one that we adjourned from our last hearing. I think, the court wanted the people to confirm whether or not, is that right? Is that what it
Not
said?
quite. I think that there was some ambiguity in the first version of that. There were potentially 2 different people who could have received restitution. I sent a breakdown to council of exactly who and who is not entitled to make any claim. Essentially, Huntington Bank is the only party. And I did specify only if they requested. If they don't, obviously, restitution will not be ordered at all, in this case, essentially.
Well,
Ms. McCary, I can believe has explained all of that to her client and he understands the situation, correct?
yeah, but I have to understand the situation.
That's, okay.
So my understanding the last time that we were here was that the victim in the case, the account holder, I guess, they had been made whole by someone.
That is correct, Your Honor.
Was that by Huntington Bank?
It was by Huntington Bank, yes.
Sir, please raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name for the record.
Terrell Voxchester.
All right, you can put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted no account check.
Yes, sir.
That is a misdemeanor punishable by up to 1 year incarceration and a $250,000 or $250 fine plus court costs. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Yes, sir.
Still wish to,
Yes, sir.
and to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as other rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will,
Yes, sir.
and also because you believe that you are indeed guilty of this offense?
Yes, sir.
Only. December 4th, 2023, at the location of 2435 South Main Street, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do that makes you think that you're guilty?
I cashed in a check that I knew it wasn't had money into it or anything.
You cashed a check and you knew there was no money?
Yes.
And what was the amount of that?
$1,900.
Counsel?
I am satisfied, Your Honor.
Well, I have to do this first, actually. Sir, you understand that if I accept your plea, that between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and also the court would not be bound by any recommendation or evaluation in your case.
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements that have caused this plea?
The is not, Judge.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
That defense is satisfied as well, Judge.
Court will accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
August 26th at 9 a.m.
August 26, 2025, 9 a.m. before Judge Falvo.
Thank you, Judge.
Bond will continue. Thank you.
Thank you, sir.
Thank you. Court calls the case People versus Vershawn Vincent.
Assistant Public Defender Hannah Athol appearing on behalf of Mr. Benson. Your Honor, I've been in contact with my client the last few days. I expected him to be here in person. He was coming in person. We have reached a resolution on the case. He informed me just now that he missed the bus ride from Detroit. So he's not here in person. For the record, I'd ask for an adjournment considering those circumstances.
Any response from the people?
Yeah. I will leave that in your discretion. We did come to a resolution. I think you were supposed to be here to sign. He's going to plead to 2 counts of RNO.
That's correct.
Attempt 2 counts of RNO.
Yes.
How did he miss the bus?
I didn't get the details, Judge. He said, I'm sorry I missed the bus. Please adjourn it if you can.
Probable cause adjourned August 14th, 2025, 9 a.m. Bond continued. Court calls case People versus Cameron Warren. Second, are you leaving? Oh, you going?
No, Judge, I'm gonna go to the office, do some more work until.
I won't tell anybody. I was just gonna say goodbye. On the Cameron Warren matter.
Oh, Assistant Public Defender Natalie Payworth, and on behalf of Mr. Warren, who's present via Zoom. Sir, can you please state your name for the record?
Cameron Warren.
All right.
Thank you, Your Honor. To my understanding, discovery is complete, and I have discussed it, reviewed it with my client. We would be asking to set this for preliminary examination.
People have their witnesses available to 12. Crickets.
Your Honor, after my sworn for people under supervision of Chief Assistant Prosecutor Brittany Harris. I apologize.
But sorry to wake you. Do people have their witnesses available?
We'll do our best.
Preliminary examination will be set for August 12th, 2025, 9 a.m. That is before Judge Fresh Hour.
Thank you, Your Honor.
And we'll continue. Thank you.
Thank you, Your
Thank you,
Honor.
person.
Thank you, Mr. Warren.
Thank you, Your
Court
Honor.
calls the case of the people versus Jeremiah Williams.
People.
Asli Bashir for Jeremiah Williams, who's approaching. We are requesting an adjournment to obtain additional discovery. Oh, sorry, Mr. Williams, if you could say your name.
Oh, Jeremiah Williams.
Thank you. Probable cause conference, August 14th, 2025, 9 a.m. Bond continued. Thank you.
Your Honor.
I thought I was done to last year. Court calls the case, people versus Elion Woods.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Asli Bashir on behalf of Ilion Woods.
Leon Woods.
And Your Honor, I've submitted a green sheet. We're requesting an adjournment to obtain some electronic discovery.
August 14th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Yes, sir.
You may.
Good afternoon, Ms. Amalia. Our number is 1423.
Thank you so much. I'm more than happy to assist you. This is Spanish interpreter 206624. Ready to assist you.
Thank you, ma'am. We need your assistance for two matters this morning. When you have a moment, can you raise your right hand to be sworn?
Yes, ma'am.
Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in the manner now before the court, so help you God?
I do.
Thank you.
All right. And good afternoon, Madam Interpreter.
Good afternoon, Your Honor.
Court does call the case of the people of the state of Michigan versus Martha Barahona.
Este es el caso que el tribunal llama del estado de Michigan versus Martha Barahona.
Got it. You don't have the attorney? I've got her. You see him?
Sí, tengo abogado. Se supone que tiene que estar en línea.
I have an attorney, Your Honor. He's supposed to be online.
Yes, your attorney is not here. When was the last time you spoke with him?
Su abogado no se encuentra aquí hoy, señora. ¿Cuándo fue la última vez que usted habló con él?
Hoy por mediodía.
Today at noon.
All right, ma'am, what I will do is I will adjourn this case out 1 week to August 7th.
Señora, lo que voy a hacer.
So hopefully you and your attorney can appear.
Señora, lo que voy a hacer es que voy a posponer el caso para el 7 de agosto, o sea, una semana más, para que usted y su abogado puedan presentarse.
Sí, una disculpa. No sabía que no estaba presente el abogado. Entonces estaré atenta.
My apologies, Your Honor. I did not know my attorney wasn't present. I'll be taking care of that.
No problem, ma'am. We'll see you next week.
No hay problema, nos vemos la próxima semana.
All right, one more, I think, here. Court does call the case of the People versus Roberto Cortez Sanchez.
El Estado llama el caso del señor, el del Estado versus el señor Roberto Cortés Sánchez.
Good afternoon, I'm Marie for the people.
Muy buenos días, su señoría Rich Adams, de parte del Estado.
Assistant Public Defender Natalie Pay on behalf of Mr. Cortez Sanchez, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Yo soy Natalie Page y soy la defensora pública en representación del señor Cortés Sánchez. Señor, ¿podría por favor activar su micrófono y presentarse? Se encuentra vía Zoom.
He's muted.
¿Me escucha?
Okay.
Yes, can you hear me now?
Yes.
Sí, señor.
Ok.
Can you state your name, sir?
Roberto
Señor.
Carlos Cortés, oh, perdón, Roberto Carlos Cortés Sánchez.
Roberto Carlos Cortés Sánchez.
Your Honor, I'm respectfully requesting an adjournment to have a discussion with my client regarding,
I understand.
which will take place tomorrow, that discussion. So a brief adjournment would be fine.
Su
Probable
señoría,
cause. Go ahead. I'm sorry.
sí thank you. Solicitaría por favor que nos den un aplazamiento para poder hablar con mi cliente. Mañana hablaré con él, así que sería como una solicitud de aplazamiento breve, lo que pediría. Gracias.
Matter will be adjourned to August 19th, 2025, 9 a.m. Bond continued.
El caso se pospone para el 19 de agosto del 2025 a las 9 de la mañana. Cerramos el caso ahorita.
Thank
Muy
you.
bien. Gracias, thank you.
Thank you.
Thank you, sir.
All right.
Gracias, señor.
Gracias, bye.
Bye.
4 o'clock. That's it. Okay. All right, we've got one more block to go. I'm going to take a brief break, folks. Eventually, we'll get through this. All right. I will have dinner. I don't know about the rest of you. 14 recess.
Do we still need interpreter on the line?
An interpreter, I do apologize. We are all set. Thank you so very much for your services today.
welcome.
Thank you as always. We appreciate you.
Thank you so much. Have a wonderful day. My pleasure.
14A District Court for County, Washington, State of Michigan is now back in session. The Honorable Judge J. Cedric Simpson presides.
May be seated. Court does call the case of the People versus Rashad Ahmad.
Good afternoon, Your Honor. Charlotte Steffen on behalf of Mr. Ahmad. Your Honor, I understand that he has retained counsel.
Oh,
Good afternoon, Your Honor. I will fax email one today, but 5 minute appearance.
you're right. You sent the appearance in, but there's already an attorney of record, so we'll need a substitute.
I will
guess,
send
Ms.
today.
Steffen, you're not objecting.
No, Your Honor, I stipulate.
All right.
Thank you.
All right. Go ahead, sir.
Your Honor, we are asking for adjournment.
Okay. Well,
I've spoken to counsel about a few things. We're in negotiations. We could got the case, so.
okay, because I have a waiver signed. Is that not what we're doing?
It is not, Your Honor. So we just need the green sheet for the adjournment.
Got it. Okay. Probable cause conference. 14th, August 14th, 2025. 9 a.m. or as you're invited to case. All right.
Thank you, Your Honor, very much. Have a nice day.
Bond will continue. Court calls case People versus William Hudgen.
Good afternoon, Your Honor. Charlotte Stefan on behalf of Mr. Hudgens.
Your name, sir?
William Hudgens.
All right. What are we doing?
Your Honor, we are asking to set this for preliminary examination, and I'd also like to,
And all discovery is complete.
yes, it is, Your Honor.
All right. And would people have their witnesses available to 12? Preliminary examination will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Yes, as bound.
Yes, thank you, Judge. As it pertains to the no contact provision, I know that's standard in this type of a case. However, I'm asking Your Honor to lift it. The complaining witness has contacted me, and I believe she's also contacted the prosecutor's office asking for that to be lifted. She and my client have been married together for 15 years. They have 4 children, and the no contact provision is a hardship on the children as well as on my client because the children are having to be transported back and forth between the residences now. But as I indicated, the complainant, she wishes to have the no contact provision dropped. And not going too deeply into the woods of the case, but aside from the initial call to the police and allegation, there is no evidence supporting the allegation. And so I think that's something that should be considered by the court.
Is she here?
No, no, she's not here. She, there was someone in our office, spoken legal assistant, claiming to be the victim. I don't know if it was or not, stating that she wanted contact for healthcare purposes. But as stated, she's not here. She has not spoken to the victim advocate about this matter. This is a strangulation. It's obviously a domestic violence case. There has been at least 1 prior incident. Your Honor, I am not comfortable with any changes in the bond currently. My understanding is that the defendant lives with his sister, potentially not very far away. So if she can work as a kind of third party for purposes of transporting the children, perhaps that would be a way to manage this. But at this stage, I'm not comfortable with it.
Your Honor, if I may respond, my client has no prior criminal record and any other previous incidents, my client was the victim. So I think that's important to note. And in terms of my client's other residents, it's only because of the bond. The marital home is still his home, Your Honor.
All right. Well, customarily, I don't change the no contact provision until I hear from the victim, the alleged victim myself. And so they would have to appear here so that I could make at least a minimal inquiry before I change it. So
I understand, Judge. I was hoping that you'd be able to take the call into the prosecutor's office as well as the contact that came to my phone today.
yeah, but I guess is what I'm understanding to the prosecutor's office. There may be were you sure that it was the victim or?
And
That's what
the problem here is that, but you could have a female call in and claim to be the victim and ask for contact, and we just don't have that verified.
So what I'm gonna do for those reasons, I'm gonna deny your request. Certainly after the preliminary examination, we can raise the issue before Judge Bravo to address if even that's necessary after exam.
I understand, Your Honor. Thank you.
All right, thank you. Bond will continue. Court does call the case, People versus David Leland.
Jacob King, Your Honor.
Good evening, Your Honor. Brian Montoya on behalf of David Leland. State your name for the record.
David Leland.
Just asking the court to set this matter for a preliminary exam, Your Honor.
All right. And all discovery is complete?
It is.
All right. And would the people have their witnesses available to 12? All right, preliminary examination in this matter will be set for August 12th, 2025, 9 a.m. And that is before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Kareem Davis. Kareem Davis. Mr. Long? Are they not hearing you? Because I'm not even getting a response. I know, I got the poly on. Mr. Long, can you hear us?
Yes, Your Honor.
Okay. Can you state your appearance, please?
Attorney George Long, P79687, appearing on behalf of the defendant, Kareem Davis, Your Honor.
Mr. Davis, did you turn his camera on? No. Kareem Davis? Could you unmute and
sir.
state your name?
Kareem Davis, Your Honor.
Thank you. All right, what are we doing in this case?
Your Honor, we have agreed to accept the state's offer. My client just accepted the offer, but he hasn't had time to sign the plea agreement. We request a short adjournment so that we may sign that agreement and enter a plea before Your Honor.
I'll adjourn the matter to August 14th, 2025, 9 a.m., or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case of the people versus Molly Fox.
Ellen Dennis appearing on behalf of Molly Fox, who is present.
Your name, ma'am?
Molly Fox.
All right. What are we doing?
Well, we Ms. Fox, pursuant to your order, was allowed out of custody and into Dawn Farms, which occurred on the 16th of July, I believe. Meanwhile, she has basically been accepted to the recovery court. I have an email from Mr. Reyes, Rhett Reyes, to that effect.
So 14B.
Yes.
Okay.
And apparently he did talk to Judge Washington or her staff about that. So we were prepared to enter a plea today, a no contest plea, and we did sign the paperwork for a plea. I mean, we signed the agreement and also the transfer order. But it's my understanding that because we asked for a no contest plea, you hadn't had an opportunity to read the police report, and so we should get another adjournment.
Right, because was it sent to me?
No.
Okay.
No, I'm not, I'm not. Right.
Okay.
And so we do need an adjournment, as I indicated on the green paper.
All right.
But it can be a short adjournment because we have signed the pre-agreement.
When is, I get it. So what I will do is I'll adjourn it to, would everything be ready in a week? And I don't.
Yes, everything is ready, right? Yeah.
Right, it should be, because we have filed,
August 7th.
we haven't filed the advice of rights, but that's easy enough.
August 7th.
And the other matter is, Your Honor, my
9
client,
o'clock.
my client has, of course, a no contact order with the victim, who is her daughter, her 15-year-old daughter. And her 15-year-old daughter is not living in the home, the family home. she's living with a friend, a godmother. But my client would very much like to have contact with her now and to set aside the no contact. Because now that she's at the Dawn Farms, the family comes and visits every, person to person visit on Sundays. And she would very much like to have some contact with her daughter whom she hasn't seen since the incident that happened that arrived and, resulted in this charge. And so that's like 8 months almost now, well, not 7 months. And she would like to have the new contact order lifted. Mr. Kennedy indicated that he didn't really take a position, but you can ask him, of course.
Yes, Your Honor. I do think that at this point, I would request that we just wait until the plea has actually been entered. Again, participating in the recovery court before we even. At this time, given that we do have a conference set for August 7th.
So I guess I'm taking that to mean that I should renew the motion on the 7th. The no contact request to be lifted. I don't think you're going to be.
Oh, you would.
I'm
Right?
sorry.
Nothing. But she's not we would take the plea, but it doesn't, her participation in the sobriety court or the court doesn't really occur till after that. And I think, Mr. Kennedy, you can correct me if I'm wrong, that's the point at which she's talking about it being looked at.
That is correct, Your Honor.
Okay,
They would be able to oversee the bond condition.
It's my understanding from Mr. Reyes that once Judge Washington, I guess, sentences her to the recovery court, which he said could be accomplished as early as the 11th of August, then all the time, she'll still be at Dawn Farms, at least until October, but it will count toward her recovery court participation, the 2-year recovery court participation. So while she's in Dawn Farms, she will also be in recovery court.
I get how it works.
Okay, well, you
I'm
probably
just-
knew much better than I.
Yes, you're right. But I think that the real issue becomes where she is in her progress towards sobriety. And what the people are saying is they're not saying no, they're just saying, get her into this process, let her establish in the process, and then at that point, take a look at the changing of the bond conditions, which to me makes sense.
Okay, but we won't be back in front of your honor. I guess we'd only be,
There'll be another judge that.
yeah, there'll be Judge Washington, I suppose. Absolutely, I suppose.
Okay, and Judge Washington, I think she'll deal with it, and she will probably, after the defendant is in the sobriety court, be in a much better position to address the issue as to where she is vis-a-vis the child.
Right. She completed, just for the court's understanding, she did complete the in-jail sobriety. It wasn't part of the sobriety port per se.
Dawn Farm program, right?
Right, and she completed that successfully.
I'm aware of that.
Okay,
Okay, all right, so as to that request, your motion is denied. As to any change in bond, and then we'll see you guys next week for entry of the plea.
Thank you, Your Honor, and I'm getting that police report sent literally in press.
would the court be, I mean, if the prosecutor were to, or the victim advocate were to talk to the daughter, would that, and got some response from her, would that be helpful to the court if we would renew it? Because I don't believe Mr. Kennedy himself has actually talked to the daughter.
Okay, so quite frankly, whether they had or not, I would have the same position. Frankly, that she needs to get herself established into the program. And I, so far as to say, I would defer the decision on that condition as well as other conditions to Judge Washington, who will be able to see her and will be overseeing her in the sobriety court.
Okay, thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court does call the case. People of the state of Michigan versus Brock Gerard.
Your Honor.
On behalf of people,
Stephen Moss, on behalf of the defendant, Brock Gerard, who is present in my office. Mr. Gerard, identify yourself, please, nice and loud. Thank you. Your Honor, this is the date and time schedule for PCC. I am asking for an adjournment. I have a massive amount of discovery to go through. I do note you've assigned August 14th as an adjourned date on some of the cases. I'm going to need a little bit more time for that, Your Honor. And with respect to a 21-day rule, waive the 20-day rule. Mr. Gerard knows fully about it. I've explained that to him.
Would August 28th work for you, counsel?
That's the one that doesn't. The following Thursday, perhaps, Your Honor?
September 4th?
Yes.
Any objection from the people?
I don't have an objection, but I just wanted to inquire, how is the defendant testing?
He is testing on a SoberLink device twice a day.
Okay. That's fine, Judge.
That's fine. All right. So I'll adjourn it to September 4th, 2025, 9 a.m. Bond will continue.
Thank you, Judge. Good to see you.
All right. Good seeing you, sir. Yes. That's where it's twice a day because it came from. It's usually 3 for me, but we'll just leave it. Court does call the case of the people versus Cameron Hallen. And
Good afternoon, Your Honor. Uwe Dawes with and on behalf of Mr. Hanlon, standing to my right, state your name for the court, please.
Cameron Hanlon. All right.
We're here with a resolution. Everything is in place, I think.
My understanding is that the defendant will be pleading no contest to the charge of disorderly person jostling, a 90-day offense. Upon a successful plea to that charge, count 1 would be then dismissed. Defendant, as part of this plea, agrees to enroll and participate in the mental health court. And also they have a sentence agreement over prosecutors deferred. That's the court's entire understanding of the agreement.
That's correct.
Is the anticipation that he would then be supervised by that court? I do prosecutors deferred. I don't know if out of, because once I transfer jurisdiction, I'm not the one sentencing under the prosecutors deferred. So I don't know, as it's laid out to me right now, this isn't going to work. Because what would happen is I would sentence basically as to the fines and costs that would go to 14A1. The case gets transferred there for probationary supervision.
Right.
The way it's supposed to work now, always changing. That case never comes back to me.
That's correct.
So
my understanding is that at the end of the mental health court probation, the prosecutor will move to dismiss the charge if Mr. Hanlon successfully completes it. So I think the agreement of ours is with the prosecutor to do so at the end of it. I have some faith that the 15th District Court will do it just so.
Well, I'm not saying they won't do it, but I'm just saying the way this reads, I just don't want the expectation that come sentencing, I'm going to sentence him to prosecutor first, because I wouldn't do that. Because I'm not going to be monitoring him, and Judge Valvo would be the one overseeing.
Your Honor, may I?
Yes.
I am the prosecutor on the mental health treatment court team. Judge Valvo, when she does the sentencing, will have me explain to him that if he does everything he's supposed to do, it's the role of the prosecutor on that team to decide whether he will be offered that deferred or not. And it will only come if he successfully completes that 2-year program, and then she will allow the dismissal. So the judge, what he's saying, I can confirm that I need to, but that's how that works.
Fair enough. I think with that understanding, if the court wanted to just take off that provision from the current form, yeah, and then we'll go to 15th and do that. No change in substance.
All right, that's the court's full understanding of the agreement. May I have the defendant sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name.
Cameron Hanlon.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of disorderly person jostling. That's a misdemeanor punishable by up to 90 days in jail and a $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. And understanding that, do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things about a no contest plea. I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea?
It's a lack of recollection, Your Honor.
All right. So to that charge, sir, how do you plead?
No contest.
Now, you understand that when pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yep.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading, you're giving up those rights as well as all the rights contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation?
Not currently.
Okay, you're not on parole either.
No.
Has anybody promised you anything other than what's been stated here today on the record?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
The court has been provided and has reviewed police report number on it. Reviewed Pittsfield Township Department of Public Safety report for their case number 253348. Any objection to the court having reviewed that report?
No, none from ours.
All right, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine secondly, any sentence evaluation or recommendation, the court would no longer be bound by. You understand that, sir?
Yes.
All right. Counsel, has there been any other promises, threats, or other inducements which have led to this plea that have not been disclosed?
No, Your Honor.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes.
Yes, you have.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A1 probation. When could we can do the 13th. All right. So that we can move his case along. I'll set sentencing before me for August 13th, 2025 at 12 p.m. Is it at 12? Yes, it is. 12 p.m. Before me. Then we can move it along. Bond will continue in this.
Thank you very much.
Thank you. Case People versus James Young.
Check County for the people, Your Honor.
Good afternoon, Your Honor. May it please the court. My name is Barton Morris, P 54701, on behalf with my client, James Young.
All right. Good afternoon. All right, what are we doing?
At this time, I believe we're going to be requesting somewhat of an extended adjournment. There are still some devices that need to be forensically analyzed in this case, and there also has been some materials found on the already analyzed devices that is likely going to lead to additional charges in this case. Get that some reviewed and those charges added.
So there may be charges that are added to. You're saying there may be charges that are added to this complaint?
Yes, sir.
Based upon that forensic review?
That is correct, sir.
All right. So how much time are we looking at? You're asking for the adjournment?
30 days? It's up to.
That would be sufficient, sir.
30 days? Would 28th work then? Or you want September 4th?
Let's go.
The PCC in this matter will be adjourned to September 4th, 2025, 9 a.m. Bond in this case will continue, and I'll sign off on the green form once I get it.
Judge, may I address the matter of bond? My understanding that there's a condition that my client not use computers, and he's a student at University of Michigan, about to begin a new semester. People and I discussed amending the bond to permit him to use computers for school purposes.
And Your Honor, that is correct. It is, however, my current understanding is the defendant has been trespassed from the University of Michigan, so I would believe that it would be necessary for that to be dealt with before we delve into amending the bond for any conditions that would for educational purposes alone. So I would be amenable to amending the bond for purposes of pursuing any sort of appeal to that University of Michigan trespass procedure.
Well, I think what the people have said that they would be permissible in amending the bond to permit him, my client, to request for permission to enter the school, but they're also, even if he doesn't enter the property, he could still go to school simply by using a computer, potentially. So I think that it's still necessary first.
Well, what is his current status? Is he eligible to enroll given the trespass?
Yes, that's correct. Have you enrolled in school for the fall?
Yes.
He's already enrolled.
And all of the classes that he could do online?
Not necessarily, but I know that some of the classes that he's a master's degree student, so not an undergraduate degree student.
Okay.
And I believe that there are classes that would require his attendance. Not.
Right, I get that. So wouldn't it really behoove us to maybe do as, although it pains me to say it, do as Mr. Kennedy suggests? And that is to address the trespassing issue with the university and then set the parameters for his use of computers. Because if, just by way of example, and I've run into this, and I'm trying to find a program that would allow somebody to use one computer that we can track everything that they do. But the issue, it seems to me, is if they say that he can't attend, let's say they say he can attend school and he can go there. Are we talking about use of any computer anywhere? Or are we talking about a limited use of a computer? It would be hard for me to even fashion or look at the parameters of what kind of use we're talking about. So
I think it'd be appropriate for myself to perform additional investigation in order to provide the precise parameters, scope, and circumstances under which that we are making the request. And I guess it pains me to say that the people perhaps may have suggested the best course of.
Don't say that. Don't ever say that. They get all out of control.
Yes.
Given too much.
Your Honor, if I may, I do know that there is MDOC probation does provide a guide list for the cataloging of devices that can be reviewed by law enforcement agency. Should that be around?
Correct, but that usually I think is attached to a device. And so if he's on campus, he has access to a myriad of devices, which may be part of a problem. So, all right, well, what I will do at this time is I'll deny your request. And then certainly it can be brought back up, but
Perhaps by stipulated order?
yes, if you can stipulate to it, then that's fine. I don't think I'm gonna have much of a problem with that.
Very good.
All right,
Thank you.
thank you.
Thank you, Your Honor.
Court calls the case, Beagle versus Ashley LaBelle.
Andrew Banish for the people.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Lavelle, for Ms. Lavelle. Ms. Lavelle, could I ask yourself to introduce yourself to the court, please?
I was gonna say Mr., but I'm Ashley Lavelle.
Sorry about that.
All right. You got her. Okay. All right. What are we doing?
Your Honor, could I ask for a brief adjournment? I'm newly appointed and I have not had an opportunity to discuss with the prosecuting attorney yet.
All right. Probable cause conference will be adjourned to August 19th, 2025.
I apologize,
9/8.
Your Honor. That's my only bad date.
Yeah, I got a doctor's appointment that day as well.
Okay. 14th. Will that work?
I just need a morning appointment because right now I'm missing work. So anything in the morning.
Ms. Lavelle, I'll speak to you about as to the
Yeah,
timing.
good.
Sorry.
Your Honor, the 14th should work fine. Thank you.
August 14th, 2025, 9 a.m. Bound continue. Court calls case of the People's State of Michigan versus Stephanie Melissa Minton.
Good afternoon, Your Honor. Jonathan Sachs for Ms. Minton.
And APA Rachel McDuffie for the people on both cases.
Ms. Minton,
And-
can you state your name, please?
Stephanie Minton.
All right. What are we doing?
Your Honor, same situation, newly appointed for Ms. Minton, and I have not had a chance to speak to the prosecuting attorney. If that same date of the 14th works, that would be awesome, but we're asking for a quick, brief adjournment.
I'll be here all day. So probable cause conference will be adjourned to August 14th, 2025, 9 a.m. as your invite indicates. All right, bond continued. Thank you.
Thank you, Your Honor.
Thank you.
Court does call the case of the people versus Richard Arende.
Good afternoon, Your Honor. Rick Henhouse.
Good evening, Your Honor. Megan McDonald, on behalf of Mr. Randy, who is present on Zoom.
And what are we doing?
Your Honor, at this time, we would like to set this matter for preliminary exam, and I would like to address a condition of bond as well.
All discovery is complete.
As far as I know, it's complete from the prosecutor, Your Honor.
When do people have their witnesses available August 12th?
We'll do it.
All right. Preliminary examination in this matter will be set for August 12th, 2025, 9 a.m. in person before Judge Valvo.
You said 9 a.m., Your Honor?
Yes, ma'am.
And then if I could address bond, please.
Yes, you may.
Your Honor, my client, he has a GPS tether on and he is ordered on house arrest right now. He does live in an apartment complex and he would like to expand his area that he's allowed to go because there's a mail room and some other amenities on the property. He says he has a 1,200-foot radius right now outside of his actual unit. And he would just ask this court if we could have permission just to expand that onto the property. The alleged victim in this matter has zero access to that property. They did not live together. They've had no contact up until this point. There should be no threat to her at all if he was to just move about his property a little bit more.
Is it an apartment or condos?
I'll defer to Mr. Miranda in this, but I have seen it from some of the discovery videos. It's a apartment, but it's not contained on a building. He can walk into his apartment from the outside. It's more so a hybrid of a condo complex.
I would agree with that.
Your Honor, that's something this is new information, of course. I think maybe the appropriate thing would be to contact community corrections and our office, and perhaps we could stipulate something. At this stage, I don't have enough information. So.
Yeah, I guess I'm trying to figure out what is it he can't get to that he would need to get to?
I know there is, I believe, and correct me if I'm wrong, Richard, that there's mail and there's some like gym amenities he would like to use. He is put on house arrest, Your Honor, so I'm gonna be forthcoming with that. He would like to be
Pardon?
able to move about his property a little bit more.
Okay, I understand that, but I think he's on that type of tether because that's in lieu of being in jail.
I understand that, Your Honor, but I just wanted to see if that was possible.
If the parties can come up with something, then I don't think I'm going to have a difficulty, but given the nature of the charges, I would have great concern. And quite frankly, like I said, he even has the ability to try to argue this by virtue of the fact that it's an alternative to him being incarcerated.
Okay,
So-
I understand.
All right, so at this time, I'm going to deny the defendant's request.
Would you consider a stipulated order if we do come to a resolution?
Absolutely.
Thank you so much,
And
Your
then
Honor.
you can send it right to Judge Valvo.
Thank
No,
you so
can
much.
send it- you can send it to me. All right.
I understand.
Bond will-
Thank you.
Bond will continue. All right, thank you.
Thank you, Your Honor.
Court does call the case of the people versus Jack Ritchie.
Good afternoon, Your Honor. For the record, Attorney Thomas Donaldson, P number 53660. Here on behalf of Mr. Ritchie. Mr. Ritchie, will you identify yourself, please?
Jack Ritchie.
Your Honor, it's,
Hey, what do we- Go
I
ahead.
believe there's some still outstanding discovery. There was my understanding that the law enforcement was still in the process of doing their forensic imaging on my client's phone, and that they were going to, once they complete that, submit a supplement. I don't know if that has occurred or what the status of that is.
That is correct, Your Honor, and per APA will and bring, they're still attempting to get into the phone, but do not have a passcode and need to get past that. However, we don't know if or when we will be able to be past that passcode.
Gotcha.
So we can adjourn for that purpose. However, we still could come back in 2-3 weeks, a month.
And not know. All right. I'll adjourn it to September 4th. With the forensics coming in 2025 at 9.
Thank you, Your Honor. Your Honor, could
Thank
I
you.
just one issue a bond, please?
Can't stop everybody, so yeah, go ahead.
Thank you, Your Honor. I'm asking the court to allow for limited access so my client can see his cousin who actually has a very aggressive form of cancer that he was just diagnosed with. It's called Burkitt. It's a B-cell lymphoma. He's in stage 4. He's currently going through chemo. He's on a cycle where he's in the hospital and then he's home. I would ask the court to allow him to be able to go visit his cousin while he's still alive and able to take visits relative to this. I would ask that he be allowed to go to the hospital to be able to spend 2 hours on a visit, and also to go to his home, be able to spend 2 hours on a visit, obviously take direct
Is he on a
routes.
home confinement?
He is, yes.
How old is his cousin?
I'm sorry?
How old is his cousin?
26 years old.
26, okay. Any response on that from the
Your Honor, discretion of the court.
Pardon?
I'm leaving it in the discretion of the court, Your Honor.
All right. Counsel, what I'm gonna do is, I'd probably rather do it this way. I'm gonna deny your request and ask that you contact and submit a proposal to the prosecutor's office. I will indicate that this court's leaning, if you guys can't agree, would be to change that provision to allow for some type of visitation. I would just need the parameters, where he's going and when that's going to occur.
I appreciate that opportunity to pursue it that way, Your Honor. I'll make sure to follow up with the prosecutor. Should I follow up with, this is a question for the prosecutor's office. Ms. Willingbring, or is there another prosecutor that?
Ms. Willingbring is on this file.
Yeah, she's much nicer than Kennedy.
Thank you very much, Your Honor.
Yeah, all right, thank you.
Thank you.
Thank you.
Are we free to leave, Your Honor?
Yes, you are. Go ahead. Thank you. Thank you. Court does call the case People versus Nicholas Slutz. Or Schultz. There's an H in there.
Victoria Burton here, Assistant Prosecutor appearing on behalf of the people.
Well, Your Honor, my name is Ed Latursky. I represent the defendant. Could you tell the judge your name, please?
Yes, Nicholas Allen Schultz.
Oh, sorry.
All right. What are we doing?
Judge, we are waiving our right to a preliminary exam. My client and I have signed the waiver form. He understands his rights to have a probable cause hearing. He also understands if there wasn't probable cause, the case would be dismissed. And he voluntarily signed that and understands that he is agreeing to be bound over.
All right. Is all of that correct, sir?
Yes, sir.
And you understand that you will not have that hearing called a preliminary examination, and you'll proceed to circuit court?
Yes, sir.
For their resolution. People also waive their rights? Just for the preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts.
Thank you, Your Honor.
Well,
will we get enough?
As to the information, you received a copy of the information. You waive its reading, sir?
Yes, Your Honor.
All right. Your client stands mute at this time.
Absolutely.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in this matter will be set
September 22nd at 1:30.
September 22nd, 2025, 1:30 before Judge Hamud.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you.
Thank you, Your Honor.
Set pre-trial.
September 22nd.
Let's do. Give me more files. Court calls the case People versus Donathan Sneed.
Good afternoon, Honor.
Stephen Mamet on behalf of the defendant, Your Honor.
All right. Sir, can you state your name, please?
Donovan Sneed.
All right. And what are we doing on this case?
Your Honor, at this time, we're going to ask to set this matter for an exam.
All right. You have discovery is complete to your knowledge, sir?
To my knowledge, yeah.
Okay. People would have their witnesses available on the 12th? All right. Preliminary examination in this matter will be set in person, August 12th, 2025.
August 12th, 2025. I do think I have a deposition that day. Is there another day available?
Sure. August 19th.
That works.
All right, August 19th, 2025, 9 a.m. That is before Judge Moore.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you.
Court calls the case of the People versus Jacqueline Watchell.
Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
Good afternoon, Your Honor. Paul Stablin appearing on behalf and with Ms. Wachel, who is appearing via Zoom. That's with her consent this afternoon, Your Honor.
All right. Ma'am, could you state your name, please?
Hi, I'm Jacqueline Wachel.
All right, thank you. All right, what are we doing on this?
Your Honor, Ms. Burton Harris and I have had some discussions today with some information that I've provided to her. And I think she is agreeing to my request to adjourn this matter for a few weeks, Judge, so that we can discuss the information that I've provided to her today.
That
will have an
correct.
impact on going forward.
All right. All right, and how much time would you guys need to get that done? I trust you that you'll not waste
2 weeks adjournment here.
2 weeks?
Yes.
All right. Probable cause conference will be adjourned to August 14th, 2025, 9 a.m. Bond will continue.
Thank you very
Thank
much,
you,
Your
Your Honor.
Honor.
All right, thank you, sir. Does call the case, People versus Andre Williams.
Andrew Dash for the people.
Yes, John, good to see you again. Brandon Bird on behalf of Andre Williams. Mr. Williams, can you please state your full name for the record?
Andre Williams. All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
All right, the plea form indicates that the defendant will be pleading guilty to the charge of attempted resisting and obstructing a police officer, the 1-year offense. On his successful plea to that charge, then count 1 would be dismissed. One box, I don't see box 5 checked. He understands that.
Yes.
Sentencing judge waiver, you went through that with him, counsel?
Yes, Your Honor.
All right, so I'll check that box and initial. All right, that's the court's full understanding. Is that it?
That is the,
All right. Let's have him sworn.
You solemnly swear to affirm the testimony about the guilty. Nothing but yourself, you got it.
Yes.
State your name.
Andre Williams. Okay, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor for 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced before Judge Washington in the 14B District Court. Do you understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
You signed an advice of rights form?
Yes.
Any question regarding any of those rights?
No, Your Honor.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights for the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On June 14, 2025, at the location of 6451 Meadowlark Lane in Ypsilanti Township, Washtenaw County, State of Michigan, did you come into contact with deputies of the Washtenaw County Sheriff's Office?
Yes, Your Honor.
What happened?
They gave me a lawful command and I attempted to.
Okay, well, what did they tell you to do?
Put my hands behind my back.
And what'd you do in response to that command?
Resisted.
Okay, how'd you resist?
By not putting my hands behind
You
my
didn't
back.
put your hands behind your back. How'd that work out for you? Not well, right? Never mind. All right. There were 2 deputies there at the time. Is that correct?
I believe there were more. but-
There were more. Okay, all right. Sir, you understand that if I accept your plea and you commit misconduct as defined by the Michigan court rules, that between the time of my acceptance of your plea and the time of sentencing, that the court would not be bound by any evaluation of sentence recommendation. You understand that, sir?
Yes, Your Honor.
And that you would not be permitted to withdraw your plea. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
All right, and have I complied with the court ruling? Would it be proper to accept this defendant?
Satisfied, Your Honor.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered. Sentencing in this matter will be September 4th, 10 a.m. Bond will continue.
Thank you. Thank you. And goodbye for real this time.
What'd you say?
I say goodbye for real this time.
Okay, all right. Court calls the case, People versus Stephen Javon.
APA Rachel McDuffie for the people.
I'm Lori Yagi, Assistant Public Defender, standing in on behalf of Mr. Chabon.
All right, he is not, I'm not bringing him back out. It was a rather irritating thing. I'm sure he's aware of what we're doing, and then council can inform him of that. What I'm gonna do are a couple of things. I'm gonna order the forensic evaluation. I'll set a competency hearing for
October 23rd.
October 23rd, 2025, 9 a.m. I am also going to, because of the defendant's behavior, I'm going to change his bond in this case. I'm going to set his bond at a $10,000 cash surety bond in this case. I will, since he is not here at this moment, counsel, you can note that I'm setting that. He'll be held. But if you believe that there would be reasons to review that bond and reinstate his personal recognizance, and you can bring that up by motion. All right. And I'm also doing that because when ordering the forensic, he had indicated that he wasn't going to participate in that. So that's caused the court some concern. All right. Thank you.
Thank you.
What?
Thank you, Mr. Allen. Never mind.
What, are you in charge of property or something, or what? They take care of that. I got people. Court calls the case, People versus Ronald Lucky.
Okay, Richard McDuffie for the people.
Good afternoon, Your Honor. Wonderful to see you. Robert Elman with and on behalf of Mr. Lucky, who's approaching.
You know what,
Mr.
Mr. Elman, you're the only person that when they say that you're happy to see me, I know really means it.
I do, Your Honor,
I know.
every time.
The rest of these people they're trying to fool me.
It's always an absolute pleasure, Your Honor.
Go ahead.
Come on up, Mr. Lucky. And state your name for the record, please.
I'm James Lucky.
Thank you. Your Honor, we're here today on my motion to withdraw. I know we discussed that a little bit at a bench conference at our previous date, so I again renew that same request. I do know that Mr. Lucky was appointed. I know the appointment office here has Mr. Kilowald here ready to be appointed if you were to grant my motion, so I'd ask that you do that.
I will grant your request, Mr. Elman, to withdraw from the case. Mr. Kilowald has now been assigned to represent Mr. Lucky.
Thank you, Your Honor.
It's a pleasure to see you again, Judge.
That I know you don't.
Judge, can we adjourn the PCC, please, to the 19th, possible?
The 19th, you had other.
Yeah, I have a trial on the 11th.
So I will adjourn the probable cause conference in this matter to August 19th.
Okay, can I break that down since I've never got any paperwork and I just found out?
Hold on, we'll get
Just
you.
relax, we'll get it, we'll get it.
August 19th.
Right, 8/19.
2025.
You need a pen that works.
I got it.
Got it?
August 19th,
August 19th.
at what time?
Okay, I'm gonna set it at 9, but you gotta keep in contact with Mr. Kilowald. He'll get the spreadsheet as to what block you're in. Typically it would be later in the afternoon, but I can't guarantee.
Could be the.
Can I just make one brief comment?
No,
on
you
this
don't,
case?
no, you don't need to say anything, no.
The
'Cause
judges
don't know. Ron,
Thank you.
Ron, if I'm gonna represent you, are we cool or not?
Yeah.
Okay, I
All
don't
right,
want to get stuck on the 6 o'clock dock.
all right, thank you.
Thanks, Judge.
Yeah.
Appreciate that. Be quick. She, did you find? I know. It's cool.
Everybody.
No, I don't know if he's cool or not.
Take care of it, Judge.
Yeah. Oh, no, man. She go that way. You like how that went? Court does call the case, the People versus Jody Merritt.
Judge, you have a nice night.
You do the same, sir.
I'm Lori Yagi, Assistant Public Defender with, and on behalf of Ms. Merritt. Ms. Merritt, can you state your name for the court? Jody Merritt.
All right, I have before me a plea form. Are we doing that? And
Yes.
then I also, I think, have a motion.
That's correct, Your Honor.
All right. Well, let's do the plea and then I'll take it on bond. All right, the plea form before me indicates that the defendant will be pleading guilty to an added count 2 of operating while intoxicated, second offense, to 1 year. Upon her successful plea to that charge, count 1 would be dismissed. The defendant is agreeing to participate in the 14B recovery court program as a condition of the plea offer. And the case, there's a sentence agreement to transfer to the 14B recovery court. That's the court's full understanding.
Yes, Your Honor.
That is the full and complete offer.
May I have her sworn?
Raise your right hand. Do you solemnly swear in affirmative testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
State your name.
Jody Merritt.
All right. Ms. Merritt, it's this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration and up to a $1,000 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, I do.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, I do.
One other thing I should mention is you understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, Your Honor.
All right. And so, ma'am, to that charge, how do you plead?
Guilty.
Say?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, I have.
Any question regarding any of those rights? Please look at paragraph 5. There's a copy on the podium. Those are your rights. If you are part of a trial, you understand that by pleading guilty, you'll be giving up those rights as well as all the rights on your form.
Yes, I do.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, Your Honor.
and because you believe that you're indeed guilty of this offense?
Yes, Your Honor.
On March 31st, 2024, at the location of 2029 Bradley Avenue in Ypsilanti Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had pineapple $99 shots for probably 3 or 4 of them
All right,
throughout the day.
throughout the day. Were you stopped by the police or was there an accident?
They came to the car where it was parked. There was no accident.
Okay. Are you disputing the right of the police to stop you and or detain you?
No.
All right. Were you ultimately then arrested?
Yes.
All right. Were you taken to the hospital for a
Yes,
blood
we
draw?
were.
What were the results of that blood draw?
0.171 grams of alcohol.
Okay, 0.171. Do you have any reason to dispute those blood test results?
I have no.
All right. And had you previously been convicted of operating while intoxicated on or about December 1st, 1999 in the 34th District Court and or of operating while impaired on or about January 26, 2000 in the 29th District Court?
Yes.
All right. Ma'am, I do have to advise you that if I accept your plea, that from the time that I accept your plea to the date of sentencing, if you commit misconduct as defined under the Michigan court rule during that period in time, that first of all, you would not be permitted to withdraw your plea. And secondly, the sentencing court would also not be bound by any evaluation or recommendation regarding a sentence. You understand that?
Sure.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, I'm not.
No, Your Honor.
Have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, the people are satisfied.
Yes, Your Honor.
All right, court will accept the defendant's plea of guilty to this charge count two. Count one is dismissed. Pre-sentence investigation report is ordered at 14B probation. Sentencing in this matter.
September 4th at 10 a.m.
September 4th, 2025, 10 a.m. before Judge Washington. Bond will, okay, and as the bond, go ahead.
I did. Yeah, thank you. Your Honor, I would ask that this court remove the scram tether and potentially even allow her to test multiple times a day on the SoberLink. She's been on the scram tether since March. Obviously, this offense here was from this past March, but a year prior. I know Ms. Merritt did have a violation that was back in April, but even
while she was on the SoberLink.
No, she was on the scram
tether. She was on the scram.
Yeah, so she was put on the scram right at arraignment and then had the violation, did jail time, and then completed inpatient residential treatment in Oakdale and has been following up doing meetings. How many times a week are you going? Like four or five times a week. She is on step 9 in her recovery journey. She has a lot of health issues, and I won't belabor the points I wrote in the motion, but she has a lot of health issues that have been a real wake-up call. She has swelling in her lower extremities that is really worsened by the scram tether. And I think she is, I think, internally, for her health reasons and for her own reasons, made the decision to be sober, not drink, and regardless of whether or not she's on the scram tether. But I think now, especially, she's pled guilty. She is going to do jail time if she has any violation if the court were to remove her tether and put her on a SoberLink. She knows she's going to go to jail because she's already pled guilty now. So I think there is that extra enhanced level of accountability for her. So I would ask at this time for the court to remove this scram tether.
Response from B.
Your Honor, after I received Ms. Jackie's motion, I reviewed the entire file and her motion. And we'll leave it in your discretion. The only thing I ask is if you do remove the tether, I ask that she be transferred to a sober.
Are you going to be able to timely blow?
Yes.
Okay, because you have to understand that a failure to blow on time on the SoberLink is a violation.
That's right.
You understand that?
Will it go off every day at the same time?
Well, no, there's a time schedule. I have you blow 3 times per day.
Okay,
Okay, and so you have to blow within certain windows 3 times per day.
okay, sure.
You think you can do that?
I think so, yes.
All right. Modification request. I'll take her off the scram tether.
Thank you, Your Honor. Thank you, Your Honor.
Scram tether. Maybe she will be switched over to a SoberLink tether for testing. She'll have to blow into the machine, into the SoberLink, excuse me, 3 times a day. I've signed that order.
Thank you, Your Honor.
Thank you.
Thanks, Your Honor. Thank you, Your Honor.
Thank you. Right. Well, my only question is that should I pick the other one? Oh, I got you. Okay, they're different. Got it. Okay. Okay, court does call the case of People versus Isaiah Bozeman.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Bozeman. Mr. Bozeman, could you please state your name for the court?
Isaiah Bozeman.
All right, this is your motion.
This is my motion, Your Honor. A couple of points. In the prosecutor's response, it does allege that Mr. Bozeman was the shooter in the situation. I actually read the police report to say, and I understand this could be a distinction without a difference, that he's really alleged on sort of an aider and abettor theory as the driver of the car. But I did want to point that out, that I don't believe he's actually alleged to have shot the gun in this situation, Your Honor. This is a situation where we, of course, don't, expect the court to drop the bond to a PR bond. He understands that the charges are serious and that's not a realistic situation. Positively speaking, he does have a lot of people that are behind him with their heads screwed on straight. He has a lot of family here that I've all spoken with several times that are really counseling him in the right way and looking out for him and guarantee that they would be responsible for him if he were to have a chance at being released and going home and making sure that he stays home, Your Honor. So again, we understand that the court would not likely drop this down all the way. We understand that, but we would appreciate any of the court's consideration in reducing the bond, Your Honor.
And you understand the people's request to raise the
bond? I didn't read the request to raise the bond, Your Honor. I am hoping that that's not the case, but since we're standing at $1 million as it is, it's effectively a no bond.
Is it set at $1 million?
Yeah.
Thinking about them looking at the
So it's quite high as it is, and realistically, he'd never be able to post it as it is now. So $1 million or 500 million.
Respond.
Mr. Coconut, office filed a response. I read it just to deny the motion.
Okay. I may have been looking at it, but go ahead.
Now, we discussed the facts. It does involve effectively random shooting of a rifle into occupied buildings in our community. This is a 21-year-old individual, and while I appreciate he has support and people that are there to support him, as stated, they were probably still around a month ago when this was happening. And so our concerns for the safety of the community remain in place, and I'd ask that the motion tonight.
Anything else?
No, Your Honor, I think the court's aware of the situation.
Well, the factors that the court has to take into consideration looking at this, I mean, there's one issue as to whether or not the original bond that was set was an abuse of discretion. This court doesn't find that it's an abuse of discretion, but then in looking at the numerous factors, or the factors, the primary of which are the safety of the community, as well as the defendant's risk of flight. I don't particularly view the defendant as a risk of flight in this case, having read all of the support that he has around him. I think the problem will be, I do view him though as a significant risk to the community. That is really my big issue. When you start firing a weapon off into an occupied dwelling, or even participating in that type of an event, you're right, Mr. Bernstein, that's a distinction without a difference as to whether or not one's the driver and the other. But if you're aiding and abetting in that type of behavior, you are a significant risk to the community. There could have been a number of people that would have lost their lives by this behavior, which would have just been, quite frankly, at least as I understand, some of the background on this would have just been absolutely senseless. It makes no sense. So since I do consider the defendant to be a danger to the community, despite the overwhelming support that he has, I think it's a good point what the prosecutor indicates, that support was there before. And quite frankly, I realize these are allegations, but before he got himself involved in something like this, he should have reached out to the support that he has around him. There's no reason for him to be standing before today with the folks that are around him and could support him if they needed to. So for those reasons, the court is going to deny at this time the defendant's motion for bond reduction. Bond will continue.
Appreciate the consideration, Your Honor.
We have another probable cause conference.
Oh, yes, PCC, yes.
Yes.
The co-defendant's case was this morning, Your Honor. Did that get adjourned to a date? Can we track with that? Fred Willis?
Did I think it was the 14th. 14th.
Yeah, will that work for you?
Yes, Your Honor. Thank you.
All right, I'll adjourn the probable cause conference in this case to August 14th, 2025, 9 a.m. or as your invite indicates. Bond will continue. Thank you. That's called the case of the people versus Jalen Priester.
Yeah, I was gonna, Ken Medalish on behalf of Mr. Priester. Can you say your name for the record, please?
Jalen Priester.
Your Honor, today people are moving to raise defendant's bond $5,000 after the details of that provision, and in the event of defendant's release, require a home confinement tether. We make this request on the basis that defendant is a dangerous individual who poses a threat to the community's physical safety. He fired a 9mm pistol at least 5 times into an occupied apartment building, striking apartments aimlessly. MCR 6.106H allows a court to modify bond if they find that there is an abuse of discretion. The current bond of $35,000 represents the abuse of discretion because it falls outside the probable and reasonable range of outcomes under the factors laid out in MCR 6.106F and MCL 756.6. I laid out the 9 factors under MCR 6.106F in my brief and leave those to the court's consideration. All of my argument is focused on MCL 756.6. This includes 4 factors. The first of which is the improbability of defendant appearing at future court dates. We don't have much to say on this factor. We would simply note that defendant was arrested for assault and battery in 2018 and attempted to flee uniformed officers at that time. Moving to the second factor, the seriousness of defendant's charges. They are very serious. There's a maximum penalty of 10 years in prison. The people have calculated sentencing guidelines between 5 to 23 months. The statute that defendant violated is designed to protect people in their own homes and in common gathering spaces. Places we shall be free and safe to be. The third factor is the protection of the public. He would have grave concerns with protection of the public if bond remained as is. Defendant has a reputation for being in a gang. He sent death threats to a victim via text. He tried to run that same victim off the road with his vehicle. And one of the neighbors who was a victim of his shooting conduct was awoken from her bed by a bullet passing through her window, past her head, and then ultimately embedding in her mirror. Defendant's conduct has escalated from targeting one individual to threatening an entire apartment building of people in Washtenaw County. You would have serious concerns if bond remained as is. Finally, defendant has an extensive criminal record and a reputation for being dangerous. His Clemis history shows at least 33 interactions with law enforcement over the years, leading to which he resulted in arrest. He's included using a telephone for harassment, larceny, and CSC worth. He has demonstrated a severe lack of concern for human life and a willingness to fire a deadly weapon, even when there is a deadly risk to bystanders. Defendant is a dangerous individual, and the factors under MCL 756.6 support raising to bond. He fired a weapon at least 5 times into that apartment building at 3 p.m. on Memorial Day, a date and time when people were particularly sensitive to the vehicle. He threatened their safety inside their own homes, a place that they should be particularly safe and free from defendants' aimless bullets and violent tendencies. Instead, their holiday was interrupted by bullets piercing their apartments. One woman again was woken from a nap on her holiday by a bullet passing through her window, past her head, before embedding in her bathroom mirror. Therefore, the people request that the court raise defendant's bond to $75,000 cash surety with no 10% provision and a home confinement tether upon release. Thank you, Your Honor, and that's all.
Thank you. response.
Your Honor, we oppose the motion for bond being increased. We don't believe that there was any abuse of discretion at arraignment stage. And we ask that the bond be continued at what is currently set at. All of that, what just was mentioned, most of it, except his criminal history, is just allegations. This is what this case is for, is to go into the allegations. And when the magistrate set the bond, he had all the information that we have now. I don't believe anything that was just mentioned is new information to us, or to either side. I don't believe there have been any violations, no calls coming out of the jail to any of the complaining witnesses. We believe that the bond that is currently set at is serving its purpose. He hasn't posted bond. He hasn't been able to, so we don't see a reason in increasing the bond, because as it is set out, it is currently serving the purpose of the bond. There is no indication that he can post what it's currently at. So we don't believe that there was a abuse of discretion in setting it at $35,000. Additionally, I do believe the bond request form at the time of arraignment had the requested bond of $50,000. I'm actually unsure what the amount that was actually requested on the record was, but the bond form did have $50,000. I don't know why it would be increased to $75,000 now when there's no new information. Of course, the police report has, its own allegations, such as the threats, but the police report does not actually include any photographs or proofs of these text messages. But aside from that, Your Honor, we believe that there was no abuse of discretion, and that we oppose that motion. Thank you.
Your Honor, I believe that the low value of $35,000 simply doesn't match the egregiousness of conduct. $75K is far more appropriate. The police also gathered ballistics and multiple victim eyewitness reports at the scene. I believe that we've laid out a strong argument here for if you raise $75K, that would be the court's discretion.
Did the people originally request 50,000?
I believe so, sir, but we wanted to make sure the bond reflects the egregiousness of this conduct. And
What, and so in the bond motion, that did not reflect it, or what?
I can't speak for the prosecutor, but I believe it's.
Well, you need to speak for that because it's your same office. So I'm saying you have a 50,000, don't you believe the defendant's point is a good point, that originally you asked for 50,000, that there's nothing that has changed between that point in time and now that would justify a $75,000 bond?
I understand your point, Your Honor, and I think defense brings up a valid point. Do you believe that 50K is appropriate?
Do you believe that it was an abuse of discretion for the magistrate to set the bond at the $35,000? I will, however, grant the people's motion to raise the bond. Defendant's bond will be modified to $50,000. Cash surety note 10% with a tether if he does post the bond. And that would be a home confinement tether. With 50,000.
Not.
That's cash.
Your Honor, oh, sorry. I was going to actually address the case. But
No, go ahead.
we're just gonna set it.
I can
So
do
look at
more than one thing at a
I don't
time.
want to make you to have to do that at 6:30.
Why? I multitask all the time. But-
All right, we'll be setting for.
Okay, you have my full attention. Boy, go ahead.
Your Honor, we're gonna be requesting to set this for preliminary examination, please.
All right. You're gonna be setting it for a preliminary examination. All discovery is complete.
Yes, Your Honor, I believe so.
All right. The people have their witnesses available. The 12th.
We'll do our best, Your Honor.
All right. He has a co-defendant. Has that been set as of yet?
Actually, the police report is quite scarce. I don't even know the defendant's name.
Is there a co-defendant with this?
I don't believe so.
I thought there was.
That's precinct, Your Honor, from this morning.
Yes. And when is that? Did we
I can
set
look
that
real
one?
quick.
But I'm saying this is a different precinct. That seventh precinct was the one that had a code amendment on it.
Not here.
Oh, okay. I was gonna say,
Okay, gotcha. Okay. So I will set, would you be ready to go on the 12th?
yes, Your Honor.
All right, I will set preliminary examination, August 12th, 2025, 9 a.m. in person before Judge Freshour. Bond will be set as I've indicated. Pardon? Yes, you may.
Regarding this case? Oh, okay, thank you.
Yeah, we want to talk without you.
I was like, I need to approach to that.
But you're not gonna get it.
Got him on his way. Oh, he's in Zoom. Court does call the case of the people of the state of Michigan versus Philip Carrick.
And is that on behalf of the people, Your Honor?
Good evening, Your Honor. Sam Bernstein with and on behalf of Mr. Carrick, appears by Zoom.
And this is a people's motion to modify bond. So you may go ahead.
Your Honor, at this time, we'd be requesting our original request of $500,000 cash surety, as well as if he is to post or be released for a home confinement tether. Your Honor, I'm not sure if the court, enough time, I know we submitted this late last night to the court, this motion, so I'll kind of go through it a little bit. Your Honor, in the instant case here, to start out, the entirety of the events of this case from March to July occurred while the defendant was either on bond for a strangulation or after he had pled to a DV second in Judge Kunke's court. In this case, the victim has laid out a series of assaults starting in March through July that include the defendant assaulting her in a numerous variety of ways, including kicking her, throwing her down, punching her, biting her, and choking her. And in some of these events, some of these specific events that stick out to the people, Your Honor, include an event where the defendant is alleged to have strangled the victim and taken her keys and her phone and had been sleeping by the door to hear when the victim tried to leave the apartment. She did attempt to leave the apartment. He then chased her down out in the parking lot, bear hugged her, and then told her that if she were to make a scene, he would, I'm sorry, Your Honor, give me the correct quote that she was stating, that if you make a scene or you scream out, I'm going to effing kill you, and then told her to get back into the apartment. Your Honor, after that, I also have concerns that at one point she was strangled to the point of unconsciousness, which in our eyes is mere seconds away from death, and she did have to go to the hospital and get treatment. Your Honor, along with this report, there are numerous images of injuries that she sustained, including bruising to her arms, bite marks, bruising on her neck, as well as a extremely large, I would say, I guess, bump on her forehead from these assaults from this defendant. He has threatened her numerous times throughout this case. In one of the points where he was strangling her, he told her she wasn't going to see her children tomorrow. She's had a black eye from this defendant. I also have concerns in this case that it occurred while he was on bond. He has a previous history of domestic violence, and in one of those cases back from 2023, he had picked up a case of domestic violence with a victim. While on bond for that case, he saw her at a bar and assaulted her again for that case. And in that specific case, the assault that he did left bruises on this victim. He had put his hand around her neck and a pillow over her face during the course of the assault. And she was so afraid and traumatized from this assault that she had fled the apartment the following day and then fled the state. And then continuing on in his criminal history, he just pled in a case for a DV second, which includes pretty similar behavior of strangulation and domestic violence. He's continuing this pattern of aggression and abuse towards women, and it seems to be escalating in this case, which has led to these charges of unlawful imprisonment, GBH strangulation, as well as domestic violence in numerous instances. I have great concerns. I also have concerns that in this police report, she also alleges other violations of bond of him being at bars drinking, which was against his conditions of bond, and that also matches what the victim impact statement was in Judge Kunke's court, that she saw him at this specific bar that the other victim mentions he was at that time. I mean, I have great concerns that he cannot follow court orders. He is a danger to the women around him and a danger to the community. I mean, he continues to not follow court orders, assault women. And I have extreme concerns for the community safety as well as just women in the community in general, given his behavior. He cannot follow court orders and continues this pattern of aggression and abuse against numerous women. He now has 3 different victims of domestic violence against him. It is a pattern of behavior that's extremely concerning to the people. And I believe our request of $500,000 cash surety as well as home confinement is helping to protect the women of our community from his abuse and aggressiveness towards them. I'm sorry.
Yes. Was it yesterday this defendant was sentenced?
He was sentenced, Your Honor, on Tuesday.
On Tuesday.
To domestic violence second offense. This report came in on, I believe it was made on Monday. We did not receive it till that morning / afternoon on Tuesday.
So, and that's what I just have one question. So Judge Conkey, when she sentenced him to I think it was 1 year probation or something like that, was not aware of.
She was surprised, Your Honor, of what was in the process of going on. And at that point, we had tried to get this complaint sworn to and have officers present to initiate this case. However, we wanted the other case to proceed as it was up for sentencing that day. So Judge Conkey was apprised of what was in the process of happening at sentencing.
Got it. Okay.
And I also wanted to note for the court as well that the context of these events at their beginning starts after the defendant's tether had been removed in the previous case after exam. That's when the beginning of these events start up until July of this year before he was sentenced.
What do you mean his tether was?
He was on a tether in the previous case, Your Honor, at the start of that DV case. And after exam, there was a motion for the tether to be removed and the tether was removed. I believe it's a hot zone tether in that case.
And then the behavior begins.
Correct.
Your allegation. All right. All right. Ms. Bernstein, respond.
One thing I want to point out, Your Honor, is that in the emergency motion, it states that the magistrate gave Mr. Carrick a $50,000 cash or surety bond. That's not actually what the bond is that the magistrate gave. He gave a $500,000 bond with a 10% privilege. And there is actually a significant difference between the two in terms of the amount of money that is required for him to get out. So at this point in time, he posted the bond, which required paying a bail bondsman $12,500, which he can't get back. And so the bond that's posted for him right now is $125,000. So it's not an insignificant amount by any means, and it's much, much more than what would just be a $50,000 cash bond.
So what you're saying is the bond that's set by he's posted?
It's posted, Your Honor. I think he's being held pending this emergency motion.
Yes. Okay.
What I think, but I mean, my point there is that it's actually much higher than is stated in the motion. I know it sounds similar, but mechanically, it actually is much more difficult to post that as 10% of $500,000 rather than a $50,000 cash surety bond. So it's not small. At the arraignment yesterday, Magistrate Odetella did say that he had participated in the swear-to. He had heard everything that has been said now. He had also reviewed the bond recommendation form as well. So there hasn't been anything stated that's different than what was given to Magistrate Odetella yesterday. And nothing has changed since then as well, Your Honor. Submit to the court that the bond in place is actually quite high. And it's not an abuse of discretion to give that type of bond in that amount. It's not a low amount by any means. It's different than $50,000 cash or surety. It is a significant bond, Your Honor, and I don't think Magistrate Odetella abused his discretion in setting that bond.
But he was on bond at the time of the occurrence of this offense.
That's the fact pattern, Your Honor.
Yeah. Okay.
And Your Honor, there is one more thing I wanted to add as well. I know it came up in arraignment. How about the timing of the report? But I did want to say in the report that the daughters and her children, and that she cared about the defendant as a person, but was terrified of him and what he's done, and did not want her daughters to have to go through that as well. And that's why she came forward. It wasn't with malicious intent.
Anything else, Mr. Rich?
What I would ask the court to take into consideration if the court is considering raising the bond at this juncture is that he has committed significant reliance on the bond as it was given yesterday. And so we'd ask the court to please take that into account when considering a bond at this point in time.
The concern that I have is that he's on bond for a domestic and this occurs. I'm also concerned that the defendant seemingly gets off a tether and then the behavior begins to escalate, which is, I think, in a certain respect, for this court problematic, and I think should have been taken to the extent the magistrate knew, should have been taken into further account. I also am not sure because frankly, I don't believe that given the fact that the defendant was on bond, which may entitle him, quite frankly, to no bond because he was on bond at the time of this offense. The magistrate chose to give him a bond, but I believe the granting of the 10% privilege is certainly problematic with all of those other circumstances before, meaning that if he's on bond, certainly I think it's an abuse of discretion to give them the 10% privilege on the bond. So the court will grant the people's motion. Yes, I will grant the people's motion. The defendant's bond in this case will be modified, not in terms of its cash component of the 500,000. I will leave that in place, but it will be cash or surety, no 10%. So I'm removing the 10%, but all of the other conditions that the magistrate set in place, the court does find appropriate, and those would remain in place.
So it will continue to be a GPS tether and not home confinement?
If he posts, I would change that to a home confinement. All right, got it.
Thank you.
Could it be released for work, Your Honor?
Pardon?
Could he travel to work? No,
If he posts, I'm gonna do it. If he posts, then there would be a home confinement tether. I will certainly take a look at what the work schedule is. I doubt that there would be agreement between the parties as to what that work is. But if he has a regular work schedule or however that is set up, the court will take a look at that and would make an accommodation so that he could work if that's a possibility.
Thank you.
Thank you. It has a PCC day? Okay. Then it will just continue to the PCC day. What's the PCC day? All right. This will continue to the probable cause conference on 8/7. All right, thank you. Tina.